All right, good afternoon and welcome. We're on the record FC 2023
Oh gosh, I forgot the date.
052771 in the
Where's the
matter
date?
of Lauren Owens versus Clayton Ray
He calls
Echard.
her Lauren.
Miss Owens, are you present on the line?
I guess I am.
Ma'am, can I have you state your name for the record, please?
Yeah,
Oh,
it's
so many times.
Laura Owens.
Thank you. And if you'll raise your right hand, I'm gonna let me know when it's up. I'm gonna have you sworn in.
It's up.
You do solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, thank you, Miss Owens. This is a hearing on your petition for order of protection. I'm going to ask you some questions about your petition. Before I do, are the statements alleged in this petition true and accurate to the best of your knowledge?
So this is the ex parte hearing. Clayton is not involved in this. She is presenting this information to the judge. He is responding to the form we just read, asking her additional questions to go on from there.
Yes.
And the nature of your relationship with the defendant, Clayton Echard, is what?
So I'm pregnant by Clayton, and so we also had a romantic relationship.
Okay, do you currently reside together?
No, we do not.
And are there currently any orders in place, protective orders in place involving either one of you?
I have a protective order against somebody, but there's nothing between us.
Okay. Now, earlier, well, let's see, it's been a couple weeks. A couple weeks ago, you had filed a petition against Mr. Echard involving some of the same circumstances that you've alleged in this petition, and the court at that time denied your petition. You know what allegations I'm referring to?
I do, yes, and there have been more, and there was even another one just since I filed it this morning.
All right, and I appreciate that. I saw that in your latest petition. The point I want to make is that because the court has already ruled on those other incidents, and specifically the one with the date associated with June 10th, and the other with the date associated with September 21st, we're not going to talk about those issues today. But I do see that your latest petition does have events that are alleged to have occurred with the dates and I'm going to quote your language, between 9/22 and 10/5. And then you have another event that has a date associated with it of 10/6/2023, where you were referred to since September 28th. So let's talk about those events in that time frame. What is it that Mr. Echard has done, and when did he do it?
Yeah, absolutely.
So I don't know if you caught that. She filed a motion to have this TRO put against him for the things he's posting online. The court denied it. So she filed another motion and said, oh, but he's doing additional things too, in addition to that. And so the judge is not considering anything that had already been decided and is only going to hear new things since the motion.
So I just want to make sure. Can we talk? I'm sorry. He had just done something, and I'm really upset. So you wanted to talk about like when he posted to his followers about to look up my court cases against the man I have the protective order against.
Yeah, and I can facilitate our communication. Let me do this. Did any of the posts refer to you by name?
They did not, but he said because I asked to remain anonymous in this whole thing, but he said to look up the post by his name, and because of that, I've been named by like everybody online.
Okay, but did Mr. Eckert post anything that referred to you by name?
No, he did not.
Did Mr. Eckert post your case number in any of his posts?
He said to look up the case number.
All right, and
you know what?
And so he provided his name, right?
Yes, and he told people where to search on the Maricopa County website.
All right, and then what are the statements that were in the post that referred to you specifically?
So he said that I had done this. By this, he meant gotten pregnant by two other men before, which is true. And after he did that, he has posted many times just facts about the cases. In one of the cases,
So far, he has posted that there was a case, which is public record, and he's posted the facts about the case, which is also public record and true. Continue.
I have a civil case, and they're both against the same man. I have a civil case that I had given discovery materials to the man in the civil case, and Clayton was able to get a hold of those and leak those documents online, which those did have my name on them.
Okay.
And then Clayton,
Do you have
and
proof?
then Clayton has now posted that the results of the paternity test came back, which they did not, and he said that he's the father. He's not the father, and again, they did not come back.
Well, they did come back. You just had to get a redo because you can't test when there's no babies. No more fake babies. So, Clayton went online as soon as he got the results. And this is what...
Listen, it's Friday, and you know what we need on a Friday? We need some good news.
But
And
you
who's
can't
got
hear
the
it,
good
can you?
news today? I got the
Hold on. I forgot. Share screen.
baby. I knew that was going to happen. You know what we need on a Friday? We need some good news. And who's got the good news today? I got the good news. What's that good news, Clayton? Well, test results came back early, and they said little to no fetal DNA present. Let's go, baby. I knew that was going to happen. Thankfully, 5 months of torture can finally be put to rest.
He's posted that.
So go away, son. I kind of wonder what would have happened if she would have called him and said, I'm pregnant. And he would have said, well, it's not mine. I can't have kids or something along those lines. She probably felt him out first, like to make sure. Because some people can't. And there's no way to know. It's not like they wear a name tag. Hey, I'm fertile. I'm not.
That I'm just getting harassed like crazy. I just have to go and submit a retest. He's really gotten people.
So let me ask you, and here's the line of concern that I'm in what's directing my question. So folks that communicate things publicly have a constitutional right to that includes a freedom of expression, and so long as their communication is not illegal speech. In other words, it's not illegal speech can include a number of things, but if the comments are true, or rather, if the comments are not untrue and they're not illegal speech, then they are generally protected free speech. So what is it about these posts that you claim are not protected free speech?
So in the first one, when he said the initial cases, I guess I should have explained that a little more. He tried to make it seem like I had faked being pregnant. That was his insinuation, that I had quote.
All right. So how did he insinuate that? So and this is let me distinguish.
Clayton was on from the start. He knew what was going on.
What you're saying. So you can't draw the conclusion. All right. So tell me, what is he saying without you drawing a conclusion? Because some people may not draw the same conclusion as you. Use his words and tell me what it is that he said that you think is unprotected free speech, or not that's not free speech.
Just that he said he said that on his page, and then on Reddit he went online and he named me and he accused me of faking pregnancies in the past, and he has cussed me out on there. He's harassed me. He himself had said that I really should kill myself on Reddit. And
again, did he refer to you by name when he made that statement?
On Reddit, yes, he did. He referred to me by Laura Owens. Every time he posts on Reddit, he posts my full name.
Okay. And then when you
I've never seen that anywhere. And if that is true, that is crossing the line. But I feel like somebody would have a screenshot of that somewhere. If you do, please show me. I would like to see it.
use the word harass, what is it that you mean?
Well, I mean, like when he said that I should kill myself, and when he said that he said online that I have lied about being pregnant when I have not, and he has absolutely no proof that I did, and I've provided all this medical evidence to prove that I was pregnant. And despite that, he's just trying to incite people against me who have just been horrendous to me online, including him, who has multiple false accounts, fake accounts that leak information that only he would have about me. And like I said, every Reddit post just has my full name. He lists my full name everywhere.
Okay. Other than through legal counsel and court proceedings, should there be any path of communication that's left open between you and Mr. Echard?
Absolutely. I still need to talk him into dating me.
The paternity case. No, I guess there's nothing else that needs to be left open.
All right. And the North 69th Street address in Scottsdale is your home address?
Yes, it is. Yeah.
And then do you know whether Mr. Echard uses or has access to firearms?
I do not know. I don't believe he does.
All right. And then I know that you have language here that says, and I'm looking at your proposed form of order. It
How
says
about
no
has he
cyber harassment or cyber
come to your
bullying
house?
under real name or pseudonyms. I'm fairly certain I understand what you're asking, but can you explain what you're asking the court to order if I were to grant your petition in terms of cyber harassment or cyber bullying?
Yeah, I guess him not posting on Reddit trying to incite people against me, or he just did this this Instagram post where he's trying to incite people against me by saying that that these test results are back when they're not, and he's name calling on Reddit. And he sent my attorney a message from an email address saying Laura Owens liar at gmail.com. And so I guess not that, like just I'm
going to put money that was one of us and not one of him. Really. I don't think he's going to create a Gmail that says Laura Owens liar. However, if you go look at some Twitter handles, you'll probably find that.
I just want him to kind of just stop all of this. I want him to just, be a truth teller and stop harassing me, I guess. I'm not explaining it well.
Okay.
There's nothing to explain. He has not crossed the line into harassment. We have talked about this.
I'm going to type some things into your order. Let me tell you, Ms. Owens, I'm going to grant your petition. I'm going to issue an order of protection that includes you as a protected person and include your home as a protected address, leaving open only the path of communication that Mr. Echard is not to have contact with you except through legal counsel and court proceedings. And then I'm gonna work on some language here for a moment that addresses the issue about what's going on online. And then I'm going to read that to you and see if there's anything that you wish to have change. So give me a moment while I do that, and then I'll read to you what I have, okay?
Oh, okay. I mean, he can, I don't mind if he emails because we don't have counsel in the paternity case. Neither one of us does.
I just want him to stop making me look bad.
Basically, I just want him to not, be that character assassination or anything like that.
Okay, but in this day and age, people have different opinions about what's character assassination, and that's what
Yeah.
I understand what you're saying, and I believe that
Yeah.
you have a particular idea about what you're saying, but to use that term, um, or cyberbullying or cyber harassment, those are amorphous terms that don't have strict boundaries. So I'm gonna work to communicate that. But you want to leave open a path where he can email you regarding the paternity case?
Yeah, just because we don't have counsel.
Okay.
So he's going to make that round peg fit in that square hole. And the reason why, I guarantee you, the reason why in his head, and I'm just guessing here, is the one comment that she said he made on Reddit. That's one comment is all it takes. Because there's literally nothing else anywhere. There's nothing. Yeah, it's really weird. Like, she filed this, it was denied, and then she comes back and now she's getting it. And then they have to come back again so he can defend himself. Like, I really don't quite understand. Thank you. Do you know what's funny? Look how, like, cool, where is my camera? It looks like almost ombre. It's just the color wash because I haven't done anything with it. It's too funny. I did look up what, let me see if I can get this share screen file, what the Arizona law is that I couldn't
have
find the other
included
day.
language in your order that says defendant shall have no contact with plaintiff other than as outlined herein, and shall not cause others to contact plaintiff other than as outlined herein. And I'll read that to you in just a moment. I have also included language
Exactly.
that says defendant shall not communicate or post untrue or harassing comments regarding plaintiff online, including but not limited to social media, and shall not cause others to communicate or post untrue or harassing comments regarding plaintiff online or otherwise. So I've tried to leave that vague, and I've tried to leave it such that it doesn't interfere with individuals' constitutional rights. With that and with that understanding, is there anything you would have changed about what I just read to you?
I think that's absolutely perfect.
Okay. And then
Of course she does, because she's getting what she wants. Wait, just okay. So in Arizona, for a emergency order of protection, which is where you start usually, or a regular order of protection, you can apply if the defendant is your spouse or former spouse, you live together, you're related, you were previously or are now involved in some form of relationship, whether it's love or not, or they're your in-laws. That's it. Like, you have to have one of those relationships. You either live together, dated, or are related by blood. And in addition to being related, the defendant has to commit, he either endangers, threatens, or intimidates assaults, including dangerous weapon, causing serious bodily harm, kidnaps, interferes with custody, criminally trespasses, abuses, interferes with judicial proceedings, blah, blah, blah. Or harasses. 2 words. Harasses, threatens. The meanings of those words are up to the judge's discretion, which is where the only reason that she's getting this is because he is writing it this way to make it fall in line with harassment and threatening, intimidating behavior. Because otherwise, she's in fear, okay, but he did nothing to cause her to be in fear.
the outlined is herein. I'm going to read that to you in just a moment. Let me just make sure I didn't miss a word or anything here.
I have an issue with classifying one night drunk hookup as a relationship. Like,
Okay, and then there's a section of the order of protection that says defendant shall not contact plaintiff except as checked, and I've checked the box other, and then it says through legal counsel in court proceedings and through electronic mail only regarding only matters pertaining to the paternity matter. Anything
That's
to change
perfect.
about that?
No,
gummy
that's
bears for the
perfect.
win.
That's perfect.
All right, so this order of protection, Ms. Owens, will not become effective until it's served. It'll be sent to the sheriff's office today for service. But after this hearing, I'm going to have my office send you a copy of the order in case you need to involve law enforcement sooner than it may take the sheriff's office to serve your order of protection. Understand that while we'll send your order of protection to the sheriff's office today, it may not be served today. It may take a day or so. But if you need to use that copy before then, look for the email after the hearing and you'll have the copy available to you to use. Okay?
Okay, perfect. Thank you so much. Thank you
You're,
so much.
you're welcome. Just a little
It
more
was because it was
information. The
twice.
order of protection becomes
The second
effective
time sealed it.
when it's served, not before then. And then once it's served, it will remain in effect for a period of 2 years, unless before then it is dismissed or modified. You could request to dismiss it or modify it, or Mr. Echard could request a hearing contesting it. If he requests a hearing contesting the order of protection, you will have the burden of proof at the hearing to show why the order ought to remain in place as issued. Okay.
Okay.
Anything else for today?
No, thank you so much.
You're very welcome. We're adjourned for today.
We do have a number of exhibits, and so if you would like to use an exhibit or admit an exhibit, then you do need to lay some, what I'm going to call foundation for that exhibit, which means you need to tell the court what the exhibit is, if there's a specific date and time that relates to that exhibit, how you have knowledge of the exhibit, and how it's relevant to what we're doing. And then you need to actually move to admit the exhibits. If you want to present an exhibit, you have to, once you've laid that foundation, you have to actually move to the court to ask to admit the exhibit. Just because you submitted them doesn't mean they come into evidence unless you move to admit those, okay? And then you'll have the opportunity, so Echard, you're going to go first because you're the plaintiff. You'll present your case and your testimony, and then the other side counsel will have the opportunity to question you, and then they can call witnesses and you'll have an opportunity to question them. And then at the end, everyone will have an opportunity to make a closing argument, okay? The things that people can testify about, you do need to make sure that they are related to something that you have personal knowledge of. So you can't just say, I saw something on the internet and so now I can testify about it. Okay, it does need to be something that you have some personal knowledge about. And I know that this case also has a family court matter. This is not the family court case. This is not the trial on the family court issues. So I need everyone to focus on the issues that we have for this hearing. So we're not deciding pregnancy issues, we're not deciding paternity issues. Those are not the issues that are going to be decided today. So what this court is looking for is a determination as to whether or not there were a series of events that were aimed at a particular person that would cause a reasonable person to be annoyed, alarmed, or harassed, that person was in fact alarmed, annoyed, or harassed, and that those actions had no legitimate purpose. Those are the findings that the court is looking to make. So, record for you, you're trying to show by preponderance of the evidence that that was the case. And then, obviously, Ms. Owens is going to be trying to show that there is not a basis for the injunction. So the things that are outlined in the petition are the things that can be discussed or addressed. Okay, but as I said, we're not discussing whether or not officially that there's a pregnancy or whether or not officially there is a paternity issue. Okay, so we need to make sure that we are keeping on track with what we want to show in our case. And so the series of events does need to be more than one, but it can be over any period of time. So those are the things that we're looking for. Does anyone have any questions about what I've just gone over?
Your Honor, I have a couple questions.
Okay.
Did you want to hear opening statements?
I mean, I would allow people to do an opening if you wanted to, or you can waive openings either way.
Okay. And my other question is that what I believe that Mr. Echard is going to present are emails regarding alleged harassment in this matter. But the emails, and I know you had indicated that, and I understand this is not the family law, the family court case, but the emails and the alleged harassment have a lot to do with paternity and things of that matter. So I think that those things are going to come out despite this not being us trying to prove paternity and things like that. I think the content of the emails has to do with that, and so those things will come out.
And I understand as they relate to the specific basis for the communication,
Okay.
that they can be brought out. I just don't want the parties to think that I'm going to be making any determinations as it relates to those other issues.
Thank you.
So do either party wish to make an opening statement? Or we can just begin with the testimony.
Present my evidence. Your Honor, I'd like to make an opening statement.
Okay, go ahead.
Your Honor, you're going to hear that back in May of 2023, Laura Owens and Clayton Echard became intimate, which led to my client becoming pregnant with twins. And since May of 2023, Clayton has refused to believe that my client became pregnant. He's refused to believe that he's the father of these unborn children. And he has refused to work with my client to create a plan on how and if he wants to be a part of these future children's lives. Instead, Clayton turned to the internet. He's turned to his fans, he's turned to his followers, and he's spread rumors and lies about my client. Clayton has insinuated that my client lied about being pregnant. Clayton posted online about legal issues he knew little about regarding my client, Laura Owens, and a legal battle that she was involved with and is still involved with another individual. Clayton has posted about Laura that has led to harassment by his fans and followers. Laura has received harassing messages. Laura was asked to, and Laura has been staying inside to protect herself, which is why she's currently appearing via Microsoft Teams for this particular proceeding. And again, this all stems from Mr. Echard's post online. All communication from Laura to Clayton during these time periods that Mr. Echard put in his petition has been related to Laura's pregnancy with Mr. Echard's unborn children. It's also been related to what Mr. Echard would like to do moving forward with the unborn children, creating a parenting plan, and actually it's also in regard to potentially him taking down posts, which again led to harassment by his fans and followers. None of the communication that Laura directed at Clayton was for harassment purposes. All the communication was for legitimate purposes, and a reasonable person in those same circumstances would not be seriously alarmed, annoyed, or harassed by that communication. And at the end of this hearing, we're going to request that the injunction against harassment be dismissed or not issued. Thank you.
So for testimony purposes, Mr. Echard, I'm assuming you're going to be testifying, and then Ms. Owens, I'm assuming, is testifying, counsel.
Ms. Owens will be testifying, Your Honor.
Okay, so if I can have you both raise your right hands, you can be sworn in for me.
promise swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Yes.
You? Okay. All right. Mr. Echard, if you want to go ahead and begin with your presentation of your testimony.
Thank you. I think it is important to just provide a little bit of context for that opening statement. It is what he had stated. I do not believe that Laura is pregnant. I know we're not here to discuss that today, but because of the evidence I will present, I will explain why I've been receiving unwanted messages for the last 5 months, and I have blocked this individual from all communication, yet they continue to send me messages. And I have asked this individual to early on do a paternity test, and she said she would not do it unless I were to date her exclusively. And so then Ms. Owens threatened to go public, which I have submitted that evidence today. But my reasoning for why I doubt her and why I have chosen to cut off all communication is because, if I can submit Exhibit 32.
And what is Exhibit 32?
So Exhibit 32 is an ultrasound image that I was sent via email by Laura. No ultrasound report was provided, and when I asked to speak with a doctor, she would not allow me to talk to that doctor. We also did an early resolution conference. It was in the last couple weeks. The mediator asked for her to make that phone call to that facility to prove that she and did have do this ultrasound. She did not do it. She was not willing to make that phone call. And so with that picture and that picture alone, I believe it is photoshopped, and there is no report that she has been able to provide. And I've asked for it, and I would like a doctor to be able to stand behind that image, as I believe it's a fraudulent medical record that she has submitted to me via email.
Okay. Are you moving to admit to the 32?
I would like to admit, yes, Exhibit 32.
Any objection?
Yes, Your Honor. If I'm not mistaken, Exhibit 32, double check.
This is the ultrasound he's referencing, and there are so many things wrong with this, but you can go over to Dave or Megan's channel, and they do a deep dive into the ultrasounds. For our purposes, let's just look at the basic things, like the fact that it doesn't even look like a real ultrasound because it's just this big blob there, and that's not what ultrasounds look like at all. At the bottom where it says 6 weeks and 6 or 8 days and the date of conception, I have never seen a date of conception printed on a medical record like that before, other than in the date of conception field. They put also that 6 weeks. If you put in her date of conception and you calculate it, that would put her in week 9 based on the date up at the top. Not 6, week 9. Interesting.
It is?
Thank you. May I continue?
Okay.
I would also like to admit Exhibit 36, the flash drive.
Before we get too much further, if you can just explain to me what you believe your relationship is or was with Ms. Owens, because part of the reason it's an injunction is because of the relationship nature of it. I think that you listed as being not an intimate relationship. So I guess maybe if you can clarify that for me.
Yes, Your Honor. Laura and I had engaged in oral sex one time. And to me, as I filed this, I did not believe that constituted a relationship of any kind, as it was a one-time thing.
Okay, thank you. All right, go ahead, sorry.
Exhibit 36, I would like to admit that as well. This is a flash drive file. This was also sent to me by Laura Owens via email. She, in this email, which I actually have, can I submit multiple at one time or no? Or reference them at least for now?
Okay.
So Exhibit 18 is a screenshot of the email that she had sent me with this ultrasound video that she claimed was, you can see on there, I don't know, 1,000,000% real ultrasound video. She's claiming that that was the ultrasound of our children. But then I uncovered the Exhibit 34. This is a YouTube video from over 6 years ago, and that video has the video that she sent me within it. And so Exhibit 36 is the video that she sent me, and then the video on YouTube. And as you play both of them out, you can see that they are identical videos. She had cut a portion from the YouTube video and claimed it to be her own when it was somebody else's. And so I would like to, I'd like to admit at least Exhibit 36, but also 34 and 18 to prove that she did in fact send this to me via email, and as 18 and 34 show, but also then to admit 36 because that is the visual proof that these videos are identical.
What he said yesterday.
Let me make this short and simple. Update time. This individual that was supposed to submit a sample, their second sample, after the first sample came out and said little to no fetal DNA, they were supposed to submit a second sample yesterday. It was confirmed they never showed up and submitted a sample. Wanted to put that out there so everyone's aware. They never showed up. Beyond that, I found out this morning, this individual sent me an email last week and showed me the ultrasound video. I already had my suspicions because, again, I already knew that this was not real. And this morning I found the YouTube video that this woman ripped the video from. So she took the ultrasound from a YouTube clip from 6 years ago. That is also confirmed. I put them side by side. They are the exact same video. This is the craziest thing I've ever been a part of. I just ask that people cover the truth at this point. I've lost out. I just got a call this morning. I lost out on another speaking engagement. I've lost out on tens of thousands of dollars. So hopefully the truth will now get out and save me.
Right here. Twin boy gender at 13 weeks. He claims that this information was taken from her. Now look, two different sonograms side by side. Who are we to say which is which? So that one, baby B, baby A, as shown here, is 3 minutes long. The sonogram we have from Jane Doe right here is 38 seconds long. What is problematic about this sonogram, and again, we're going to show that she denies that this is from her, and she believes that this sonogram was created by one of her exes who is vindictive and out to get her. I'm going to show you the paper trail that proves probably that she is not telling the truth there. So, I added the music. Okay, this is music that I added. What you're seeing here is the start of the video on the left that says twin gender seen at 13 weeks. That's the left and that's the right. So what I did right here in this moment is I synced them up perfectly. And you might say, how could you sync them up perfectly? I am going to overlap them on top of each other so you see that it is one cohesive heartbeat. This might sound redundant, folks, but I don't want there to be a shadow of a doubt that I didn't do my research here. So here they are. And this says sync begins. Let's put it to fit it right here. So this is where the sync begins. I will label where the sync ends. We're watching it. It ends right now. Oh, excuse me. You see the placenta on both sides hits at the same exact second, and that's where the sync begins, and the sync ends right here. Now, the video on the left shows that baby B is there and points out, and now it syncs again. So she edited out this part right here. She edited out, I don't know why, but she edited out baby B. Maybe because there's the little mouse code there. Maybe she didn't want that involved. And again, I say she. It could have been someone else. Again, it might not be Jane Doe. We're going to get into that. So the sync ends. The sync comes back. Baby A on both sides perfectly. And now it's synced. And now baby B comes back. I mean, I got this down to the frame that has it exactly the same.
Any objection to 18?
Yes, Your Honor. I don't think there's enough foundation for the different things that Mr. Echard is stating. It sounds like something was sent to him, and I don't know what websites that he's going to get these. And the things that he's claiming in here, he's saying that these are identical. I don't know if he can testify that these are, in fact, identical.
Okay. So 18 appears to be kind of a screenshot of almost similar to 32, but I think it's closer to matches the 34. But I think 18 is the one that actually was sent to him. Is that correct?
That is correct.
So do you have a specific objection to 18? Or objection?
If that's what was sent to
more
him,
related. Yeah.
Wait, 17, 18.
18, I think, was the one that was sent to him. So do you have something specific about that exhibit?
I mean, maybe just some foundation regarding who it was sent from and how he knows. Your Honor.
So, Mr. Echard, if you can just outline for the court specifically the way that you received this.
Yes, I was sent this by Laura Owens. As you can see in the screenshot, this was sent from her.
What date?
The date of it was October 6th at 4:39 p.m.
Any objection to 18?
Your Honor.
18 will be admitted. And then 34, give me more information about when and where you received this document.
So Exhibit 34, I uncovered as I had questioned the validity of Exhibit 18, what she sent me. I did not believe that it was in her ultrasound. So I started to look online, and I found this YouTube video. And upon playing it, I found that the video that she had sent to me is within that YouTube video.
Okay. Objections to 34.
There you are.
34 will be admitted. And then objections to 36.
There you are.
Right, so 36 will be admitted. Record, if you want to continue.
Yes, I would like to. I would also like to discuss Exhibit 30. So Exhibit 30 entails a prior court case with this individual. And the reason why I bring it up is because of the repeated or similar patterns of behavior that Ms. Owens has exhibited. In this exhibit, there is an ultrasound in which she presented to this individual, and then it was found that through a reverse Google image search that she had taken that from online as well. In this case as well, she states that she became pregnant by this individual, and she also claims that she was became pregnant with twins after one sexual encounter. And so the parallels between my case and this individual's case, I think, is important to bring that to light and admit that as well, because this individual has displayed repeated patterns of behavior. And I think that's important to note as to why I question the validity of this individual's claims.
The different ways. And I think the biggest tell is her saying, I think all sonograms look the same.
Right.
I like
Yeah.
that part.
Absolutely. So
They don't
I guess
look the same.
let's set the table here. This is what's going to be the ultrasound image that's of question. This image has proven to have come from this blog, I Still Believe Vanishing, which is about a vanishing twin, which is essentially when one of a set of twins isn't viable, and rather than expel it, it gets absorbed. I believe I have that right. And he calls her out on this. We're going to see how quickly he calls her out on this reverse image search. We're also going to see how these images are the same, but how they've been doctored. So it's my belief that she or somebody doctored this image. It's also got this extremely bizarre sort of like UFO-like crop circle happening here. So it's got this kind
That's
of
a blur dot. I'm sure that's a blur dot.
so what's interesting here, and by the way, there's also I never saw this. What are we seeing here? What's this? HEVN? Is this a? Are you seeing this? I'm
That's
literally.
Yeah, that looks like a watermark.
What the hell's going on here?
What is
How
that?
You
Wait a
know what?
minute. Go back in.
I never noticed it, and now I can't see it. I can't unsee it. What the hell is that? VEN
That's a
NVEN.
watermark.
What weird?
That's a
Did she
watermark.
possibly alter this? Okay, hold on a second. I don't know, but could she have possibly altered this in one of those apps that she was using the free version of the?
Well,
Is
Danielle
that?
says it says Fiverr.
Oh no! Oh, no. Hold on. Okay, hold on. This is why you do it live.
And where did you obtain this document?
I obtained this document from this court. I came in here, it's publicly accessible. So I came here and I searched it, and there's about 14 pages in this that I printed off. There's more in the court system, but I consolidated it to bring out the documents that referenced similar instances. And so this individual that she had brought this claim against also questioned if she was pregnant or not. It does state in here that she provided sonographic images, and then a reverse dual image search revealed the images were identical to a sonogram found on a blog post from 2015. And then within this document, it shows the pictures that were submitted to the court, the ultrasound in question. And then I'd also like to bring to, in this document, in the picture, it says that she'd sent to him, it looks like you're going to be a dad to 1 or 2 babies. And so she again states that she was pregnant with twins with this individual. And then on one of the last pages of this document that I had pulled out, it was noted in this court case, the plaintiff reportedly fabricated a pregnancy and subsequent abortion in the past during a relationship with a Michael Maricini in 2016. I do not know the specifics of all of these cases, but I do want to bring this to light and submit it admit the exhibit because of the repeated patterns of behavior that I think are important to note, because contextually speaking, that is part of the reason why I will then present my evidence towards why I feel I'm harassed, because I do not believe what this individual is stating. I don't believe anything that she's saying, and these are the reasons why.
I'm going to object to this being entered. This is an ongoing case. We don't know what claims are or are not true within this exhibit. I don't think that it's appropriate, and I don't think that it's relevant to Mr. Echard's petition in this specific matter.
So one of the allegations is a pattern of behavior of accusing men of getting pregnant in his petition. So I guess that's what he's presenting it for. So hang on, Ms. Owens, just a minute. I think that's one of the allegations in his petition, but
again, Your Honor, this is an ongoing case. We don't know what the results of this specific case regarding this exhibit is. We don't know anything about this case. We have it looks like this is some sort of complaint. It looks like it's a motion to dismiss, I'm sorry. Or there's several documents here. I don't think that this is relevant for this particular case. I think that this is speculation. These are claims that other people have made think this is hearsay. I don't think it's admissible for this type of hearing.
All right. So I'm not going to be able to admit Exhibit 30. I do agree that there's not, this is a complaint and a motion to dismiss, but whether or not there's significant information enough to be able to support that and whether you have any knowledge of it is I think, I'm not going to be able to admit that exhibit. Ms. Owens is raising her hand, but your attorney is here. So did you have a question?
No, he covered everything.
Okay. And he's going to be speaking on your behalf unless you're testifying. So
I would like to testify.
You don't have your chance to testify, but you can't testify in the middle of his testimony, and then your attorney needs to be the one that speaks on your behalf unless it's your testimony, okay?
Okay.
All right, Ms. Echard, anything else?
Yes. Now I'd like to go in and admit each of these documents, and I have them set in an order. So the very first one, Exhibit 1, this is just showing all of the files that I have accrued. There's often 2 to 3 emails that she sends me a day. She started sending me emails, harassing emails on the 6th of June, and she is still sending me emails as of yesterday. And so Exhibit 1 is just showing the frequency of her harassment from a bird's eye view.
And so when you get the email from her, tell me how this gets created.
Yes, so when she sends me emails, I screenshot them and then I place them into these files so that I have them for a record.
Okay. Any objection to Exhibit 1?
Yes, Your Honor. Again, I don't think that the frequency of emails is something that would indicate harassment without something more. If there's communication back and forth between emails, then the frequency of how many times somebody sends an email, I might send 60 a day, but the frequency of emails between, I believe, May to now, and I don't know how many these are. We don't see the emails in here. There's nothing to say that this, in fact, is harassment within the meaning of the statute. So for those reasons, I'm objecting to this being admitted.
All right. Over the objection, I'll admit Exhibit 1.
Thank you. Can I continue? Exhibit 2, a lot of these next exhibits are all going to be phone numbers that Laura has contacted me from. She has contacted me from 13 different phone numbers, and I finally stopped blocking the 13th one because I knew that she just would continue to create a Google Voice phone number. And so this first one, it says in the text message, it's Laura, I need please unblock and then she shows her number. That was her original number. And so I would like to admit these one by one to show again the many different times that she has continually contacted me after blocking her from different phone numbers.
And so this is a text message from when, do you know?
Unfortunately, I don't. It just says text message from today. Again, I was screenshotting these as I received them. I received these over the last 5 months. As far as what exact day, I'm not right now. I'm not aware, and I don't know if there's.
Can you approximate when this message came in, or you don't know?
To be honest with you, Your Honor, as far as when this one came in versus the other ones, I don't know. This one says, I have it down here as her blocked cell number 12, so this was probably one of her last ones that she had sent to me. And I would say that I think this one came through probably about a month ago, because since then she resorted back to sending me emails because she put a mail tracker on the messages. So she was able to see when I was reading them. But during this period of time, when she was sending these text messages, I was not opening her messages. And so she knew through her mail tracker that I wasn't reading them. So she decided to go about the Google Voice manner in order to get them to me, because she could see that I was not opening her emails.
Okay, so you have this one, you believe is from one of the 12, at least one, the 12th message, that as well cell phone number that she was using.
Correct, yes. Each of these came from Laura, yes.
Okay. Any objection to 2?
Yes, Your Honor. Again, Mr. Echard must show that there is harassment. When I look at this text message, I don't see anything that is even remotely close to harassing here. It's a text message indicating to him that they're having a boy and girl. She has an ultrasound to show. I just don't see anything in here that is even related to the petition itself that shows that this is harassment, that he was annoyed, alarmed, harassed in any way. This is simply a text message.
Well, I mean, part of his, petition is the high volume of those, and that ultimately he can testify whether he was annoyed or harassed by these. So I'm going to admit Exhibit 2 over the objection.
Thank you. Again, Exhibit 3, just to make this, again, I want to be respectful of everyone's time here. This is, again, another cell phone that she had contacted me from, so I'd like to admit this one as well for the same reasons as Exhibit 2. Your Honor, it sounds like there's going to be a number of different cell phone screenshots submitted to the court, and I just want to make record sure that I am objecting to all of these based on the same reasons I was objecting in Exhibit 2. So,
okay. So
I don't have to just repeat myself over and over again.
All right. And so, this Exhibit 3 it has that similar language to police and blocks the original number. So you're telling me this came from Laura, but from another blocks number.
Correct.
All right. I'll admit 3 over the objection.
Thank you. 4, also sent from Laura. This one says that she couldn't get into Google Voice, had to make a new number. So again, this one just shows that she was in fact using Google Voice and creating more and more numbers in order to harass me. And yes, I did feel harassed because I did not want these messages. This one you can see I did respond to, and what I said is how I felt. I was asking for her to schedule the paternity test, which she continuously declined unless I were to date her exclusively. But for the purposes of this text message, it was another unwanted text message that she had sent my way.
So tell me a little bit more about the dating thing, what you're telling me when you say that.
Yes, so you can see this in this exhibit here. She said, guessing you won't read this, but I made you a pretty good offer. Meet up tonight to discuss the pregnancy and the possibility of dating. But regardless of the outcome, I will schedule a test with Radgen tomorrow. So her stipulation for taking a paternity test early on has always been that she would only do the test if I were to date her exclusively for 2 weeks. Then she dropped it to a week, and I did not agree to any of that. I simply just said, as it says in here, drop the dating stipulation, schedule the test, pay for the first part of it, then email me when you schedule it, and I will schedule my part. So I had continuously tried to figure this out, and she would not do the prenatal paternity test unless I were to date her.
And this Radgen is the?
Radgen is it is the facility that provided the test so that you can test for a prenatal paternity test for twins.
Okay. All right, I'll admit 4 over the objection.
5, again, is another text message. From her again, saying that she doesn't know how to use this app. She's referencing Google Voice. She said, I'd like to meet, no strings attached. I did not want to meet with her. She's asked me to do multiple times. I do not feel safe meeting with her because I'm not sure what she would claim if we were to meet up. And I don't have any reason to meet up with her. So this is another text message that she sent me that was unwanted and very harassing.
Over the objection, I'll admit 5.
6, again, another text message says she should change her number. I would like to admit this one as well for the same reasons as the previous messages.
All right, and this is another different number than previously used.
Yes, and then in this one I would even just like to highlight, she said she threatened to leak this to the media, which I will be admitting in evidence for that, but she threatened to go to the media, which she ended up doing. This text message just proves that she was, again, looking to defame me through basically whether we date or leak this to the media. She threatened me to go to the media with this text message, amongst other times she threatened me.
All right. I'll admit 6 over the objection.
7, similar thing again. She stated this time she would do it with no strings attached. I had then responded by saying, let's schedule the paternity test regardless. But she was asking for this agreement and that we needed to meet up for a good faith consultation. Again, I did not feel safe meeting up with her one-on-one, so I disagreed with this. But this is another text message that she decided to send from a different number. These are all, as I can just a reference, these are every single one of these, as you can see at the top, they're all different numbers. So these are all coming from a different number every time.
I'll admit 7 over the objection.
Another text message, she just states that she sent an email to Rabjan, and then she threatened, you want me to go to the public instead of meet up? So those were the options. Either we meet up or she goes public with the information.
I'll admit 8 over the objection.
9, another message that I didn't block. As you can see, she sent multiple messages before I decided to block her. And she was asking for a good faith consultation. Again, she was trying to meet up with me. For what reason, I can only speculate, but I did not feel comfortable doing so. And so this is another phone number that I ended up blocking.
And can you elaborate on what it says I just made, what I think is a very enticing offer? What that mean?
So to be honest with you, I don't remember exactly what her offer was. She made multiple ones, but they all centered around a very similar, if we meet up and we try to date, it was 2 weeks, and it became 1 week, then it became just meet up for this tonight, this good faith consultation. And she would make a lot of promises as far as once we do this, then I will go take the test. But again, I did not feel safe being with her one-on-one. I did ask actually to meet up with in the court, or I said we could even meet up. At one point I said a coffee shop with people around, and she declined that and said, no, we need to meet up in private. So I said no to that and blocked her again on this phone number.
All right, I'll admit 9 over the objection.
Again, 10, this is another phone number. She mentions going dark on her, which is a reference to me not responding to her. Again, just to highlight that she has been consistently harassing me with me not responding to her for the large majority of these messages. The only time that I was often responding was to try to get a paternity test scheduled. Outside of that, I did not. I had little to no interaction with her. And so at this point, she references here, I will cancel the Rabjan appointment. She had scheduled one, paid the $750 for it. But then in the past, as she had stated she had scheduled it, she would end up canceling these. So it was just a show on her side of things to state, yes, I'm trying to do this test. But when it came down to it, she always placed stipulations whenever I responded to her. So at this point, when she said I'd spend $750, I did not respond to this and block this phone number because I was not taking any of what she was saying seriously. Because every time I would ask, okay, let's do this, she would bring a stipulation on board.
Submit 10 over the objection.
11. So again, similar thing. I think this is around the same time. She said she'll tell Rabjan that we don't want the appointment next week. But I couldn't be more steadfast in my decision not to take it early without the stipulation. So again, the stipulation is the only way, as she says here, and then she says, anyway, I hate to go to the press, but that was your decision as well, and I respect it. And then she even says, she tries to talk about making an offer on a property for real estate. But so again, I don't understand why, as clearly there's no relationship here or any interest in me wanting to talk, but yet she was trying to have any type of discussion with me. But again, she said your stipulation is the only way to do the test, and so I ended up blocking her again.
That was mid 11 over objection.
12, again, this one, she said she wants to do the test. I then said, you want to do the test and the stipulations? She said, you're going to be forced by the court to meet up with me. So the second I found out that she, again, I asked, she'd do no stipulation. She ended up saying, you have to meet up with me. And then she says down here, I said, you're willing to meet up in a very public place. You will take the test afterwards. She said, no, it's with a week worth of stipulations and hopefully more. So again, she stated that after she said she wants to take the test, she then confirmed that she was not willing to take the test unless the stipulations were added.
Amendment 12 over the objection.
13, again, another message from Laura, different number. I asked her if she'll meet up at the court with the mediator present. She said that's not how it goes. We can meet up just us, and I will withdraw the request for sanctions. And then again, I said, would you meet up in a public location? This thing was cut off. It was in another text message, but she ended up disagreeing to, or not being willing to meet publicly. She said we had to meet privately, and so then I blocked her on this phone number as well.
Amendment 13 over the objection.
Okay. How am I doing on time?
You have about 10 minutes.
That's okay.
Maybe 15 minutes.
I want to skip now. I want to make sure I get to the ones that I really want to talk about.
Mm-hmm.
Okay, so Exhibit 15. Laura sent me a very alarming message stating that she was going to kill herself if I do not remove it was a video that I posted to my Instagram. So Laura has claimed that my responses online are meant to defame her, but that is not the case. Laura decided to leak the story to the Sun originally, and she leaked it with her as anonymously, so she did not place her name out there. But what she did do is she mentioned to them that we had an active court case. So that active court case, she is the one that brought that against me. In that court case, her name was on the court documents. So she ended up then bringing that, once this was leaked to the Sun, they submitted the story, and then it stated that within that document that there was an active court case with me. People then searched my name and found her name through that. So this email right here, she was basically threatening me to take down my video. In my video, I just stated that this individual was making these claims. I just made a statement of the facts, so they were making these claims, and they opened a court case against me. And then from there, I do have a large following. I am a public figure, a celebrity, I suppose. I don't like that word. But I have a large following, and then that audience, I cannot control what they do. But they then went and found that court case in the system and found her name, and then started to talk about her online. And then Laura, I assume, was feeling the pressure from it being online and her name being out there. She then sends me this alarming message, which again I felt was harassing, but to threaten to kill herself. I don't think anybody should ever receive a message such as that.
All right.
I'm going to continue to object for the same reasons that the other exhibits 2 through 11, actually 2 through 13, for the same reasons. I don't think that, again, this is showing that this is harassment by sending an email to him, asking him to take down posts, or saying that maybe she is suicidal. And for those reasons, I'm requesting that this not be admitted into evidence.
All right. I'll admit 15 over the objection.
Thank you. Come back to that. Let's see. I just want to make sure if I have some on that time here. I'll jump ahead here just to Exhibit 23. So Laura has contacted multiple nonprofits that I work for in attempts to defame me. and basically get them to not work with me. So in this email here, she sent this to the Arizona SPC. This was I just spoke actually at this Hope conference. I'm a mental health advocate. And so Laura began to blackmail me and reach out to individuals that she had seen that I interacted with online. So I'd like to admit this as evidence that, again, she was harassing me through reaching out to individuals close to me in attempts to defame me.
And how did you get this? It was sent to you as well?
She copied me on the email.
Okay, and when was this sent?
This was sent on August 3rd, 2023.
Okay. Any objection?
Yes, Your Honor, I'm going to object because this appears to be an email that Mr. Echard was either to or CC'd on that indicates his reasoning for why she believed that he shouldn't be a speaker at this conference. And this isn't harassment, and it doesn't seem like it was directed toward him. It was directed, although he was CC'd in the email, or he was in the email, it was directed to the Hope Conference in relation to whether he should be speaking at this based on what was going on and his credibility. I don't think this would be appropriate to be admitted in this case. This wasn't directed toward him for harassment purposes, and so this shouldn't be admitted.
All right, I'm going to admit 23 over the objection.
I would like to now go to Exhibit 26. This email was sent by Laura threatening to sue me, again, with the videos that I was posting in order to protect my own image. My image is how I make my money, and I make my money online, mental health advocate. Also, being a public figure, I have brand deals and such, and companies that I work with. So everything that I'd stated, I've never once mentioned her name in public, and then in this email, as I put up a video to protect my own integrity and protect my own reputation, Laura threatened to sue me with a massive lawsuit and stated she had an unlimited budget to sue me, which I felt was very harassing in nature.
Is this the same video that was the previous nature of the other email that she was asking to take down? Or is that something?
I believe this one was. To be honest with you, again, I put up a few messages or videos. I believe that was referencing that video, where again, I believe it was either that, but to be honest with you, I'm not sure if it was that one or if it was the one where I stated I had scheduled a prenatal paternity test and I was waiting for her to schedule her portion. I submitted I think I put 3 or 4 public statements online, and every time she had threatened me to take it down or face legal action.
Any objection to 26?
Yes, Your Honor, same thing that I've been objecting for this entire time. Again, I don't think that this email specifically shows that she was trying to harass him. I don't think that it's relevant to the petition, and for those reasons, I don't think this should be admitted.
I'll admit 26 over the objection.
Thank you. Anything else? I guess I will go to Exhibit 19 now. This is, again, another email that I was copied on. Laura had sent this to my father. I sent a long email basically saying that I blocked her and that, hopefully he could get through to me and get me to end up talking with her. So I want to admit this just to show that she went to many various different avenues, friends and family, in order to bring light to this and put pressure on me to then interact with her.
Different objection to 19.
This isn't directed at Clayton, Your Honor. This is directed at his father. It's an email to his father. Mr. Echard's father is not indicated in this petition. He's not here today. I don't think that this should be admitted for those reasons.
It does appear that Mr. Echard was copied on the email as well, so I'm going to admit 19 over the objection.
Thank you. I'd like to look at
About 5 more minutes.
Okay, thank you. I'd like to look at Exhibit 16. This was an email sent to me from Laura And basically in this is Exhibit 16 and 17. They came within the same email. She stated that this is the photo I'm going to use. It was a picture of two pieces of clothing saying Echard twins coming February 2024. In this email, she said, "Surprise! I can't wait for the arrival of these two next Valentine's Day," which I don't know how she would know that she'd be due on February 14th. But she stated then that on a more serious note, their father said he wants nothing to do with the process. He has blocked me. Tag him and let him know what you think. So this was a threatening email where she was stating, if you want option A, and option A had to deal with dating her. She said, "I will not post this. I'm just looking for support during this incredibly overwhelming time."
And when was this sent?
I see that it says yesterday, 2:23. So I wish there was a timestamp, but I believe this was earlier. This was probably 3 months ago. It was towards the beginning. Again, this has been 5 months ongoing, but this is probably 3 months. And at this point, this is before she had not leaked the story to the Sun at this point.
Any other objection to 16 or 17?
Objections to both for the same reasons stated before, Your Honor.
All right. At 16 and 17.
Thank you. I'd like to focus on Exhibit 21. So this shows a process server that Ms. Owens hired to serve me papers when I went down to Miami to visit my cousin. She knew that I was down there, and she had researched women that I had interacted with or expressed interest with in the past, found that these two women lived in Miami. I didn't even know that Mrs. Jessica Gerard even lived in Miami, but I did not go to see either of them. But she had a process server try to serve papers to both of those residents, which I felt was very harassing in nature, as these individuals I have not been in contact with for quite some time, and I believe it was a display of power on Ms. Owens' part to, again, harass me and try to get other people involved. And so I'd like to admit this because I felt that, again, it was very harassing in nature that I had a process server trying to serve papers to individuals that I had expressed interest to in the past. It didn't seem necessary, as you could have just served the papers in Scottsdale.
Yes, Your Honor. In almost any lawsuit, there needs to be service of process. That's how a lawsuit begins. That is for personal service. The court has jurisdiction over the person. Nobody likes to be served papers. I don't think that this shows any amount of harassment. This was the process server emailing Mr. Echard. My client isn't even on this email.
All right. So I'm going to sustain the objection as to 21. I'm not going to admit that one.
I guess I can just admit this. The last one, Exhibit 35. This was sent on Friday of last week. I took a screenshot of it. This is after Ms. Owens filed a order of protection against me. And as I've never threatened her, I believe I have not ever threatened her, but yet she continued to contact me. So this was, I thought, again, she was asking to go to a sonogram appointment, and it would mean a lot to me if you would go. Again, I think all things considered, the fact that she's still, I had no interest in wanting to meet up, and she was still sending me these messages after she placed an order of protection against me. I think it just more so shows that the reason she sent the order of protection, it would not make sense as to why she would want to meet up after that point. Again, this felt threatening because just another message that she continued to send. And I just didn't, I've been not wanting any of these emails to come over to me.
Any objections?
Yeah, Your Honor, same objections as before, but at the same time, this is outside the scope of even this petition.
And I do think we're restricted to kind of the petition since this was happened after the petition was filed. I will sustain an objection and not admit 35. Record, if there's any other testimony you want to give as well, just outside of exhibits that you want to let the court know, you can also provide other testimony.
Yes. Is this the time for me to ask a question in the court, or as far as what I don't know?
I'm not sure what that is, but you can.
Again, I guess I'll say this.
And you'll have the time to do a closing, but if you have additional evidence or anything else you want to present, just that's what I'm looking for you to do. But if you have a specific question, you can ask that as well.
Okay. I guess I just wanted to state, well, maybe this would be better for my closing statement. I guess I don't have any questions at the moment.
Okay. And no other evidence you wanted to present?
I mean, for the sake of time, I know that I ran out. I mean, I could try to submit the rest of these, but I think I've run out of time.
All right. Thank you. Any questions?
Yes, Your Honor. You were Laura's real estate agent, is that correct?
I was for a brief period of time, correct.
Okay. And that was earlier this year, is that correct?
Correct.
All right. And back in around May of 2023, you and Laura had become intimate, is that correct?
Correct.
And since then, Laura has made it known to you or has claimed that she's been pregnant, is that correct?
That's correct.
And you have, even until this day, you've refused to believe that Laura is pregnant, is that correct?
I would say that's not correct. I mean, I did question, yes, if she was, but I have tried to give her every possible option or ability to prove to me that she's pregnant. She's not allowed me to talk to any of her medical examiners that have administered the quote-unquote ultrasounds that she has done.
Okay, and she isn't required to give you her health information, is that correct?
I personally would say that when she's claiming I'm the father, that the father of her alleged children should be able to have access to her medical records, especially when it's pertaining to pregnancy.
But it is true that at the beginning, back in maybe May or June, you did not believe that Laura was in fact pregnant. Is that correct?
Yes, I have questioned if she's pregnant.
Okay, correct. You have exchanged emails or text messages with Laura indicating that you did want her to get an abortion. Is that correct?
I had stated that if my preference was to not have children with her, but it was ultimately her choice, and I was not going to pressure her.
And those were communications that you had back and forth with Laura in text messages. Is that correct?
Yes, we had interacted via email early on.
Okay. But had you also interacted with her in text messages?
Yes, as evidence I've submitted, I did respond to her early in the messages.
Now, you agreed to meet with Laura or have Laura come to your house to do a pregnancy test. Is that correct?
That's correct.
And Laura did come to your house to do or go to your house to do a pregnancy test, correct?
Yes, she ended up doing one when she was there, yes.
Okay, and that test showed that she was in fact pregnant. Is that correct?
And showed that she had HCG in her blood, yes.
Okay. And when you all agreed to do that, you were communicating back and forth with Laura, correct?
Correct.
She didn't just show up at your house, correct?
Correct.
You questioned then not only whether she was actually pregnant, but then whether you were the father. Is that correct?
That is correct.
And Laura went out of her way to schedule various paternity tests to show that you were the father. Is that correct?
For that, I would say she was claiming she'd scheduled them. She did schedule a few, but then whenever I did not agree to her stipulation, she canceled them.
Okay. So she scheduled a few. Is that correct?
I believe she did, yes.
Okay. And it was her that did the scheduling. Is that correct?
Until I scheduled one, yes, that she and I took recently, which came back little to no fetal DNA present.
Okay. The communication between you and Laura for the scheduling, was that through email?
Yes, mostly it was over email at that point, correct.
Some of it was through text messages, is that correct?
I had asked for her to schedule them via text. Yes, I believe that, yes, I mean, as you saw in the exhibits, I had asked for if she would do it without stipulations.
Okay. And so there was communication back and forth between you and Lori, is that correct?
But yeah, it's very limited overall considering the frequency of the messages she sent. But yes, at certain points I was trying to work this out with her.
Okay. Now, the text messages and emails that you've provided to the court today, those are not all of the text messages from you, and of course they're not all of the text messages from her. Is that correct?
That's correct.
And same thing with the emails. That's not all the emails from her. It's not all the emails from you. Is that correct?
That is correct.
Okay.
I would not be able to submit.
I don't have a question. Now, you at some point in time stopped responding to Laura, whether it be through text messages or emails. Is that correct?
Yes.
And this is also around the time when Laura was trying to schedule the paternity test. Is that correct?
I stopped responding, and then she started to state she wanted to schedule a test. Just she was claiming she wanted to, but she would never, whenever it came down to me wanting to schedule it with no stipulations. So I stopped responding at a certain point when I realized that she would always keep adding the stipulations in. So from that point forward, she was making claims she wanted to schedule them. It didn't mean anything. She had already proven that she had no interest in actually following through.
Was there a time that you're aware of that Laura hired an attorney to help schedule the paternity testing?
I had spoken with one of her attorneys at one point, and they had shown me the ultrasound that I had admitted here, and I asked for them to subpoena the records or to get the records from that ultrasound. She would not provide it, and then stated that I asked her if she would schedule without stipulations, and the lawyer told me she would not.
Okay. Laura paid for you to have or to do some sort of blood test to determine, to do your part of the paternity testing. Is that correct?
As I referenced in my exhibits, she did make a payment, and then when I would not do it without the stipulations, she canceled.
She canceled or you canceled?
Canceled. Somebody canceled my portion. It was not me. It was I. They called in and tried to cancel my portion, in which case I found that out, and that's what led to me scheduling it and then going online to make a statement so everyone knew that I was trying to do this paternity test. I did not cancel it, though. Absolutely not. Somebody called in and canceled it for me because our names were under the same test.
You're stating that somebody canceled a paternity test on your behalf, and it wasn't you, and you didn't authorize that?
That is correct.
Now, you and Laura have an active family court case together, is that correct?
That is correct.
And it was Laura that filed that case against you, is that correct?
That's correct.
And this family court case is in regard to paternity, is that correct?
In regards to a parenting plan, she filed for a parenting plan.
Okay.
The children that have not been proven.
All right. And you're not represented by an attorney, is that correct, in that family court case?
That is correct.
Okay. And is it your understanding that she, at least at the time, wasn't represented by an attorney in that case?
I understand the purpose of that question, but I don't. But I've spoken with lawyers. I believe that she filed in that case, though, as representing herself.
Okay. And the court ordered that you guys meet and confer. Is that correct?
For an early resolution conference virtually, but not to meet in person. That was never sent to me, although she claims that the court mandated that.
To resolve different issues prior to that conference. Is that correct?
The court did not mandate that. I never was told by the court. I was told to show up to an early resolution conference. She said that we were supposed to, if able to. Apparently the court asked that individuals try to resolve all matters, but I had no interest in doing that because I did not trust her if we were to meet up one-on-one, what she would accuse me of.
Okay. But you emailed you or texted you in regard to trying to resolve those issues before showing up to the early resolution conference. Is that correct?
Claim that we needed to meet up to discuss matters. What specifically I was not sure of.
Now, you have accused Laura multiple times of lying that she is pregnant. Is that correct?
That's correct.
And you've done that online. Is that correct?
I believe in a video, again, I never once mentioned her name. I believe I may have said I questioned whether or not she was pregnant.
Okay, so you insinuated that she was lying. Is that correct?
I believe she was lying, yes.
And the different media outlets that have you spoken to media outlets about this?
I early on provided statements to a couple of outlets to state that I did not believe that I was the father, and that I was hoping to do a prenatal paternity test in order to prove whether or not I in fact was.
Okay. And up until recently, you hadn't done a paternity test. Is that correct?
Yes, but that was because of Miss Owens was not willing to do one as I asked her to as far back as 4 months ago.
Okay, so you're blaming Miss Owens for not doing a paternity test. Is that correct?
Correct.
And that's why you wouldn't do a paternity test?
I could not do one because she would not do one. She would not do it unless I were to date her. Those were her stipulations.
Now, you indicated that you spoke to the media about this, and they published those statements online. Is that correct?
There were a few outlets, yes, that published my response. Yes.
And the results of the paternity test are not resolved. Is that correct?
I was told that little to no fetal DNA was present on the first sample and that she needed to submit another sample.
So the results are not in yet. Is that correct?
Yes, I suppose that is correct.
Now, you had indicated that Laura had blocked you several times. I apologize. You had indicated during your testimony that you had blocked Laura several times in various from various numbers. Is that correct?
Yes.
Okay. But you were in communication with Laura this entire time since May. Is that correct?
I would not say that's correct. I was not in communication the entire time. If I were to be able to show all the exhibits, I probably responded to maybe 5% of what she has sent to me.
Okay. I'd like to take a look at Exhibit 4. Plaintiff's Exhibit 4. You had indicated that this was a text message from Laura to you. Is that correct?
Yes.
Okay. And you had responded to Laura in this particular text message. Is that correct?
Correct.
Okay. Is that the same thing with Exhibit 12 and Exhibit 13? You had responded to Laura after she messaged you?
If there's a text bubble, as I'm trying to look here for the sake of respecting time, if there's a text bubble, then yeah, I mean, I was the responder in those messages.
Okay. And in all of these text messages that you submitted to the court, did you ever, one time, tell Laura to stop texting you?
Multiple times I asked her to stop communicating with me.
Okay. I'm asking in the exhibits you submitted to the court and in your testimony, you not one time ever said that Laura stop texting me or stop communicating with me, did you?
I'd have to go back and see exhibits that I directly submitted, but I've asked multiple times for her to cease communication. And now you're asking for me specifically if I stated this in the text messages, but I can absolutely confirm I've asked her multiple times to stop responding to me. And I have evidence to prove that, maybe not on these text messages alone, but again, I have 500 exhibits I could have been submitted.
And isn't it true that you indicated Laura threatened to go to the media regarding this, correct? You had indicated that Laura had spoken to you either via email or text message, that she was willing to go to the media to discuss what was going on between you and her. Is that correct?
Yeah, she stated she was going to go to the media, yes.
And didn't you email or text Laura indicating, go ahead? Essentially, go ahead, you can talk to the media.
I believe I did state that at one point, because my reasoning for that was because I knew she was trying to threaten me and scare me by going to the media, and I did not want to give her the joy or whatever you want to call it of knowing that she was affecting me. So I just stated, sure, if you want to go to the media, go to the media. But I was not giving her permit. I guess I wasn't agreeing to it. I just knew it was inevitable. She was threatening me.
So you consented to it?
I wouldn't say I consented to it. I wanted to resolve this privately, very, very early on, multiple times. And as I sent some of these exhibits show, I was trying to. She had threatened to go to the media multiple times. And at that point, after she had threatened me multiple times, I stated, go ahead, just simply because I knew that she was going to continue to threaten me and she would eventually go public.
No further questions.
And you have an opportunity to provide rebuttal testimony if you want to, based on what he's asked you. If you have anything else you wanted to help clarify.
Yeah. Again, I think what he's trying or what he's attempting to show is that there was continuous communication throughout. And I believe, again, this is a matter of frequency, my messages versus hers. I was continuously trying to solve this matter. And the few times that I did reach out, I was trying to come to a conclusion. Again, had I actually been the father and the prenatal paternity test was done 4 months ago, I was willing to take the test back then and willing to then move forward from that point. But this individual, Ms. Owens, never had any interest in settling this matter. As I had referenced in our prior cases, this individual, I believe, again, this is just my opinion, but, harasses individuals into dating her. And when they do not want to, then she starts to say that she's not willing to take a test, or at one point it was, I'll take Plan B or the abortion pills if you agree to date. So there's always stipulations around that. But the few times where I did respond to her, it was from me trying to get a prenatal paternity test on the books, because I was wanting to be able to prove that I was not, in fact, the father. Through all of this, I just want to make this statement. Ms. Owens has not been able to prove that she is 5 months pregnant with twins. A positive HCG test, you can manipulate HCG levels. These sonograms don't have a report with them either. And so no doctor has ever stood behind these tests and been willing to state that she is in fact pregnant with 5 months pregnant with twins. And so
I'm going to object right now. This sounds like a closing argument as opposed to testimony.
Overruled. Go ahead.
So again, the whole thing for me is I've been trying to quash this. I've been trying to come to a solution. I never wanted this to be public. I never wanted this to get out there and be such a big deal, but this individual did and made sure that it got out. I would just, again, I would like the order of protection or injunction against harassment. I would like that because this individual is an aggressor, and if she will not continue to come after me, or she will continue to come after me unless I cut off communication. And so this is, whether or not I responded, it's the sheer frequency of unwanted messages that she sent me.
Tell me what that is. Tell me what you believe is the number of messages you've received.
I believe, in that I believe she has sent me at this point 400 to 500 emails, probably.
That's over what period of time?
Over 5 months.
And is that including email and text messages, or?
Yes,
email?
She predominantly has sent me emails. And most of it was mostly email, not text message that she's been sending me.
the messages that you provided as exhibits, a lot of them were text messages.
Yes.
And so the other messages that you were receiving, I think Exhibit 1 had that big picture of all those, emails or whatever, but your testimony is that primarily she's been communicating you with by email. And tell me more about the nature of the emails that she's been sending.
Yeah, so as some of the exhibits I admitted today, these are just the ones that I felt, again, I know that we're here for injunction and harassment, so I was focusing on messages that pertain to harassment itself. But the rest of the messages, again, were very repetitive. I think a lot of this is encapsulated as far as what she was sending me. She would send me visual images to try to harass me. She noticed that when she sent visual images, I became emotional, and then she would send more messages on top of that to try to aggravate me. Again, I was not able to submit all of the emails because I would have submitted probably 500 to 600 exhibits. And so for the sake of time, I chose what I felt was specific to harassment itself. But I would say that, again, the first exhibit that I submitted, it just shows you with the folders the dates and how often she was sending me emails. And it was just every day, or every other day for 5 months. And I believe that this individual, again, her whole, she tries to overwhelm individuals through constantly messaging and trying to convince them of this reality that she has created. But again, as I will have to go to court tomorrow with the family court, she has not been able to prove she is 5 months pregnant with twins. And I continue to reiterate that because she has falsified medical records, I believe, and she's also lied under oath. And I believe these are criminal offenses, and I believe that this individual continues to do this in court, and that is why I tried to draw parallels with the other cases, because she's done this multiple times, and I believe that she'll continue to do it. So I am trying to, for one, stop her from communicating with me, but I'm also trying to bring to light that this individual continues to do similar repeated patterns of behavior, and it has been extremely stressful. I have been very, very, very stressed out by receiving these constant influx of messages that could have all been solved had she had just took a prenatal paternity test all the way back at the earliest time that we were able to do so. None of this had to have happened. She didn't have to take it this far. But the point I'm making is she never actually wanted to take it until I went public and stated I signed up for a prenatal paternity test. Now she needs to schedule her part. I then placed that upon her to schedule her portion. And then as people knew that she had to schedule it, she then scheduled. But the test came back little to no fetal DNA present, which would track with her not actually being 5 months pregnant with twins, because if she had twins, then there would be fetal DNA present. She claims that there was an issue with the sample. She then submitted another sample that got caught up in Tennessee or wherever. It didn't make its way there. I can give my own opinion on what I believe happened, and I believe the message may have been intercepted, but I do not know that. But I know that when she tests again, it's going to come back the same thing. I do not believe, at this point, I'm not technically questioning that she's not pregnant, because I do believe she may have gotten pregnant to corroborate her story, but I 1,000% she does not believe that she's not 5 months pregnant with my twins. And that ultrasound that I have, she would not call the facility when I met with the mediator at the early resolution conference. She would not get on the phone and make a phone call to just state, did I in fact come to this facility? Because I believe she never went to that facility, and that was a falsified medical record.
All right. Anything, Mr. Lopez, do you want to present some testimony?
Yes, Your Honor. And before I present, how are we on time?
Fairly short.
How much time do we get?
I would say 20 minutes.
Okay. Could you please remind me when we're at 5 minutes? I appreciate it. Thank you, Your Honor. So, Laura, how did you first meet Clayton?
He was my realtor. I contacted his agency because they specialize in creative finance, and then I got connected with Clayton. I'm sorry, go on.
Did you become intimate with Clayton at some point?
Yes, I did.
And was it Clayton that, I guess, made you pregnant? Or is it the two of you that created these unborn children?
Yes, there's absolutely no possibility at all they are anybody else's. There's no chance.
And you're testifying under oath today, is that right?
Yes, absolutely.
Under penalty of perjury.
Yes.
Now, when did you find out that you were pregnant?
On June 1st, I found out.
Okay. And did you ever let Clayton know?
Yes, I let Clayton know on June 1st that I was pregnant.
How did you let him know?
Well, I had gone to urgent care to get the pregnancy confirmed because I figured he wouldn't believe me. And then afterwards, I sent him a text telling him that I was pregnant.
And how did he react?
He said that if he was found to be the father, that one of us would get 100% custody. He wouldn't do joint custody. He told me, or it will be put up for adoption, was what he said initially. And then he said that he might even move out of state with the children. And so I think it's understandable that I would be panicky about, what exactly he wanted done and why I was so into getting a parenting plan before they're born.
Okay, now let me just stop. This communication that you were having with Clayton, how was that communication? Through text, emails? How were you communicating with him?
Mainly through text.
And was he texting you back?
Yes, he was texting me back through about June 20th.
And prior to you becoming pregnant, was it your understanding that Clayton wanted to have a family?
Yes, it was.
Okay. And were you doing the things that you could do to inform him about the pregnancy and what was happening with it?
Yes, I was.
Okay.
Every step of the way.
What were those things that you were doing to inform Clayton?
Well, I invited Clayton and his family to my first sonogram with, he can't deny that I wasn't pregnant. I got into a specialist, a perinatologist, because I have epilepsy. And that was my first appointment. I know we have that in evidence as well, that he was invited. I even told his family if they wanted to come that I would change the date for them.
And what month are we talking about here? What months are we in when you're talking about these different things, the communication between you and Clayton?
July, but because that's when I found out I was pregnant with twins, but in June, that was when I went over to Clayton's house and took the pregnancy test in front of him.
Now, during this time when you first informed Clayton, was it clear to you whether Clayton believed that you were pregnant, or did he not believe you, or what was that conversation?
I know that what he wrote initially was basically that he believed it, and because that's why he got into the custody stuff, but really throughout this whole thing, I would say the theme has definitely been that he doesn't believe I'm pregnant, and I believe that's because he just doesn't want to take responsibility.
Okay. Now, you indicated there was a time that you went to his house. What was that in regard to?
I went to his house because he invited me over on, I believe it was June 17th. He invited me over saying he wanted to talk, and I agreed to go over to his house. And once I got there, I told him I would love to order a pregnancy test, and he said he already had one. So then I took the pregnancy test in front of him. I peed on the stick in front of him. It showed up positive pretty much right away, and he just threw away the stick and said he didn't need to see more. And then we talked about what would happen for us down the line, and he said he would, consider figuring out dating or whatever, because I don't think it's unreasonable to want to see if things can work with the father of your, what I now know as kids.
And let me just stop you. Now, were Clayton's intentions regarding the pregnancy and the unborn children ever clear at any point as far as what he wanted to do?
No.
Okay.
No,
so there was one, and when we say over, so is this over weeks or even months that we're talking?
Yes. Yes,
okay.
over months.
Okay. So was there a point when he wanted you to have an abortion?
Yes, there was.
Was there a point where he wanted to give the kids away for adoption?
Yes, there was, and all of that's in text messages.
Okay. Was there a point where then he didn't want anything to do with the kids and you have sole custody?
Yes.
Okay. And these are communications that you're having with Mr. Echard through text messages?
Yeah, those were through text.
What about emails?
Emails started later on, after we had the day after we had the conversation where I went to his house and took the pregnancy test. He and I were having a good conversation. Like, he messaged me in the morning. He said he wanted to be intimate that weekend, which I also have that text. And then an hour later, without me responding, he said God told him that we were not meant to be together, and he took that back. And then he blocked me, and I've pretty much been blocked since then.
Okay, so you would admit that you knew that Clayton had blocked you at some point. Is that right?
Yes, via text. Yes, I did.
Okay.
And he
But
told
then
me
would there be...
that's
Go ahead.
what I want to say is he told me to email him.
Okay. But were there times that even after he blocked you, he would then communicate with you through text?
Yes. He
Okay.
block and unblock.
So sometimes he would block you, but then he would unblock you?
Yes, and I think if you go to Exhibit 1, you can see some of the text messages that he sent to me.
Okay, let's take a look at Defense Exhibit 1, Your Honor, if I may. What is Exhibit 1, Your
Okay, well, it's not Exhibit 1 because obviously we have all of the things to exhibit, so you need to refer to the exhibit as it is on the exhibit worksheet, which I'm assuming is the first defense exhibit I have is 40.
Okay, Defense Exhibit 40.
I was only given 37, 38, but 39. I don't see any other exhibits
Titled
anymore.
Clayton, cruel and threatening text to me.
Your Honor, the exhibits that we had uploaded to the court, but I don't...
Were they provided to Mr. Echard?
I gave them to him on a flash drive right before the hearing.
Okay.
I did upload them, and it said it was successful. And that was on Friday, or Thursday.
Okay, Ms. Owens, thank you. The court has the exhibits. My issue is that Mr. Echard doesn't have the exhibit. So I guess, Mr.
I could show them on my computer, Your Honor.
How we believe that he would be able to view those.
Well, I have them on my computer, Your Honor. I gave him a USB with the exhibits on it prior to this hearing.
Okay. And prior to the hearing, like when you came into court today?
Yeah, I gave him the exhibits on a thumb drive. We had submitted the exhibits as the court wanted. I gave them to him electronically on a thumb drive, and I have them on my computer. I don't have them printed out.
Well, I guess I'm not sure how we're going to...
I have them right here on my computer.
I mean, I understand, but you're just going to show him them on your computer while you're talking about them? Is that what you're trying to do?
I'll let him access them with my computer, yeah.
Okay.
They're all in order. If you're saying it's Exhibit 40, then I guess we'll start there.
Okay, Mr. Echard?
I was just going to say, I mean, yeah, he gave me a thumb drive 20 minutes before we started this case, so I don't have my laptop with me. Nothing was submitted to me until today. I don't understand how, then I don't have any of it, so how can we bring it to light when it was never sent to me until 20 minutes before the case? And I don't have a computer to plug the flash drive into.
Your Honor, and if I may, there are no disclosure requirements in these types of cases. The rules of protective order procedure, injunction against harassment, there are no disclosure requirements. Despite that, again, I gave him a flash drive before court today. I have the exhibits on my computer. He has access to them.
Okay. Well, the logistics of that seem extremely difficult to me when we're at 4:30 already, so we're already an hour and a half into the hearing. And so if we're starting to look at exhibits, on your computer while you're trying to ask questions of her about him, I find that's going to be a bit of a difficult issue that I'm having with us trying to logistically all do that.
What does the court propose?
I mean,
again, I can show them my computer. The exhibits are here. I have them in order.
I almost think we need to reset for another, half hour of hearing where you can provide the exhibits, or he can have an opportunity to at least view the ones that you provided on your flash drive, and then we can discuss them as you're trying to admit those.
I mean, we could do that, Your Honor, but then I'd like to proceed with the rest of the case, just to use up this time, and then we could do that at another time if we need to.
I mean, that's fine. I'm just saying I think that exhibit issue, we need to try to resolve that. But if you have additional questions you want to ask her, that's fine.
Okay. So was there a conversation between you? Clayton was responding back to text messages that you had with him, correct?
Correct.
Okay. And same thing with emails during this time?
Yes, yeah. It wasn't like he stopped responding. And I also do have on MailTrack that Clayton opened every single one of the emails. I know he said he didn't, but I have proof he opened every one.
Okay. And the different exhibits that Clayton had admitted into evidence during his case, those were not the full text message conversations or emails between you and Clayton. Is that right?
Yes, that's right.
Okay. He was, in fact, texting you back and emailing you back.
Yes, that's correct.
And during the entire 5 months, or since I believe it's May that's indicated in the petition, has there been one time that Clayton has told you, please stop texting me, please stop emailing me, or something along those lines?
No.
In fact, you had asked Clayton whether it was okay if you went to the media regarding this. Is that right?
Correct.
And what did he say?
He said, if you can tell, I'm completely unbothered by it. And I went to the media the next day. And I never wanted to go to the media. I just wanted to make a parenting plan.
Okay. Was there a time that you had to hire an attorney?
Yes.
And what was that in regard to?
I thought it would be easier for the two of us to communicate to try to get that parenting plan with an attorney and for us to avoid having to go to court.
Okay. Was there a time that you tried to do paternity testing with Clayton?
Yes, absolutely. Clayton was very unresponsive to that. And I paid $750 in August to have the testing. I asked him to email the lab to schedule his time because I already had a time scheduled. And he never emailed the lab, so that's why it was canceled. He had, more than a week to email the lab to tell them a date and time, and he didn't do that.
How many times did you schedule paternity testing?
I paid for it once, but I was in communication with the lab, RavGen, which is the lab that Clayton chose, about scheduling countless times.
Okay. And did he ever do any paternity testing, or did you do any paternity testing?
Not until recently.
Okay. And during this, you and Clayton were texting or emailing back and forth regarding scheduling of the paternity testing?
Yes, exactly. Exactly. And I didn't actually have to provide prenatal paternity testing by the court. I was doing it for Clayton's sake. I could have waited until they're born.
Okay. And was that the main form of communication between you and Clayton?
100%. Everything was about paternity and pregnancy. That was it.
But was it through emails and text messages?
Correct.
That's how the two of you decided to communicate?
What was that?
That's how the two of you decided to communicate?
Yes, was primarily through email.
You said something, except for something.
Oh, except for in June when we met up. Other than that, it was just by texting and emailing.
All right. And it came to a point where Clayton wasn't agreeing to or he didn't want to create a family plan. Was that your understanding?
Yes, that was.
And what did you want from Clayton?
I wanted to create a parenting plan because I was so unsure about, since he'd given me so many different options for what was going to happen. I really wanted it nailed down before I give birth as to what custody was going to be. And I wanted to see if there would be a possibility for us to do joint custody, not to be dating, but just because I think that would be the best thing for the kids, to not have 100% and 100%, or just 100%, I'm sorry.
Okay. And that wasn't possible to do prior to hiring an attorney and then eventually filing a family law court case. Is that right?
Yes, that's right.
But you tried to make that happen. Is that right?
That's right. Yes. That was the
And
whole point.
that was the point of the communication via text message and emails. Is that right?
That was entirely the point.
Let's fact check this for a moment, shall we? So their encounter happened the night of May 20th. Now, on May 25th at 10 a.m., that's 4.5 days later, this is the text message that Laura sent to Clayton. I have one final thing to say that I think you might find important and have nothing to lose by sharing it with you. I have been in a dark place, as I said yesterday, and emotionally tortured since we hooked up because I felt like I didn't know how to bring this up to you. But at this point, I might as well. I have not been on birth control since what happened to me about 15 months ago. There hasn't been a reason since I said I hadn't done anything with anyone since then. Being sexually responsible was not on my radar after taking the gummy, and our clothes were coming off. When I went to the bathroom afterwards, some of your fluids were down there. In all honesty, I was planning on taking Plan B when I got home. But then, when you said you were going to church, I realized that you had a strong faith base as well, and questioned whether or not it was a sign that I should. Then, after we talked in the car, I felt even more so, like both of us had a deep belief in God, and like it was a sign I should just leave it up to Him and not buy it. Obviously, my mind has ping-ponged about this since then, and you were empathetic about me not bringing up anything that wasn't professional or friend-like, of which this situation is neither. I desperately wanted to figure out how to bring it up to you, and I thought that if we could just get together and talk openly, we could, but you didn't want that until the deal closed, which would be too late to take it. I wanted to ask you how you felt about it. I wanted to ask you how you felt about me taking it from a religious standpoint, but we didn't get a chance to. Clearly, I was factoring in things that you weren't, that made me panic and led me to a total breakdown in communication. My podcast had a fertility test kit as a sponsor, and so yes, I know I am fertile. At this point, from my overwhelming research on Plan B since Sunday, it's most effective 3 days after, but can still work 5 days out. Meaning this is the last day I could take it and have hope of it working if it needs to. If you have any thoughts on this, I'm open to hearing you out. If, and only if, you are kind and respectful, this has been extremely stressful on me. If I don't hear back from you, I'm not going to take Plan B. You're obviously free to think that I'm full of shit, but I'm not. I'll take it as a sign that you don't care what happens either way, and we'll just allow God's will, whatever that is, to be the determining factor. If I do test positive in a few weeks, though, there is 0% chance of it being anyone's but yours. I'd take any test to prove it. And at that point, any input from you won't matter. Clayton responds, take the Plan B. I support that. You have been really dismissive of my thoughts and feelings, and it's a bigger thing for me to think about now than it was when we originally happened. After all, I do want to have kids. I'm not basing what I'm doing off a 2-sentence response. Let me tell you how serious I am about all of this, since you think it was a plot to hold on to you. If you were to tell me that we could date if I admitted to making it up, as you called it before, I would tell you no can do. None of this is made up, and I am genuinely panicked. I cannot be more serious about this. Please be there for me. Thank you. I'm debating filing a police report. Please leave me alone. If you file a police report because A, you're trying to figure out about Plan B tonight, and B, I'm trying to figure out the status of my offers I made last night, and you won't even tell me if they are active or not, I will file a report with the AAR, which I am absolutely entitled to do, but won't do. Can you please simply help me figure out these issues? At least you said you would be part of the child's life if I'm pregnant and pay child support, which makes me feel better not taking it. Thank you. No, I would file a police report for harassment and would get a protection order. These messages alone would be enough to act on. These messages alone would be enough to enact one. There has not been a response to either offer, so in 2 hours they will be inactive. But again, I have texts trying to transfer you over to my brokerage and you declined. So you have no case against me for the AAR. I did my due diligence. I'm going to tell you exactly what happened because I've ridden this ride at the fair before. This was like a day or two after everything happened. She thought she hooked her one and he didn't respond. And then when they went to look at properties, he's like, whoa, 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 we made a mistake. That can't happen anymore. And she's like, no, no, no. I want you. I am going to have you. And he said no. And she started texting. And he wanted nothing to do with her. And he brushed her off. So she got more aggressive. And he kept brushing her off. And she got more manipulative in the way that she talked. And she used her offers on the properties as a way to keep connected with him so that she could say, keep asking about them. Well, tell me about them. And then when she would text incessantly and he wouldn't respond, then she starts threatening. Well, if you don't tell me, I'm going to do this. And if you don't tell me, I'm going to do that. And then it starts with, well, if I was, which it's like 3 days later. You don't know. That's not how this works. But she's, premonitioning that she might be. And then the next day, literally, she says she took a test. 5 days later, she took a test. That's not possible. That is not humanly possible. It's not. Like, there's scientific research. 8 to 10 days is the absolute earliest. Absolute. Yikes. She started scheming this the second he brushed her off that next morning. And I have no sympathy for her because as deep as she got herself in, she has had so many opportunities to get out, and instead, she's just taking it all down with her. I'm gonna just burn it all down. I'm away. And that's sad. And I know there's a lot of MH going on, but there's still enough sanity and intelligence in there. She knows what she's doing.
Okay. When did you file the family law case?
I believe it was August 1st.
And was there a point in time that you had to meet up with Clayton because of that case?
Yes.
And what did you need to do before that hearing?
Well, there were two things. I filed a motion where we were supposed to have a good faith consultation, and Clayton just didn't get back to me about that. And then we were supposed to get together before the early resolution conference to see if we could resolve the issues or resolve some of the issues without having to involve the court, I guess.
Is that, and when you received that information from the court regarding those things you needed to do before court, was it your understanding that you were supposed to meet up physically?
Yes, it absolutely was. It specifically said meet up, and he got the same information that I did.
Okay, so you were trying to meet up with him physically due to what the court had ordered.
Correct.
And you communicated that through text messages and emails.
Correct.
Okay. Now, did that meeting ever happen?
No, it did not.
Okay. Who was trying to make it happen?
I was the whole time.
Now, did you know what the penalty would be if you didn't meet up?
I was just going to say that I did not know what the penalty would be if we didn't meet up, and I didn't want to face any penalties or get in trouble with the court when I was trying to abide by the rules. Yeah, that was all I was trying to do.
And the family court case between you and Clayton, that's still active, right?
Correct.
You guys are both unrepresented, is that right?
Yeah, correct.
So you're forced to communicate with him regarding some of these issues at least, is that right?
Yes, absolutely.
Scheduling and meet and confer, things like that?
Yeah.
Now, there was a paternity test that was done, is that right?
Correct.
Okay, can you tell me a little bit about that?
Yeah, so I took the paternity test on I don't know, it was earlier this month, I believe, and it came back within the sample, there was little to no fetal DNA, which I was told specifically by the guy who heads this lab that the testing was ongoing, but that was not a conclusive test, and that he needed to have me do a retest. And so but after that, I said, is Clayton aware of this, that the testing results are not final? And he said, yes. And I do have that as an exhibit of him on the phone telling me that. But despite that, Clayton went public and said, we also have that exhibit as well, where Clayton boisterously said that there was little to no fetal DNA and I wasn't pregnant, which incited a tremendous amount of harassment towards me. And then after the sample...
Let me stop you really quick.
Oh, sorry.
Stop you really quick. Now, during the paternity testing, did you have to communicate back and forth with Clayton regarding results or what was going on?
I tried to, and he would not respond to me about it.
And is that when he went online?
What was that?
And is that when he went online to indicate what the results were?
Yes. Yeah, and that's what...
There were no results?
Yeah, there were no results. Testing was ongoing.
Is it still ongoing?
Yes, it is still ongoing. They just needed a sample that wasn't so diluted, and so they asked me to come back. I took a test a couple weeks ago. I think it's crazy that Clayton's acting like I somehow intercepted that sample in Tennessee. It ended up, I guess, getting stuck in Tennessee and getting delivered in 2 days instead of 1 to the lab, which meant the sample was no good. And then I went today and I gave blood again. But that's my third time giving blood. It's not my fault, at all.
Now, aside from texting or emailing Clayton regarding the pregnancy, the paternity test, this family court case, was there anything else that you had emailed or texted Clayton?
Not a single thing, and he knows that as well.
What about the post online?
Well, that was related to the paternity. I did message him after asking him to take that off when I started getting people telling me to kill myself, and people were posting terrible reviews on my podcast. I was getting horrible messages on my Instagram. I had to deactivate that. And I begged him, please take this down. The results are not back. Here's Brett from Rabgen explaining that that the test results aren't back. You can't be posting this kind of stuff and inciting harassment against me.
And is that because you're understanding Clayton's fans or Clayton's followers were harassing you online?
Yes, and they were naming me in his comments and giving my handle out, my Instagram handle out.
Okay, and those were because of Clayton's posts?
Entirely because of Clayton's post. And then on Reddit, I mean, I can't even go into the what people have said about me on Reddit as a result of his post, which, I'm clearly pregnant, and I, will do anything to prove the paternity. And so it's just all of this information that he's put out there that's false has been so upsetting to me.
But you had reached out to Clayton regarding those posts and asked him to take it down after you were receiving these harassing emails or messages online?
Correct.
Okay. Now, was there a time that you had reached out to somebody who Clayton was going to speak, somewhere where he was going to speak?
Yes, I did.
And what
5
was
minutes.
that?
5 minutes.
And what was that?
I contacted them because I was feeling suicidal as a result of Clayton's action towards me, and I'm sure, I'm hormonal because of the pregnancy and not knowing, what the plan is going to be going forward, but I felt that it's strongly in my heart this was not to harass Clayton. I just felt that if Clayton was the kind of person who would not respond to me knowing I was pregnant with his kids, then there's no way Clayton would respond to somebody else who reached out to him saying they were in need and that they were suicidal.
Okay, let me just stop you. We have about 3 minutes.
Okay.
So, Clayton had brought up instances of other cases that you're involved with other individuals. Is the current case that you're involved with Clayton with similar to any of the other cases that he's brought up in his exhibit?
No.
Okay. And that's an ongoing case, is that right?
Correct. It's been going on for 2 years, and that attorney dropped out of the case. There was never an ultrasound presented to him. I was too early on, but the pregnancy was proven to him by a nurse practitioner, by tons of medical results. I can prove that all day long.
Now, in the communication that you had with Clayton, were you ever trying to threaten him or harass him or annoy him in any way?
Absolutely not. Absolutely not. I mean, I would think he would want a parenting plan as well.
Okay. Your intent during this time was essentially to get the parenting plan then and get this all figured out before the unborn children are born.
Yes, because I'm panicked about having twins and not knowing if he's even going to, he specifically put on that he didn't want to even be on the birth certificate and didn't want to give them his last name. So.
No further questions, Your Honor.
All right. So I'll go ahead and stop here, and then we'll pick up, because you may have some questions still for her about the exhibits. If we're going to pick up again, I'm assuming that there may be some exhibits that you want to.
Oh, yeah. When I said no further questions, I just meant.
Yeah, for now. Yeah, I understood. That's right. We're going to take a break now, and then, Mr. Echard, you have the exhibits now in your possession. Is that correct? Obviously not.
Flash drives.
So you have the flash drive, so you can do that to see the exhibits, correct?
Yes. Are we going to do this today? I would like to come to a conclusion today as far as how we're going to proceed.
Well, I don't think that we're going to be able to finish it today, because we're already at our time, past our time, really, for doing the trial, and we haven't done their exhibits yet. And so I want to give them an opportunity to do their exhibits, but I can try to find another date to see if we can come back and finish up the hearing.
I have the ability to ask questions to her.
You will once she gets done with her testimony, so I'm going to give them still time to do some of their exhibits and questions, but then you'll be able to cross-examine her.
Okay. Great. Is there a way to request for her to cease conversation via all avenues until this next hearing?
I'm not sure I don't know if there's a legal method for that.
I would just ask or make a request that she stop sending me messages. I don't think that it's maybe it's just, I don't think it's worthwhile. It's not necessary considering we're under in a court case. I don't know if I can request that, but I would like to request that so that we can avoid having conversations outside the court anyways.
Well, Your Honor, they have an active family court case right now, and this type of hearing specifically is for what Mr. Echard is asking for. That's why we're doing this hearing, and I don't think the court can order that my client, not saying that she would, but I'm just indicating that I don't think that this court can order her not to have any contact with them at this point. They have a family law case together. We actually have another protective order hearing tomorrow. I don't think the court has the power to do that, and I don't think that that request should be granted.
Yeah, I don't know that I can do that. If I can do either the 26th, which is Thursday at 11, or I can do the 2nd at 11.
26th of this week, correct?
Correct.
Your Honor, I'd be requesting the 2nd, if that's possible. I do have a criminal trial at 8:30 in the morning on the 26th that should be going at least all morning. That's out of the Phoenix Municipal Court.
It's November 2nd at 11 work for everybody then?
I would request the 26th. I don't want to drag this out longer than it needs to go. So if it were, if I may, I would like to ask for the 26th so that we can forward in a quicker manner.
And I understand. I just think if he has a court conflict, I'm not sure of an aesthetic. I know he has a court conflict.
Is it possible, like, if the court has time in the afternoon, like 3 o'clock on that Thursday night?
I don't have another injunction trial that afternoon.
I guess my question is would your court case not have an end time? And if so, what is that time?
Well, usually, just like in a criminal trial, it's usually 3 hours. So, it'd be kind of like this. So, the court's saying 11. Is that what you said, Your Honor, like 11 or 11:30? And
11 is when I can do it.
yeah, driving from Phoenix to here, that's going to be a minimum of 30 minutes. I wouldn't be able to finish that.
Driving from Phoenix.
But even assuming they start at 8:30?
Okay, so it's supposed to, I'm not trying to be difficult. So you're saying it's supposed to start at 8:30?
That's correct.
And it's scheduled for a 3-hour time. This had a time limit on it. So it's scheduled for 3 hours?
Yes.
Okay. Oh.
Right, so November 2nd at 11. We're going to pick up with the exhibits, defense exhibits, and then we'll allow Mr. Echard to do cross-examination, and then Mr. Echard, you would have the opportunity to present any rebuttal testimony if you felt that was needed.
Thank you, Your Honor.
All right, thanks, everyone.
Thank you.
Thank you. We'll get an email for that, or just confirming? 11? Okay. Thank you. I take these exhibits with me, or?
You can take your copies of them. We have the court's exhibits, so.
Okay.
USB is the same one.
Okay. You guys got mine? Too.
I did. I've been through the court case, yes.
Okay.
Okay, yes, send it on. And I apologize. I didn't.
So all of this happened before the video that was in the in the number 1, whatever. Yeah. You know what I'm trying to say. Brain's not working very good. I know that's a typo, but that's epic. She's getting an oral protection. That's awesome. Because she feels threatened. She feels like that's awesome. She feels like he's he and his followers online are all gonna say mean things about her and hurt her feelings. They're gonna make her feelings feel bad. And she's gonna feel bad. Fucking grow up. I would like for her to come live a day in my life. Let's see how that works for you. Let's see how you do with that. It'll teach you what a lot of those words mean that you don't seem to know. Jeez. It just blows my mind. So after the last hearing, no, before the last, okay, so we're still before the last hearing that I showed you. Now, Clayton gets this and he's like, WTF? Really? Like, an order of protection can really hurt you when it stays on your record. I mean, it comes up in background checks and everything else. It's not like it's no big deal and nobody sees it. It's not just a piece of paper. I mean, it's a piece of paper when you need it for protection, but it hangs over your head and it causes issues. So, somebody say scones? Where's scones? I want scones. I love scones. Orange scones, orange cranberry. Oh. Anyways, so I'm sure he freaked out when he got this. So he's contesting it. And that's what this hearing is. And the audio is absolute freaking garbage. Horrible. I enhanced it the best I could. I'm not an audio engineer, but I just made it louder and louder and louder and louder.
Owens and Clayton Echard, case FC 2023-052771. For Ms. Owens, counsel, do you want to make your appearance?
Yes, Your Honor. Attorney Joshua Lopez representing the plaintiff in this matter, Laura Owens, who's present before the court, sitting to my right.
Thank you. Nobody has to stand up again, okay?
Oh.
Not even you, all right? So, Ms. Owens, please tell me your name and date of birth.
Laura Owens, 5/14/1990.
Thank you. Mr. Echard, sir, tell me your name and date of birth.
Clayton Echard, 4/29/93.
Echard, thank you. All right, I'm going to administer the oath. Do you both solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay. I'm just before we start, there was a motion to allow plaintiff to appear by phone. I denied it last night. And then
Where is that coming from? What did I believe? Because there's been like 3 or 4 comments about that. I'm not really sure what. I believe in evidence, not words. Like I like writing, not let me tell you a story, because if I'm telling you a story, it's probably not completely true.
there's another motion from the plaintiff
Things get
this morning.
changed. Memory.
Oh, it says attorney for defendant, but that's a typo, right?
That is a typo, Your Honor, and it's my understanding, at the same time I was unaware, yesterday there was the hearing, and we had a hearing yesterday. Mr. Echard was the petitioner in that matter in an injunction against harassment matter that was available for individuals to access that hearing online via the court's website. It's my understanding in order of protection hearings that online access is not available.
That's what I was told by staff.
Okay.
So I'm just going to deny it as moot.
No problem.
Your second motion,
Okay,
which
thank
is
you.
to request that the hearing be closed from the public. Well, that's a non-starter pretty much.
Okay.
That's really rare.
I understand.
How do you go to the public, announce everything, put your name out there, and then say, okay, but you can't know anything else about it? It doesn't work that way. If you're going to put it out there, it's out there. This stuff is public record already. Like, you don't get to take and say, oh, but I don't want mine to be. That's not how this works.
And, I mean, these public hearings. But at the same time, or that the hearing be closed from watching online. I'm told by my staff that we don't do that. It's just not set up to do that today.
Okay, thank you.
You're welcome. So that's denied as well. Anyway, we'll file your, we'll just give this to you so you can file it after the hearing. there are real kind of unusual rules attached to orders of protection. So. All right, I've read the petition. Folks, the way I run all of this is just, where do you go? Is he down there?
Yeah, he's plugging in.
All right, the way I run all of my hearings on orders of protection is they give us a time slot of 45 minutes. So I usually I always start out by saying to people, each side will get 20 minutes to put on their entire case, and that includes me looking at any exhibits you might have. And the way the sequence of events will be that the plaintiff gets to go first. I want to hear her view of the matter, her story, and she can include her exhibits, as to supplement what she's saying. And then after plaintiff is done testifying, then I'm going to invite the defendant, Mr. Echard, to ask questions of the plaintiff if you have any. You don't have to have any, and I don't take any inference from whether you have them or not. So once that process is done, then I'm going to invite the defendant, Mr. Echard, to tell me what happened from his point of view. And we'll consider the exhibits that he has. And then I'm going to invite counsel for Ms. Owens to ask Mr. Echard any questions if he has any. Again, you don't have to have any. And then finally, here's the other one. And then finally, I'll give Ms. Owens an opportunity to sum up or to do a rebuttal to what Mr. Echard said. Okay? So it's a
event that
Shit. God, I hate this thing. He really tells them like exactly what they're gonna do. Like, this is how it's gonna go. You get this amount of time, you get this amount of time, and that's it. Like, follow the rules. Sorry, I hit the
closed
button.
from
I
the
always hit the
public.
button.
Well, that's you don't have to have any, and I don't take any. Probably will not allow more time. So,
I think they used like
with
the
that
original
said,
first webcam ever
I will
made.
invite Ms. Owens to put on her case. You've got 20 minutes, Mr. Lopez.
And Your Honor, can I do a brief opening?
Of course.
Okay. Let me just start my timer. The evidence will show that Laura and Clayton had a romantic relationship back in May of 2023. Laura became pregnant with Clayton's twins. They are due in February of 2024. Since that time, Clayton has disputed that Laura is actually pregnant or that he is the father of their unborn children. Clayton has made it known to Laura that he hates her, and this has caused him to post harassing information about Laura to his hundreds of thousands of followers online. The evidence will show that Clayton has committed domestic violence within the meaning of the statute in multiple ways within the past year, and that there is a likelihood that this unlawful conduct will continue into the future if this order of protection does not remain in effect. We will request at the end of this hearing that it do remain in effect. Thank you.
Oh, you're welcome. Okay. Start by establishing the relationship and then including whether they've ever lived together, and then take it from there.
Okay. Thank you, Your Honor.
Sure.
Laura, how do you know Clayton?
He was my realtor to start with, and then we were intimate one night in May of this year.
And when you say intimate, is that a sexual relationship that you had with Mr. Echard?
Yes.
Where was that?
I think it's like
That was at his house.
And is his house located in Scottsdale?
Yes, it is.
Here in Arizona?
Yes.
And within Maricopa County?
Yes.
All right. And after that encounter with Clayton, was that back in May of 2023?
Yes, it was.
And what happened from then?
From then, well, we had a real estate transaction that went wrong. He ended up getting in trouble with the ADRE for not submitting my offers. But that happened a few months later. After that, on June 1st, I found out that I was pregnant, and I figured he probably wouldn't believe it. So I went to urgent care, to Banner Urgent Care, and had it confirmed there by a doctor, and then I told him.
Okay. And was there anybody else other than Clayton that these unborn children could belong to?
No, I hadn't been intimate with anyone else since March of 2022. I was violently assaulted and raped, and I had hang-ups for a long time.
Okay. Now, since then, what has your relationship been with Clayton moving forward?
Well, I've tried to get Clayton to accept responsibility and figure out a parenting plan with me. but that's really been it. It's not like it's been a dating relationship. And yeah, I mean, we've communicated via email for the most part.
Okay, and has he posted anything online or sent you communications indicating his hatred toward you?
Yes, he has.
Please avoid the leading questions.
Has he sent communication to you?
Yes.
Okay, and what is that in regard to?
That has been in regard to how he feels about me, and how he hates me, and that doing this to him, meaning making him be a father, would be his idea of being in a living hell. He's told me he wanted 100% custody, despite also claiming I was.
Oh my God, it hurts my brain. It hurts my brain. Like, this is a normal, like, Saturday night argument. Like, not even a bad one. What the hell is the problem? Like, move on with your life. It is not a big deal.
I wasn't pregnant, but then he said I should take 100% custody. He also said that when we thought it was just one baby, would be put up for adoption, and then he said that he wanted me to have an abortion.
Okay, so I'd like you to turn to Exhibit 1. What is that?
These are text messages from Clayton to me, just threatening, really, saying that, you know, I needed to back off on, basically on saying I was pregnant, and then he referred to, yeah, he hates me. He demanded he talk to my mom, which he did, and then he said people like me needed to be held accountable if I was lying about being pregnant, which I clearly was not. He said that when his mind is rooted in anger, it doesn't sway, which I took as threatening, and then we have about him saying about an abortion or adoption.
No, these text messages, are those from Clayton to you?
Yes.
And were those within the past year?
Yes, they were.
Since May of 2023?
Yes.
When you became pregnant?
Yes.
Okay. What happened on 9/21/2023, as you stated in your petition?
That was when Clayton posted on his social media, that had a big following, that I had 2 identical cases, and tried to present me in a very false light to his followers.
I'm sorry. What in that statement is wrong? That is all, it was all true. It happened. Like, this isn't something that she denies. She had to. Thank you, Donna. Welcome. She had 2 identical cases. Yep. Nailed it. Like, you can't get mad at someone for posting the truth about you. Like, if you don't want to be called a hoe, don't be a hoe. And I'm not saying she's a hoe. I'm just saying in general, like, if you don't want the reputation, don't do what you're doing. I think he has a couple 100,000. It's not like he's raking in 10 million people. He's not telling the whole world. And of those, how many even know who she is? 5?
Did Clayton ever indicate to you that he wanted you to prove to him that you were pregnant?
Yes.
And did you take steps to do that?
Yes, I did. I went over to his house and took a test he bought in front of him, and I peed on a stick in front of him.
Okay. Were there other things that you did to show Clayton that you were in fact pregnant?
Yes, I invited Clayton and his family to go to my first ultrasound with me, which his family didn't respond and he didn't go. And I asked about taking a prenatal paternity test, and this has been an issue with him and I going back and forth as to who to take the paternity test, but I proved that I paid for it in August, and he did not show up for his portion. He didn't schedule it.
So did you ever send him a video showing him that you in fact were pregnant?
Yes, I did.
Okay, I'd like to turn the court to Exhibit 17, and Your Honor, I'd like to admit Exhibit 1 into evidence.
Any objection to Exhibit 1, the text messages?
Okay, quick question, then I'm going to stop talking because it's going to take forever and I want to go to bed. if he wasn't liked during his season and he didn't get the opportunities everybody else did, do you think that going through this experience and him being the victim humbled him enough that it made him likable? Or, I mean, that it will change it and propel him more into the spotlight once this is resolved? That's just my own curiosity on how this will affect that.
Yes. So I'm trying to pull it up here. I got it sent via email. I would just simply object on the basis that I think there's missing context. It's a text message that where no context is provided, and considering the circumstances that I do not believe her to be pregnant, I believe that I'm the one being harassed. So I don't believe that I ever have harassed her.
Okay. I think the context can be shown when it's your turn. You can fill that in, okay? So overruled, I'll admit Exhibit 1. What's the next one?
Your Honor, I'd like to present, and I'm skipping around here because of the limitation of time, but Exhibit 17, Your Honor.
Okay.
And I can bring it's a video, I can bring it up to
what?
The court doesn't have a video in hand, so that would be it's going to be the last exhibit on the list, which will be Exhibit 52.
You don't have a video in hand?
No, I don't have a video.
Did you give her a thumb drive?
I did give up my thumb drive yesterday, Your Honor.
Okay, so if it's in there, it'll be Exhibit 52 because our exhibits are numbered differently than how you guys submitted them. So it'll just be Exhibit 52.
Did you give Mr. Echard a copy of the thumb drive?
I did, Your Honor.
Good, okay. All right. Tell us what's on it first, so Mr. Echard just doesn't land in his lap.
No
problem. And he has a chance to object.
Okay.
So what is this? Lay a foundation for this video.
Okay.
You've already talked about the fact that that she offered to all the stuff that she did to show Mr. Echard that she really was pregnant, paternity test. She said he didn't show up for it, all that stuff. So what is this a video of? Is it him or is it somebody else on the video?
Who is the video of Ms. Owens?
It's of me showing that I was pregnant. It was a video of me turning to each side to show that I was pregnant.
And did you send that video to anyone else except for Mr. Echard?
The video on 9/20.
The video that you just disclosed regarding your pregnant stomach?
No.
Okay. And did you ever find any harassing information regarding that video online after you sent it to Mr. Echard?
I think you're referring to a different exhibit, actually. The Halloween one?
Yeah.
Because that was one was a video, one was a photo.
Get your shit together.
Did you ever send?
Yes,
this had an image. So exhibit 11.
Not likely.
Is
it would take a lot.
A screen grab of a Reddit thread saying how to win the scariest costume contest, and it's me turned showing my stomach, and it's me holding a sonogram of our son that only he had possession of. So he clearly made this up of me, which obviously was offensive.
I know no one else had it because I made it.
11.
Yeah.
Our exhibit 11. That is a picture that you had sent to Mr. Echard.
Yes.
You did not send that to anyone else, or did you?
This was sent to somebody in the press, but they weren't supposed to publish it. But the sonogram that I'm supposedly holding was.
Why would you send it to someone in the press? Like, why? You can't send something and say, "Oh, but don't publish that." I mean, yes, you can, but you have to actually be someone. Like, you can't be a nobody like her. And okay. So what you have to remember is Clayton is number at least 4. 4 from the lawsuits we know of. So this has happened previously with other people in various forms. It's kind of like an evolving art. Like, do you remember when you watched me like a year ago and I really sucked? And, a year later, I've done a lot of stuff and I suck a little less. And today I'm having a really bad night, but overall, in general, people evolve over time, and she has evolved her craft and she is changing it up. This is 2 before douche canoe. 2 before. This lawyer actually withdraws after the next hearing we're going to watch.
That was not sent to
5 hearings,
anyone
I
else
think.
other than him.
Okay. So was he the only one that would have been
No.
able to post that?
Yes, he was.
Okay. Your Honor, Exhibit 11, I'd like to admit into evidence.
Any objection?
That's the one with the picture right there. Just want to
Yeah.
be sure you can admit that.
Okay, thank you. Exhibit 11 is admitted.
Yes, in this
Okay.
case.
Moving forward, let's talk about
Yeah, it's worth noting. This is
Well,
what
tell
she
me,
was
what channel,
what she was upset about in the email she wrote to me is that I didn't specifically note, hey guys, look, this is Laura showing up to court the day after the video that I showed in part 1, where she had her belly up to her boobs, and she showed up in court the next day, and that's to prove that she's really pregnant because she showed up in court looking pregnant. But then it went away.
did this have any connection to her, or besides, her image, her face is not shown? So does this identify her in any way?
So it does because of his image. People on Reddit, there have been just thousands of people who have posted on this about me, and so this was just another post about me, but I've been identified on Reddit. And this image was shown. Somebody had gotten this image on Reddit, and it was with my face. They just took it out for the purpose of this post.
Okay.
Now, is it your understanding that Clayton had posted online regarding misinformation regarding your pregnancy?
Yes.
Okay. And what happened after that?
So Clayton posted a video on 10/6 on his Instagram that I believe we have, and it was him saying that there had been test results back from the lab, from the prenatal paternity test, saying that the results came back and there was little to no fetal DNA, and that he wasn't the father, and like a great way to start off the week.
Now,
that's the one we watched a few minutes ago.
Was the paternity test over at that point?
No, it was not. It still is not over.
Is it ongoing?
It's ongoing, and that's what I was told by the lab. They said that they got a diluted sample and that they needed me to submit a new sample, that there was little to no fetal DNA within that sample, but obviously not that there wasn't within me. It was some issue with transit, so they had me come back and take another test.
After Clayton made that.
We're all talking about this, but really stop for a minute and put yourself in her position. She's sitting there pulling all this together. I'm sure most of you have been in a courthouse at some point in time or another in your lives. Do they give you that instant on guard feeling when you walk in? You're just, I don't know, maybe it's just my anxiety, but I'm always just a little bit more nervous when I'm a little more proper and you're sitting there in front of a judge who's, asking you all these questions about all these things. She is all in.
And I'm really upset.
And who I got pregnant by. The pregnancies are verified. That's we admitted that into evidence as well.
Let me just stop you. Are you pregnant?
Yes.
Okay. Can you stand up for the court?
Yes.
Oh.
Now,
I'll take her.
I'm sorry. If you're pregnant, if you're showing somebody something Can you stand up for the court? Aren't you going to stand up and go like this? Like move your arms out of it. Like, look. Not like stand like this and cover it up. Sorry, you probably couldn't hear me very well. Like, aren't you going to be like, look at this and like all around? Not like arms in front of you, covering it up like all. Really? Hold on. Let me go back a second.
These two identical allegations.
Do you have any questions?
It just jumps. It doesn't let you stop. And you're like, oh, that's where I want to
These
stop. And it
two
won't stop.
identical allegations. I've never had a paternity case against somebody. I do have 2 orders of protection against 2 men who I.
But this is after it, isn't it? Oh my gosh. Could you not jump 20 seconds at a time? That would be great.
Parents and my brother-in-law and my sister acting like I'm crazy and like I have, quote, done this before when I wanted to address that because I know that he's going to address that these 2 identical allegations. I've never had a paternity case against somebody. I do have 2 orders of protection against 2 men who I got pregnant by. The pregnancies are verified. That's we admitted that into evidence as well.
Let me just stop you. Are you pregnant?
Yes.
Okay, can you stand up for the court?
Yes.
She keeps her hands on the desk and stands up. Like, I'd be flipping my shirt up, like, look, motherfuckers, like, this is it. That causes me pause. You know, that Psych 101 from college.
No.
Raising red flags.
I'll take your word for it.
I'm done.
Everybody seems to be assuming that. All right, you're you're out of time pretty much.
Okay,
You
can I
shouldn't
just ask?
assume.
One,
You know what happens when you assume?
No.
Okay.
Mr. Echard, do you have any questions for the plaintiff? You don't have to have any.
I do, actually.
You go ahead.
Yes.
Questions? Okay, don't argue with it though. Okay.
Yes. Ms. Owens, did you send me via email an ultrasound video?
Yes.
You did? Okay. That was sent by you, okay. Did you also send me an ultrasound photo via email?
Yes, I did.
You did? Okay.
But the video was not the video I was trying to attach for you.
So the video that I received,
Yes.
you sent that video?
Yes. That's my understanding.
You
said that you got the video, so.
Okay. I will show the video when it's my time to present that I'm speaking of. And the ultrasound picture that you sent me, or you had your lawyer show me, do you have an ultrasound report that comes with that?
Yes.
You do. Why have you not presented that as evidence?
Because
Objection, Your Honor. That sounds like health information that she doesn't have to disclose her health information to the court.
Overruled. You can answer.
I offered you
Yes,
a
she does.
HIPAA release to get my health information as recently as I think last week, and you didn't get back to me.
But you had it right there. You have the paper to show him.
That's false. Did I ask you multiple times early on to take a paternity test?
Yes, as did I. I asked you the same thing.
And did you place stipulations upon that I had to date you exclusively in order for you to take that test?
For 2 weeks in order to take it early. Otherwise, I would just wait until the birth of the children as was required of me by law. It was if you wanted to know early.
Then she's obviously not picky. I mean, she's willing to, like, extort people into dating her. I think we should put together a fund and get her a mail order groom that she can go have, put her back in the casita, and then she'll leave everybody else alone. Like, if you fulfill the need, then you cut off the problem. End story. That's all she needs.
So you're agreeing you would only take the test if I were to date you exclusively?
I think you're mischaracterizing what it was. It was so we could make a decision as to whether or not to even proceed with the pregnancy.
This is his time.
Yeah.
So I'm going to ask you to just answer his question, yes or no, if you can. If you're unable to, just say, I'm unable to answer it.
Okay.
So, Mr. Echard, ask the question again.
Yes. Did you state to me that you would only take or do a paternity test if I were to date you exclusively?
At what point?
Within the first two months?
Yes.
You did state that?
Yeah.
Okay. Last question. Would you agree that only oral sex was performed the night that we were intimate?
I would not agree with that.
What would you say happened?
I explained it to you in an email. You said you were insanely high that night and clearly do not have full recollection of what happened. Mm-hmm. Do you want me to explain it to the court in detail, or?
I'm okay with that. You explaining what happened, yes.
Okay.
I remember everything, but yes, go ahead.
I remember everything as well. You were asking me when we were naked and...
Just a moment. Did you have a legal objection?
Yeah, I'm going to object at this point. I think this is a little bit outside of the scope of what this hearing is in regard to this specific. I think that I've laid enough foundation. I think I've presented enough evidence to show that there was a romantic relationship. Mr. Echard actually, it sounds like he's acknowledging that by his question. Getting into the details of
You define romantic?
what sounds to be potentially sexual intercourse on the date of this, of what happened on that night, I don't think that needs to be presented in testimony to the court.
Well, sir, since you're here on a paternity case, you kind of need to talk about the fact that there was no way she could get pregnant from that. So if there's a way, then you need to talk about it and put it on the record.
I think to some degree I sympathize with that. Mr. Echard, to go step by step about, like, who took whose shirt off first kind of thing is really kind of beside the point. It's salacious, and it's an invasion of both of your rights of privacy.
Okay.
But what I would think is legitimate is to say, did we have sexual intercourse, where, a person would become pregnant. You can ask something like that.
Yeah, and I guess I'll ask that directly.
The definition of romantic is conducive to or characterized by the expression of love. But it doesn't say that it has to be a mutual expression of love. So that's kind of interesting.
We have sexual intercourse that night.
Yes.
All right. So you're finished with your question?
I am.
Okay. Then I'd like to hear what you have to say about everything they presented. Try to focus on what they presented. Everything else is beside the point, because I'm just focusing on what they put into evidence, not their allegations, but what's in evidence.
Sure. So I would just like to state again, I guess I can address first the video that you saw. I had mentioned that I had been tortured for the last 5 months. The reason, and I did state that
Very true, Carol.
the results of the first round of the prenatal paternity test came back and it showed little to no fetal DNA, which is in fact what was stated to me. This led me, aligned with what I believed, that she is not in fact pregnant with 5 months pregnant with my twins, which I have questioned the entirety of this time. I have not been able to receive any evidence proving that she's 5 months pregnant with twins. When I've requested it, she has not given it to me. We did an early resolution conference last week. The mediator asked for her to make a phone call to the facility. I will present this evidence, the ultrasound photo, to make a call and confirm that she did in fact do that test there. She was not willing to do so. She has not allowed me to speak to any of the doctors that have administered these ultrasounds, which of course has caused me to question her for that very reason, that it should be a very simple thing to do. She states that she invited me, my family and I, to an ultrasound. For one, my parents live in Missouri. Two, they don't believe her. And three...
Objection, Your Honor. Speculation.
Well, they
overruled.
don't.
Go ahead.
Yeah, they don't.
Go ahead.
And beyond that, I actually asked to... I did not want to go in person and see her, but I did ask for her to FaceTime me while she was there. She then canceled that ultrasound and stating that she wanted her sister to be there to see the ultrasound for the first time. So, and then when it was time to reschedule the ultrasound, she then stated, I feel unsafe, and therefore I do not want you to know when I'm doing the next ultrasound because I'm afraid for my safety. So she then did not tell me when she did the next ultrasound, and that, in my opinion...
And there has been zero evidence presented that she had a reason to fear for her safety, which pisses me off to no end. If you're legitimately in danger, go for it. But don't fabricate that shit, because you're going to hurt someone else that needs it. And don't lie about that shit.
It was her way of getting out of being able to FaceTime me while she was there with the doctor. So with all of the times, all she has presented to claim that she's pregnant is a visual image of her stomach and a positive HCG test, which that is not enough evidence to prove a viable pregnancy. Under normal circumstances, HCG, yes, that hormone is present whenever an individual is pregnant, but that can be manipulated. The proof that she states that she submitted in prior cases was the same positive HCG test. That was it. There was never an ultrasound or report or a OBGYN or a doctor willing to corroborate her story. And that has been the case as well. She mentions in the previous cases that they are not exact. And I would state that, sure, they're not exact if we're going to be very specific with our words. But what I can state is she's claiming that she's 5 months pregnant with my twins after we engaged in not sexual intercourse, but oral sex. She's claiming that we engaged in sexual intercourse. I deny that. She performed oral sex on me. There was no penetration. But after one time, she's claiming she's pregnant with twins. In her previous court case, which is publicly accessible, and I accessed the documents, and that's one of the exhibits that I would like to show, she claimed that she became pregnant from an individual after they engaged in sexual intercourse, and she became pregnant with twins. In the court case that I have here as evidence, there's an ultrasound that was sent to the defendant in which she states in the text message that she's pregnant with twins. So considering all of the evidence, I believe that she has engaged in repeated patterns of behavior. And with all of that being said, I do not believe that she's in fact 5 months pregnant with my twins, because I have not been able to receive any evidence of proof that that is in fact the case. She would need to have an ultrasound report and a OBGYN or doctor willing to back up those claims, and she has not presented that.
Okay.
So that is my rebuttal to any of that. As far as the harassing messages, I don't believe I'm harassing her. I never did. I stated that if she's lying, she'll be held accountable, and I don't believe that's a threat. She attacked me as a public figure. I have a large following online. I was on reality television, and she decided to open a court case against me. This family court case. She then decided to leak this to the Sun anonymously so she could protect her name. But
objection, Your Honor. Speculation.
Yeah. How do you know that? Tell me. You just said she decided to leak this to the Sun.
Yes.
What's the Sun? Is that like a tabloid?
The Sun is a tabloid, and I have. I did not submit the evidence today, but I do have emails and text messages of her. Well, actually, I did actually submit something. She did threaten to go public. Yes, I do actually have an exhibit in here. Oh. She threatened multiple times to go public.
Oh, okay. So that would be relevant.
And so I can show that. And
well, why don't we see it?
Do you want to see it now?
I think it's important.
It is.
I wonder if he had an attorney from this point, if they could have quashed everything. before it got
Refer
to
to
the
your
court.
exhibit number.
This is exhibit 16. I'm going to slide this up on the screen here.
Exhibit 6,
So
they've been renumbered.
Yeah, he submitted a couple exhibits that were numbered the same, and so it's a little,
Right.
yeah.
So this is his exhibit 16, but what exhibit would this be on? You don't know? Hold on. The problem is that there are a lot of exhibits and we have little time to put them together, so let me find
So messed up.
your exhibits. Oh my God, quite a few.
Yeah.
So what's your title on this one?
Threat to go public and shame me. Exhibit
That's what it
16.
says?
Yes.
Okay. Got it.
34.
34 and 30, which one, 34 or 35 do I, well, he doesn't know.
I don't think he understood like the
Connect
level of
commission.
cray cray.
Let's see.
Yeah, right click on it on your computer.
Oh,
I'm thinking so.
oh, there.
Yeah. Seriously, like
I
top
don't want a
2,
7-day
3.
trial. Go ahead. No, just go. Won't let me. Okay, but I can, obviously.
Jay, that
do
link
this.
might be expired.
So let's see. So why don't you lay a foundation for this?
Yes.
Oh, it's right up there, too.
Yes.
Why don't you lay a foundation, date, how did you find out about it? Where did you download this image?
Yes.
What day? Give me some context.
Let me see if I can scroll up here. So this is,
I can see it on my screen.
yeah, it should say the date. I can't see the date from here. But it should be in the top right. So she says in this
It
email.
just says,
I mean, women have been fake claiming to be pregnant or actually getting themselves knocked up when the guy didn't want it for decades. Decades. That's why I'm on this earth. However, like, why is the court allowing this? That blows my mind. Like, this, how is this? There's no babies. There's no babies. Why are we wasting all this time? We could do this after the babies are born, when we can touch them and feel them and make sure they're real. And then everything's okay. Like, I don't understand. Like, there's no newborn that you're going to take him away from his mother, like, the day he's born and give him to his father and then back to his mother. Like, we're not going to start our time-sharing plan day one when he's born. So, I mean, we can work it out after they're born. I really think that law needs to be changed. I feel very passionately about that because this absolutely blows my mind. Thank you so much. Do you know which statute it was? The one I looked up, I only saw 2 requirements. I would love to look that up if you would send me the link.
yesterday, so that's not helpful.
Okay, in this case, this was sent within the last month. As far as the exact date, I don't have it, but it was
Within the last month?
Yes, because this is when probably about a month and a half ago.
Okay.
So she states in here, if you want option A, I will not post this. Option A dealt with a dating stipulation. She said, I'm just looking for support because this would probably be over a long time. And so then she states here that she's going to put up a post, the caption, surprise, can't wait for the arrival of these 2 next Valentine's Day. How she knew she was going to deliver on February 14th is beyond me. But she stated on a more serious note.
I can read that. I'm just trying to get context. You've already laid the foundation.
Onesies.
And where did you get this?
This is a screenshot from an email she sent me.
I got you. Okay. So.
The judge is old school. You don't expect
do you have any
people to not
objection to me considering this exhibit?
be truthful.
No objection, Your Honor.
Okay, then exhibit 34 and 35. Have you seen 35?
35.
Let's look at 35.
If it's the one, I know it's the one of the post with the 2.
Echard twins coming February 24.
Yes.
All right.
No objection.
Okay, so both of those will be admitted. Okay, I can read them.
Sorry,
if that's okay.
Yeah.
But if you want to read them yourself, it's your case. You tell me how you want.
Sorry, I didn't.
You want to read it? You can.
Well, I just wanted to lay some groundwork, but I didn't mean to.
I just closed 34.
I would like to move over to my video.
All right, let me just read this first, though. Okay. I can't do it. This is so lame. Okay.
We do not have a video.
Oh.
The video, I have a USB drive here.
Okay, perfect. Do you have a copy?
Please give that to the clerk in one.
I give them a copy. I have one. Here's one for you.
Allison, close out of your browser and try it again.
E3.
Yes, twins usually deliver early. And somebody was asking about twins earlier. It doesn't have to run in your family. I covered it in the other one. A very small percentage runs in your family. The other, it's where you release 2 eggs instead of 1 because your body's screwed up. And it's pretty rare. I think it's, what,
Okay.
3% or, no.
Let me make sure I got all of
Sure.
it because, all right, I got it. All right, so let me just look again at 34.
I'm sorry, I didn't pre-watch this and edit it.
And so what's the context of 35? When did you get this?
That was in the same email.
Oh, I see.
Yes.
And this is from the plaintiff, Ms. Owens?
Correct.
Okay, got it. All right, so what do you want me to see next?
So I'd like to admit this exhibit, if possible. So this is
This is also part of Exhibit 52 because you put all the videos in one. So this will be defendants 53? Yes. Okay. Lay some groundwork so they can have a chance to object. Okay,
Yes.
What are we going to be looking at here?
So what you're going to see is 2 screen recordings. The first screen recording is showing my email inbox that this message was sent from Ms. Owens. Within the message, you'll see the ultrasound video that she earlier stated she sent to me. Then the second clip you will see is a screen recording of a YouTube video from 6 years ago. That video contains the exact same video that she sent me. So you will see that these videos are identical, and this ultrasound video that she sent to me is not her ultrasound. It is a ultrasound that she stole online.
And Your Honor, I'm going to object to that because the scope of this hearing is, again, whether they had a domestic relationship and whether there has been domestic violence by Mr. Echard toward my client.
It's not denying it.
Regarding paternity, regarding her pregnancy and regarding what maybe she sent to him, isn't within the scope of this hearing. What this hearing is in regard to is whether, again, they had a domestic relationship and whether he has harassed her by putting things online when there's now a court order forbidding him to post false information. What he sounds like he's trying to show, again, it doesn't have, that's outside the scope of what this hearing is about.
I will consider your objection in deciding what weight to give the evidence, but
I don't know.
And to some extent, I think there's some validity to what you're saying, but I'm going to give Mr. Echard an opportunity to basically what he's trying to do, and I believe at least,
No, she upped her levels.
is to show me that this is something that the plaintiff has done before as a way of, I don't know, somehow benefiting herself. And that, she created this whole situation. And that whatever he did was some sort of legitimate self-defense to protect his reputation because she threatened his reputation. I believe that's where he's going with this. And so I'm going to decide, I have to decide what weight to give it and whether that outweighs what he's done. But I think it's legitimate to allow him to put that into evidence, so I overrule. Go ahead.
Thank you.
You're welcome.
So I will play this video again. You can see within here it says ultrasound video proof. And so I will play this video. I'm going to just pause it so I can give context throughout.
All right, remember, we'll do a time check. Oh, you're almost out of time yourself. How much do you, how long?
I mean, this video looks like 2 minutes. I mean, I do have additional evidence that I feel is important to try to submit.
Well,
but this is the most important one.
Jermaine, who sent me the statute. So this order, the temporary protective order, was granted based on the revenge porn statute because of the belly photo with the Halloween package. Is that what it's from?
Go ahead, play it.
Okay. So this is showing that this is the email she sent me. She says here is whatever percentage that is, 1,000,000% a real ultrasound video.
1 million.
When did you get this?
Does it state on here? This is probably within the last month. Oh, it should stay up there on the at the top right. Maybe
You have it on your computer. Can you magnify the view?
Oh, just tell me. Let me pull it up. Oh, what's going to pull up the same one? Yeah, let me pull it over here so I can.
Or even just look at, the information, get info on the file.
This is Friday, October 6th. Yeah, it says October 6th.
All right, and is that about when you received this?
Yes.
Okay.
So this shows that this was sent from her, and I just pulled up that her contact info.
Okay.
Now, what's going to show? This is the ultrasound video. I want to highlight the. You'll see it'll say baby A, baby B, and placenta, and that's important. Again, I want you to focus. Here's baby B, then placenta pops up, and then it says baby A. And so again, I just want to show that this video. This shows B again, and this is the video that she sent me and claimed to be 1,000,000% her ultrasound. Then it shows A, and then it comes here. It shows B and A again. And this is the end of the video. Should be right about here.
Okay.
Okay. So that is what she sent me directly to my email stating that was her ultrasound. Now this is a screen recording from a YouTube video that I found of a video that is what I believe to be the exact same video.
All right, now, how can you connect this video with the plaintiff? You have to do that first. It can't just be someone that you just found on YouTube and you're saying it's the plaintiff, but you can't prove it's the plaintiff.
Yeah. I'm stating that this is not this video that I just showed you.
Let him speak first. Go ahead.
The video that I just showed you is within this video. She took that ultrasound video.
She used the exact same video.
Correct.
But I'm not an obstetrician. I don't know. How am I going to be able to tell that?
I think
the video.
with the video.
I'm going to quote your language.
Oh my God, I did it again. This is the video I showed you last time where Dave put them on the screen side by side. While they were going. I freaking hate this. My hand twitches and then I click on the wrong thing. Does anybody remember exactly where we were at?
I think it's legitimate to question whether she was pregnant.
Okay, no, it was a little bit before that.
If I may, it's just in regard to the law, what I think applies here under the domestic statute.
Under what statute?
ARS section 133601. It specifically indicates what domestic violence means.
Right.
And it lists, call it about 20 different ways it can be viewed. And there's just,
that's kind of where I was going, but you said you wanted to interject. So, okay, go ahead. You're right so far.
Okay, so I just wanted to just list four that I think are applicable in this case. So,
yeah. Which ones do you think apply?
ARS 132904.
2904?
That's correct. That should be disorderly conduct. And then three more, which are ARS section 132916, ARS section 132921, and then possibly ARS section 132921.01. That's just all I wanted to inform the court about.
All right. So tell me, I could pull all these statutes, but what is 2916, real briefly?
2916, just one moment. use of an electronic communication to terrify, intimidate, threaten, or harass.
Right. I prepared for this hearing yesterday after my calendar was over. And that was, I looked at the petition and I thought, well, which statutes are probably going to be in play? And so I made copies of them. And I did make a copy of that one. And I also made a copy of course, 2921, which is the harassment.
Thank you.
So 29, these are all, as he said, in the criminal code, they define domestic violence as any violation of the following statutes, and they're all criminal statutes. And so so these are what I call predicate statutes. One of them is ARS 13 is the criminal code. 13-2921 is the harassment statute that's applicable to domestic violence per se. There are other definitions of harassment elsewhere, but they don't apply to this. Then another predicate offense is ARS 13, again, the criminal code. 2916, which is use of an electronic communication to terrify, intimidate, threaten, or harass, and so on. And so, okay, I got that one. So what is the other statute that you want me to, let's see, 2916, got that, that's terror. 2921, we already talked about that, that's harassment. And what's 2921.01?
That one, that was a possibility, but that has to do with, let me just.
I got the ARS page in front of you. It's aggravated harassment. That's just like
He's not even a judge. He's the commissioner, where they get an attorney like Norbreck in Michigan. You get an attorney and you make him a magistrate, or in some states it's a magistrate, some states it's a commissioner, and then they help you with the family court case backlog. He's a commissioner.
If a person has already been
Not a
convicted
sitting
of it
judge.
and they do it again, then they can be convicted of aggravated harassment. Or they violated an order of protection.
And to be forthcoming, Your Honor, I don't believe that we were able to get in the evidence that would have shown that one. So I believe the ones that most comply are the first three that I gave you.
I see.
Am I able to ask a question?
Just a second, I'm trying to figure this case out. When you sent the images to the press, that's similar to this one, only I realized you were at a different stage in your pregnancy and you were wearing different clothes, but you still showed basically your belly.
Right.
Right. Did you, when you sent it to the press, didn't you know that they could publish that?
They swore to me, it was to page 6, and they swore to me they were not going to publish anything, that it was just for them to confirm that that I was indeed pregnant. But yeah, it was a different image. It was earlier on in the pregnancy.
Did you give them permission to publish that image?
No, and I made sure that I had been writing from them that they were not going to publish it, and they didn't in any of their stories or anything.
Did you give Mr. Echard permission to publish this image in Exhibit 11?
No.
Not the ultrasound, but
no.
Is Exhibit 11 the leopard print?
All right.
Or the other one?
I'm going to find that the plaintiff has met her burden.
Thank you so much.
One of the predicate offenses here is ARS 13-1425, which is unlawful disclosure of images. The statute is really targeted toward people who send pictures of one another nude or having sex.
I missed Dave.
And then they publish that kind of thing. But then there's also the second under ARS 13-1425A2. The photo is such that it captures the person, the depicted person, who has a reasonable expectation of privacy. And then that's the first sentence. The second sentence, evidence that a person has sent an image to another person using an electronic device does not on its own.
So the thing is the person is supposed to be nude or engaged in a sexual activity. I don't see how showing your belly in a photo? I mean, that one. That's the photo, right? I believe. Like, she has published this photo everywhere. I may be a little fluffy now, but when I wasn't, I have GI issues. So if I eat ice cream, I'm bigger than that. My belly would swell up. You'd think I was 9 months pregnant. Like, that's nothing. Nothing. I didn't give that a second thought. But if you're... That's not nude. That's more than you'd wear to the beach. Yeah, see the muscles and the abs, how they come up, like you could still see them. That's not what a pregnant belly looks like.
Remove the person's reasonable expectation of privacy for that image.
It's ice cream
And
belly.
so, you know, I'm looking at
That's
the
Ben and
context
Jerry's
of
belly.
this. There was a dispute as to not only whether she was pregnant with your child, but also whether she was pregnant at
I
all.
couldn't go back.
And she sent this image to you saying that this was her. She's testified that that is her image. And you know, that hasn't been disputed. And so, and she said you're the only person that she sent it to. I realize it's possible that she could have sent it to somebody else who could have published it. That's true. But she denies that. And then I have to decide, you know, would she really want to do that? Because it's not the most flattering picture. That obviously when a person's pregnant, you know, their body's changes. And it's not something that I would think that any woman would want to share. Once in a while you see it, you know, on TV or something. But it's something that...
Okay, let me just dispel that rumor for you. I'm a hot mess right now. I don't care if it gets shared. If it's getting to the goal at the end of the line. Like, it's not like it used to be where, you know, Susie Homemaker is wearing her cute little blue dress with a sailor collar and everything's all neat and pressed and perfect. Times have changed. Papa, times have changed.
I don't believe that she would have wanted to share. And this depiction not only showed her, but it was poking fun at her. And it does seem to suggest that you had a connection with it, because that it does say somehow it connects her to this picture, because it's somehow it was connected. The Bachelor website saw that. And also it's this idea of this show holding a fake sonogram, or let's see, I have to move the statute out of the way and look at the imaging.
That's ridiculous. Because it's connected to The Bachelor. It's his fault. Are you serious?
Yeah. It was something like making fun of the sonogram, saying, you know, this is all, you know, not true. Real sonogram. Unbrushed wig. I mean, you know, the hair is similar, I guess, to the hair that she
real.
has.
Yeah, I'm kind of done too.
So I'm going to find that posting of that image, publicizing that image, was triggered the the domestic violence statute 133601 does include the cite to ARS 1425. I'm going to find that that statute applies, and that is the reason I'm affirming that. Oh, and there's an intent.
That's bullshit. Straight up bullshit. Yeah, and it'd be okay, except that I keep biting my cheeks. I'm sorry if I'm talking weird. My mouth is a hot mess from antibiotics. Like, he literally just went against everything that we know and we have. Like, this goes all the way up to the Supreme Court. Like, you can't like associate A and B. Well, you know, since you like apples and that guy's eating an apple, you must be related. I mean, come the fuck on. Really? That's not okay. Wow. And I understand people are ultra conservative when it comes to DV cases because you don't want to be the one that let the killer go free. I mean, I don't know if you guys remember the David Chase case. He was in front of Judge Manning, but he had prior cases in Nashville, and he beat the crap out of his girlfriend, went to jail, his dad was well known in Nashville, so he got out when you're supposed to have a 12-hour DV hold, and nobody knew it, went home and got her again. Almost killed her. Got off the second time too, but anyways, it happens like more than we care to realize. And no, it has nothing to do with DV, but that's how it was presented and that's how it's classified and that's what the checkboxes say and that's the only way you can get this order in this fashion. And it's bullshit. This is like some made-up fairy tale world. Like, can you imagine all of a sudden, like, someone is telling everybody this thing about you, and you can't prove that it's not true? Like, you're not in control of... You didn't do it. You didn't cause it. And you can barely fight it. And this person is showing images to confirm what they said. I mean, that has to be like messed up, gaslighting, brain. Fuck. And I'm sorry I'm cussing a lot today. I had a rough day. But like, this is unbelievable. I don't even think it's that. I think it's a generational thing. Because I see what he's thinking. There's no way. Nobody would do that. Think about your grandparents. Think about your grandparents' life. Would they be doing this shit? Right. So that's why he can't
that has
process
to be
it.
shown as well. And the intent, just the act of disclosing it is unlawful.
I'm a hot mess today.
That would be ARS 1425A2. I'm also going to find that it also violated ARS 1425A3. The images disclosed with the intent to harm, harass, intimidate, threaten, or coerce the depicted person. And the intent can be filled in by Exhibit 1, which is your email to her that if she goes forward with what I understood to be the paternity claim, that you would hate her and that would
Are you
not
kidding
end
me?
well for her. I mean, those aren't exactly what you said, but let me just get the exhibit back up again. You said in particular,
Yeah, it wouldn't end well. Wouldn't be great. It would probably suck. Like, it would make our lives hell. Like, we don't want to end up being one of those couples in family court
back
in
to her
10 years.
exhibits.
Messing up their kids'
One.
heads.
Your Honor, am I able to ask the question?
Just a moment, please. Let me just make my record, and
That's
if
not
you
on
can.
the,
I'm really-
that's not on the docket for today.
I'm not an appropriate person to ask questions of, but I'll listen to your question, but give me a moment to get this out.
Okay.
The bottom of the string
Because you
says, I
can't
hate you
prove it.
right now. But there was something here.
Oh. Wow. I know what he's looking for. There was the one quote. People can twist anything. You really have to be careful, like, what you put out there.
You better be serious about being pregnant, because if you're not, I'm bringing this all to light. People like you need to be held accountable. We can back off now. This is all a game, and I'll let it go. But if you continue any longer, and it's all a lie, I won't hesitate to reveal the truth. One thing about me is when I make up my mind for good, especially when it's rooted in anger, I don't sway ever.
Oh my God, he might expose our lie. Let's
Individuals
put that
like you
under the
that play with people's
porn
emotions are
statute.
the worst kind of person. I've met many, been taken advantage of by many, and I'm sick and tired of being nice, playing nice with them. My hate is toward you and to you only. My hatred would only grow if you decide to put me through all this. I mean, on the one hand, I think it's legitimate to question whether she was pregnant. I think it's legitimate to question whether, even if she is pregnant, whether it's your child. But there are ways of dealing with that, and that would be, going through the paternity case and proving, making her, it's her burden. She has
What
to
about
prove
the
that she's
500
pregnant with your
messages?
child in order for you to be legally responsible for that child. That's the way to handle it. It's like the common denominator in every order of protection that's affirmed is that people have sometimes really legitimate feelings and rights, like I feel you do. But at the same time, they go about it, though, they go about vindicating those rights by taking matters into their own hands and using self-help remedies instead of dealing with it through the courts like you're supposed to. And that's where you went wrong. Not that you had your feelings about, questioning this or thinking that it was a fake or that kind of thing are illegitimate. You can think those things if it sounds like you might have had some reason to think that. But the way you published this photo, and which is what I found, I know that you've denied it, but I'm finding that there's really no other accounting for it except
that he
if she
published the
posted
photo.
it, and I don't think a woman would have done that in a situation like this. Not any person wouldn't have done that. If I before I went on a diet and I took a picture and sent it to somebody, I wouldn't want that picture. It's unflattering. I wouldn't want it. Yes, it's focused on a woman here, but this is something that most humans don't want to have unflattering pictures of themselves posted all over the internet. And so that's my reason for making my decision.
You wouldn't have done it.
So,
You wouldn't have
and the
liked
intent
it.
is
So she
proven
didn't.
by Exhibit 1. And I also find that that's by doing that you violated ARS 13- the harassment statute. ARS 13-2921A.
Wow. I didn't realize how bad this was.
1 and 3, which is causing a communication with another person by verbal, electronic, mechanical, telegraphic, and so on, and written means. And another one is surveys or causes another person to survey the person. I think that is well, a survey may have to be in person. It's not.
Yeah.
That term can mean following somebody. It could mean following them and harassing them online. I mean, today, harassment online is just as bad as, almost as bad, possibly worse in some cases.
Yes,
where, you know,
there's no
it can be
proof he did
magnified
it.
by the large public following. That's something that I think, to me at least, just looking at the regular word survey, it doesn't have to say publicly survey as it does. And like subsection A2, for example, that requires public, that you're following another person in or about a public place after being asked to stop. That doesn't apply here. But I think subsection 3 does, because it doesn't have those limitations about being in public or in person, really. And then I'm also, counsel had suggested that ARS 132916 is applicable. Use of an electronic communication to terrorize a person. This one I'm not sure. Let me look at it.
Kind of hard to put in legal jargon. Oh yeah, there'd be 3 bailiffs dragging me out.
I do not find that that applies. One of the subsections, oh, hold on, there's one other thing. I'm looking at 2916, the terrify, intimidate, harass statute, A, subsection 4. It's unlawful for a person to knowingly terrify, intimidate, threaten, or harass a specific person or persons by doing any of the following. I don't think 1 through 3 apply, but subsection 4 might. So let me read it. Without the person's consent and for the purpose of imminently causing the person unwanted physical contact, injury, or harassment by a third party, like a following, for example. Use an electronic communication device to electronically distribute, publish, email, hyperlink, and make available for downloading the person's personal identifying information, including a digital image of the person, and the use does, in fact, incite or produce that unwanted physical contact, injury, or harassment.
Yes, October 4th.
This paragraph also applies to a person who intends to terrify, intimidate, threaten, or harass an immediate family member of the person whose personal identifying information is used. I don't find that the last sentence applies. There's no evidence that he intended to terrify or intimidate or harass her family. Although that might have been the effect of it, I don't think that he had that intent. But I think that he had the intent to do that to you. And so I'm going to find that another applicable statute, which is another predicate in ARS 133601.
He's just pulling shit out of his ass at this point. OMG. Like, how? Yeah, well, you know, I think you might have possibly, you know, did that because there's no way she would have done it herself. And, you know, who else would have done it? Not the, you know, hundreds of thousands of people that are all stirred up by this. No, it had to be you. You're responsible. Sorry. What? WTF? Come on now. All right, so this
is ARS 13.
For starting to cover the case and for raising money for Clayton for an attorney. I mean, it's obvious he needed an attorney. Anybody who knows anything about this could see he was doing amazing on his own, but he really, you know, needed that legal help. Like if he would have had those Dropbox screenshots, that would have been done. That was all. That's all he has is that photo with an unknown origin. And if you can link it back to Jane Doe, done so.
2916A4. And so those are the reasons for my ruling. Brady does not apply because my understanding is the parties never lived together, right?
Yes, we did not.
So that's required by Brady.
They didn't even go on a date.
So you're not going to lose your gun right. But obviously you want to be really careful with how you use those. And you've never threatened, personally told her that you're going to harm her. It's just that this, it's almost like you can summon a tsunami with your followers, according to her testimony.
Summon a tsunami.
Does the plaintiff want, I'm going to answer, I know you have a question, so I'm going to give you a chance to ask it. But before I get there, I want to find out from you, is there anything that you want me to do to modify the order of protection?
I think, we can still have communication about paternity. My main concern with him is just that he's going to be posting untrue things that are going to cause people to harass me.
Mm-hmm.
I'm not afraid he's going to physically harm me.
Mm-hmm.
My concern is more that, but I still think we need to talk about the paternity case because we're both unrepresented in that.
That's fine.
Yeah.
I think that the order of protection itself is broad enough to encompass this idea of continuing to incite people to bother you. And so I choose not to put anything on there because it would be really difficult to write. Why?
Nobody
there are First
showed
Amendment
anything.
concerns here that I don't want to say. Don't tell any of your followers anything about your situation with Laura Owens. Well, I'm not sure that that's probably overbroad, but I would be working probably futilely to find the right balance of language here. So I'm just going to leave it. All right, so I'm not going to amend the order of protection. Okay? All right, now, Mr. Echard, you had a question for me. I would, let me just finish this form and then I'm going to be glad to try to at least answer your question. Go ahead.
I'm okay to ask?
Yes.
Okay.
And thank you for
What on
waiting
earth?
patiently.
Just happened.
My understanding is that this order is going into effect because the belief is that I was the only one that had access to that photo. If I'm able to prove, which I believe I can prove, that she has sent it to someone else, am I able to get an extension before this ruling?
No.
Because I do believe
No?
I can prove that she sent this to other individuals.
Okay.
So what would I guess my question is, how do I go about, because again, my understanding is that's what this is hinging on, and I do believe that I can get credible evidence that she sent this to another individual. So if I'm able to get my hands on that, would that not reverse the ruling?
No. Well, first of all, I'm going to rule now. I do not, this is the time for the hearing. And these are, this is, I don't think it's appropriate here to hold the case open until you can come back with more evidence. So, no, I choose not to do that. I also, and I know that was my main focus, but I also believe that you talked with your followers about this and that she testified that you had made comments about her and how you don't believe her and that she's a liar to your fan base. And I also believe that is something that can be added as reasons for my decision under the harassment statute.
I guarantee you he has
errors
zero clue how social
29,
media works.
21, 1A, 1, and 2. And she came to me for well, I don't know if I'm allowed to say that. I think if all that we got were a text message.
So it actually causes you problems. Background checks and things like that, it shows up on it. So it kind of hangs over your head. And while it's not something that would necessarily disqualify you from normal employment and things like that, nobody's going to hire you to be a mental health motivational speaker, all these things, when it says that you have a DV restraining order against you by your ex-girlfriend. There's nothing in there that says it was from posting a Halloween costume picture parody online. It just says DV restraining order. So it looks really bad for a person.
From you saying, I hate you, and if you do this, I'm going to be really mad and you're going to regret it. I mean, that could mean a lot of things. It could mean I'm going to sue you, and I'm going to have attorneys, follow you to the lawful ends of the earth to the extent that the law allows. That is, that's scary, but you have the right to do, you could say it once. And if that's all you did, then that I wouldn't have granted an order of protection.
He was going on harassment.
Here, you not only expressed your intent, but then I find that you followed through with it. And you used the means that were available to you in order to, frankly, get her to stand down and abandon these claims that you're the father of these children, or that I think at some point you accept the fact that she's pregnant, but you're still, and you have the right to still say, I don't believe that this is my child.
Wow. And right there's the crux of it all. I apologize. I kept hitting, my fingers twitch from the MS, and I go to pause it, and sometimes if you're like a 1/10 of an inch up, it takes the whole video back to the beginning. So yes, she did admit to having contact with the judge. It is on record, where she emailed him and everything else, and it's just unbelievable. So the judge believes she is pregnant at this time. Now, at this point in time, there have been, I believe all the ultrasounds that have been submitted have been disproven by Clayton. There have been no medical records. There is the one HCG, I think. Oh, I don't even know if that's on file yet. And the no fetal DNA. So I don't understand how all those things can happen and not cause that shadow of a doubt that he should have, to not make assumptions against Clayton. What he should do is admonish both of them for acting like children, and you go home and you stop saying mean things and you stop harassing him. Go on with your life. I mean, that's the position the court is usually in this situation. This is like way overreaching. He's like creating. Wow.
And that's going to play out in a paternity case. So I hope that answers your question. If not to your satisfaction, at least that's the best I can do. So I'm going to order that, because this has been affirmed, that you please leave stuff. One other thing. I'm making a finding that these acts that I just found had occurred caused I believe that it caused the plaintiff to feel
poor little me. Yeah.
Seriously alarmed, annoyed, humiliated, and mentally distressed. And in fact, so that's it made her feel that way as a subjective matter.
I would love to get her take on this.
And that it would have caused a reasonable person to feel the same way under the circumstances. So, anyway. So I focused on his intent, her intent. I think I've completely given every reason that I can think of. And of course, anything else that's supported by the record is important. Now, please, everybody going forward, use your legal rights, use your the legal pathways that are available to protect you.
Anticipated this, though.
And I wish both of you the best. I appreciate your patience with me today.
All right. So, good morning. I'm Commissioner Jones-Fittis. And we're here today in the matter of Clayton Echard versus Laura Owens, CV 20230533952. We will start by having everyone state their names. Ms. Arena, if you want to begin.
Good morning, Your Honor. Deandra Arena, counsel for the plaintiff, Clayton Echard. I'm also accompanied by Isabel Braney from my office, who's an associate.
You, Mr. Eckert?
My name's Clayton Echard.
Thank you. Yes.
Good morning, Your Honor. Attorney Joshua Lopez representing Laura Owens, who's present before the court on Microsoft Teams.
Right, thank you. Ms. Owens, if you can state your name for me.
Laura Owens.
All right, thank you. All right, so this is the continuation of the contested hearing that the previously held on October 24th. Before we start, I guess we'll discuss there was a request to have the hearing not put on live stream. The court granted that. Then there was an objection to that filed. The court had granted it prior to the objection, but I have reviewed the objection. At this time, I'm still ordering that the live stream not be active during the hearing. The courtroom is still open. Anyone who wants to come to the courthouse can view the hearing in the courthouse, but I'm not having the hearing live streamed. We also had a notice of supplemental allegations filed on October 31st. Mr. Lopez, did you have an opportunity to review that?
I did have an opportunity to review it, and I'd like to object on a handful of different reasons, Your Honor. And if you'd like, I can present those now.
Sure.
So in regard to the amendment, well, in regard to the amendment, Your Honor, generally what happens in these order of protection hearings or injunction against harassment hearings, the petitioner is able to amend their petition at the beginning of the hearing before we've even started to determine what the scope of the hearing should be in regard to. In this particular instance, Clayton did not have those in his petition, and we are now 4/5 of the way through his petition. Not only that, we've started the hearing and he's ended his case in chief. We've already presented now. He's ended his testimony. He's ended entering his exhibits. We've moved on to the defense case in chief, and we're 4/5. Again, we're 4/5 of the way through the hearing. If this was all complete on the same day, he wouldn't get that opportunity to now amend his petition once we're already about to be at the end of the hearing. Just because he's now hired counsel doesn't give him a new opportunity to now amend the petition or add exhibits or add testimony. That would essentially be restarting this whole hearing over again, opening up the petitioner to be able to testify and then cross-examination, and then we would get a chance to respond. That wouldn't make any sense. It's too late now. He shouldn't be able to amend the petition at this point.
If you wanted to be heard.
I do, Your Honor, and
You can remain seated.
Okay.
It's better for the microphone anyway. So
whatever the court's preference is, of course. Your Honor, with respect to our request to amend pursuant to Rule 38D, it's our position that we are able to amend at this point in time. Mr. Echard has already provided testimony to support these new allegations in his case in chief. I believe the purpose of Rule 38 is in part for judicial economy. As the court's well aware, Mr. Echard could proceed with filing an additional injunction against harassment at a later date. So we're really just doing this to ensure that the court has all the necessary allegations to proceed with making a determination in this hearing today. I don't believe it's prejudicial whatsoever. Again, the testimony has already been provided to support these new allegations, and I think it's important that they be added so that the court can make a determination today and Mr. Echard doesn't have to come back another time with a new injunction.
All right, thank you. So when I first received it, I was concerned that we were, just adding stuff at the last second. I do think that these are just making more specific allegations that we did discuss, that Mr. Lopez did have an opportunity to cross-examine him about because they were based on exhibits that were already admitted and have already been admitted at this time. So I will allow the amended allegations at this time over the objection. But I do have the same concerns Mr. Lopez expressed, which is we're not restarting this hearing. And so the reason we reset it was so that Mr. Lopez could ask Ms. Owens questions about their exhibits and admit whatever exhibits they were choosing to admit. Mr. Echard, I have given him an opportunity to review those exhibits prior to those being admitted, since he hadn't had an opportunity to see those. So where we are in the case is that Ms. Owens has testified primarily. She is going to, I guess, finish her testimony through whatever exhibits Mr. Lopez wants to admit. And then Mr. Eckert would have the opportunity to cross-examine Ms. Owens because that part he hadn't concluded yet. And then we would do closing arguments. So that's kind of where we are. Okay.
Just a question, Your Honor. So I understand that you're going to allow the amended petition, but as far as the exhibits that the petitioner was trying to supplement, those are not being included. Is that correct? He's not getting the opportunity to admit additional exhibits. Is that correct?
I mean, I guess the only thing I have about the exhibits, and I haven't seen that, I haven't reviewed all of those exhibits. The only thing I don't know about any of the exhibits is if they were in response to any of the exhibits that you have, I guess is what I'm not.
And I guess I'm not sure either.
I guess that's the only thing I don't know, but at this point I do think his, case has been basically concluded.
Okay. My final question is, as far as this hearing, I know it indicates in the minute entry it was, we were just going to go for 30 minutes. Is that 30 minutes altogether? Is that 30 minutes for us to present our exhibits? Is that broken down? I just want to make sure that I'm efficient with my time as best I can be.
I mean, ideally we're here for 30 minutes, but I will extend it to 45 minutes to allow everyone to do closing. So the testimony portion, and that would include cross-examination time, would be the 30 minutes.
Okay. Is it, do I have 20 or is it like 15 and 15? I just want to make sure.
20 is fine, and then 15, 10 minutes to cross-examine if we need to, and 15 minutes for closing or whatever. Around that time.
All right. Thank you.
Okay. Ms. Rena?
Your Honor, with respect to the exhibits, the supplementals, they are, for the most part, impeachment exhibits with respect to Ms. Owens' prior testimony. So that's what they would be using for. And so I guess to answer the court's question, they are responsive to defendant's exhibits here. So it would be utilized for cross-examination. That's what the supplemental exhibits are for.
And I mean, I think you could use them for impeachment purposes if you felt they would be relevant. So I just don't know if she has them to look at.
They were disclosed to Mr. Lopez on, I believe, yesterday morning.
I was able to send them to my client, Your Honor.
Okay, thank you.
And Your Honor, one last thing. While I understand and respect the court's decision regarding the courtroom being closed for live stream, I do have concerns regarding the fact that Ms. Owens is present virtually and who's present, in her household and who else is being able to listen to this. My client, unfortunately, with this hearing not being able to be live streamed, is being precluded from having any of his family, friends, or any other persons that may want to listen in support of him from being able to do that. So I would just ask that the court at least confirm with Ms. Owens that no one is present. I know this is hard to confirm, but that's one of our concerns.
Okay. I'm not sure. I mean, obviously his family can be here, and I'm not sure it looks like he has some people here, but Ms. Owens, is anyone else with you?
No, I'm in a casita by myself.
Okay.
I can also pan if they want to see that nobody else is present, if that would be helpful.
Okay. All right, thank you. All right, so Mr. Lopez, you may proceed.
Yes, Your Honor. I want to turn the court's attention to, and I'll jump around here a little bit, but Exhibit 38. And Your Honor, do you have that available? It's a video. Do you need a USB?
You can hook up to your computer so it to show it. I can make you a presenter.
I can play it on my computer. Is that what you need? Because I can bring it up there.
Yeah, if you want to present it, then I can make you a presenter, and you can. Well, actually, because I think you need the little hookup thing to that.
Yeah, there were some technical difficulties. I want to either say last time or in a different court. I could try and do that. I don't have the.
Best if you can bring in those hookup things.
What was that, Your Honor? Sorry.
I'm trying to get my JA to bring in the little extra extension thing that I think you need. Sure, as long as everyone can.
Okay.
So anyone wants to come up and see it too, or?
Okay. Laura, do you have in front of you exhibit that's marked 38?
I believe I know the one that you're referring to as I don't have it in front of me, but I believe it's the video of my pregnant stomach. Is that correct?
I believe this is the video she's referring to. This was sent to, I'm not sure who, Clayton and somebody else as proof of pregnancy.
Yeah, is this an accurate video of you?
So it's actually not showing up at all on mine. Your Honor, I can see you and I can see Mr. Echard's counsel, but I can't see my attorney or anything else.
You can't see me?
No,
If you can maybe just put it near the lap, we might be able to see it just on the
I
screen
think
there.
what she's saying is she can't see all the participants.
She can see you. Well, can you see him now?
I cannot. I can only see you and I can see Mr. Echard's counsel.
I mean, I can maybe unmake you a presenter because I think maybe that's what happened. Is can you see him now?
I cannot.
Can you click something on your screen, like participants, or a different view?
Let me see.
Okay,
Show
gallery, what is?
No, nothing else. Nobody else is showing up.
Okay. Despite you being able to see me, do you have in front of you Exhibit 38?
The video of my pregnant stomach.
Yes. What is this?
It's a video that I took of my pregnant stomach because Mr. Echard asked me to take it for him so he could verify that I was indeed pregnant.
Okay. And is this video an accurate reflection of what you looked like recently?
In September, I believe.
And is this a video that Mr. Echard asked you to send to him?
Yes, it is.
Was that to show proof that you were in fact pregnant?
Yes.
Okay. Then I'd like to move into evidence Exhibit 38.
No objection. I don't believe sufficient foundation was laid. Also, this video does not have any time or date stamp on it to be inherently reliable.
I mean, I can't see it, but
is there any way, Your Honor, for the video to be played on the Microsoft Teams?
So that's what I think we were trying to have him do with that, the hookup thing, but I don't know specifically how to do it. Beth, do you know how to hook it up or no?
I do not, but I can ask next door.
Do you know if Clayton had changed his number since he had texted you from that number previously?
No, he had not, to my knowledge.
Okay. And these text messages, were they sent to you during the time periods between when you became pregnant to when this petition against you for this injunction against harassment was filed?
Yes.
Are these accurate reflections of those text messages? Have they been altered in any way?
They have not been altered in any way.
Okay. Your Honor, I'd like to admit into evidence Exhibit 40.
Any objection?
Sir, I am objecting for the record. I think there's a completeness issue here. These text messages have been altered. As the court can see, these text messages only include the statements that Ms. Owens wants to include here, not the context surrounding the text messages. I also believe that there hasn't been sufficient foundation laid with respect to the actual dates that these text messages span.
All right, I'll admit 40 over objection.
All right, I'd like to turn your attention now to Exhibit 47. Do you have Exhibit 47 in front of you?
Yes, I do.
And what is this exhibit?
This is an email I got from Clayton on September 17th saying that he was unbothered by me going to the media about the situation.
Okay. Now, you said when was this email sent to you?
September 17th.
And it was your understanding that it was sent from Mr. Echard?
Yes, correct.
Okay. And what was this email in response to?
This was in response to me saying that I had told him that if he didn't continue to participate in the paternity case, that I felt like I was going to need to go to the press because I thought that would pressure him to come up with a parenting
Objection,
plan.
Your Honor. She's providing a narrative that's not part of this exhibit. Again, this is a completeness issue here. She is cutting out the portions she wants and leaving out the context, which would be the email that she sent him that he is responding to.
I'm only
If you want to present the other half of it, obviously you can. I would go ahead and admit exhibit, what are we, 40?
Okay, Your Honor, yeah, at this time I'd like to admit this exhibit.
47, it'll be admitted.
Okay, I'd like to turn your attention to Exhibit 37. This, again, is, what is this?
I do not have Exhibit 37 in front of me.
It should be a video.
Can you possibly give me the context for which video it is? Or
It should be a video that was posted by Clayton.
oh, okay, yes, I know exactly the video. It was a video that Clayton posted on October the 6th on his public.
Okay, what is it? What is this video?
This is Mr. Echard telling his 200 and nearly 300,000 followers that the results of our paternity testing were back and he was not the father when, in fact, the paternity test results were not back.
Okay, so you had done a paternity test?
Correct.
The results are not back?
The results are still not back. The testing is ongoing according to the lab.
But since the paternity test had come back, you are indicating Clayton had posted a video?
Correct.
Where was that video posted?
I'm sorry, did you say where or when?
Where?
It was posted to his public Instagram.
When was it posted?
October the 6th.
Okay, how did you get a copy of it?
I got a copy because it was on his public Instagram.
Okay, and was this an accurate have you altered the video in any way?
No, I have not.
Okay, Your Honor, I'd like to admit Exhibit 37 into evidence.
I'm objecting on relevance. This case is about Miss Owens' harassment of Mr. Echard. Mr. Echard posting anything on his private social media is not relevant to this case.
Your Honor, as part of the petition that Mr. Echard had written, he had indicated that my client was defaming him when in fact my client was not defaming him and that she was harassing him by sending him emails and different text messages. I think that this is relevant to show that not only were the text messages and emails concerning my client's pregnancy, paternity, but also what I had indicated in my opening and evidence that we had Ms. Owens testify to, that she did in fact also message Clayton to take down certain false videos or false statements offline because she was getting harassed by his fans and followers. So this video is to show that this was the video that he had posted and the reason she had continued communication with him beyond just the pregnancy and paternity was for him to take down certain videos, that it wasn't for harassment and that it was for legitimate purposes. This is that video that we want to present to show why my client was communicating with Clayton regarding that specific issue.
All right, I'll admit the exhibit for the purpose of that limited purpose that you're referring to.
Listen, it's Friday, and you know what we need on a Friday? We need some good news. And who's got the good news today? I got the good news. What's that good news, Clayton? Well, test results came back early, and they said little to no fetal DNA present. Let's go, baby. We knew, I knew that was going to happen. Thankfully, 5 months of torture can finally be put to rest. I want to say thank you all to those that have supported me and waited until everything came out. And man, 2 false accusations in 2 years. I really don't want to, look ahead to next year and see what's going to happen. I think 2 false accusations in a lifetime is enough. So Thank you all for the support, the love. This was a trying time, but I learned so much about myself. And now, back to the regularly scheduled programming, baby.
Back to the regularly scheduled programming, baby. Listen, it's Friday.
About 5 more minutes.
All right, I'd like to turn the court and, Ms. Owens, I'd like to turn your attention to Exhibit 44. What is Exhibit 44?
Exhibit 44 is a text message I received from Clayton on June the 4th.
Okay, and was this, okay, this was from, is this a text message or is this an email?
This is a text message.
Is this an accurate reflection of the text message? Has it been altered in any way that Clayton had sent to you?
No, it has not been altered, and yes, it is accurate.
I don't see a phone number in here. Was Mr. Echard's phone number saved as Clayton Echard in your phone?
Yes, it was at that point.
Okay. And, Your Honor, I'd like to admit Exhibit 44 into evidence at this time.
Any objection to 44?
Your Honor, I would just object for the record as to completeness. Again, I believe there is more to this text message than what is being disclosed in this exhibit.
All right, I'll admit it over objection.
Okay, I'd like to turn to Exhibit 46. Ms. Owens, what is Exhibit 46?
Exhibit 46 is a variety of different medical providers that I saw confirming that I am, in fact, pregnant from the day I found out I was pregnant on June 1st through, I believe it was last week. It may have been through the week prior to that, but I have the dates on there through October.
Okay.
Yeah, I'm sorry.
Okay. Were these pictures, why were these pictures taken? Why did you save these documents?
I saved these documents again to try to prove to Mr. Echard that I was indeed pregnant because he doubted me.
Did he ask you to send these documents?
Yes, he did.
To show why?
He asked for these documents to show that I was indeed pregnant and that the pregnancy was ongoing and that it was viable.
Have you altered any of these documents in any way to misconstrue their meaning?
No, I have not altered them.
And are these an accurate reflection of these documents?
Yes, it's entirely accurate.
They are your documents?
Yes, they are.
All right, Your Honor, I'd like to admit Exhibit 46 into evidence.
Your Honor, I'm not objecting because I believe the court needs to see these exhibits, but I will note that we have concerns regarding what they're being offered for.
So I'll admit 46.
I'd like to take your attention to Exhibit 48. Do you have that in front of you?
I do, yes.
Okay, what is it?
This is a letter from the Arizona Department of Real Estate that they sent me after looking into Mr. Echard's conduct when he was my realtor.
So after the brief hookup, whatever you want to call it, they met and he showed her some properties. She asked him to put an offer in on 2 of them and showed him a printout of a money market account with a $400,000 balance. It was during that meeting that he told her, hey, listen, we're just going to be friends. And immediately after that is when the psycho texts and stalking and craziness started. He offered to refer her over to another agent broker in his firm to finish the deals, all that. She refused. He didn't put through the offers because he started questioning whether she had the money or not. So, he probably should have got some advice from someone else because, ethically, he didn't really do exactly what he was supposed to do. But given the circumstances, I kind of Don't blame him.
Showing that he was found in violation of professional conduct for not submitting an offer.
Okay, was this something that you received from the Arizona Department of Real Estate?
Correct.
Did you alter this document in any way?
No, I did not.
Did you receive it on or about September 15th, 2023?
Correct.
Okay, Your Honor, I'd like to admit this into evidence.
I'm objecting for the record based on relevance. Again, this matter is about Ms. Owens' harassment of Mr. Echard. I do not believe that this is relevant.
I agree. It will not be admitted. 48.
Your Honor, how much time?
1 minute.
I'd like to turn to Exhibit 50, Your Honor. This will be the final one that Or Exhibit 50, do you recognize that exhibit?
Yes, I do.
Okay, and what is it of?
This is something that was posted to Reddit by Mr. Echard under a false name, and that was also in the order of protection hearing I had against him last week. It was discussed.
Okay, and did you change this image in any way?
No, I definitely did not.
How'd you get a copy of this image?
It was on Reddit. Somebody had created it, but I know it was Mr. Echard because only he had this image.
Okay.
Objection. She's testifying, Your Honor, regarding information that she cannot testify about. Speculating.
You can have her lay foundation that she has knowledge of.
Okay. It's your understanding that Mr. Echard posted this picture?
Yes, because only he had the photo and the sonogram I'm holding that's been edited. I mean,
Okay.
that's been edited.
Your Honor, I'd like to admit Exhibit
50.
50 at this time.
Your Honor, I'm objecting. This is inherently unreliable. She's failed to lay sufficient foundation. This was not posted by Mr. Echard, and she's provided zero proof that this was posted by Mr. Echard or further that this was sent to Mr. Echard in this manner.
I'm going to sustain the objection and not admit 50.
Okay, nothing further at this time, Your Honor.
Cross-examination.
Your Honor, before I start with cross-examination, my request would be, if the court's willing to entertain this, that we be permitted to go until noon. And I would be willing to waive closing argument because I do have important questions that I would like to go through as opposed to presenting the court with a closing argument if the court would allow that.
Well, let's see how we're doing on time.
Thank you, Your Honor. Good morning, Ms. Owens.
Good morning.
You were thoroughly questioned by your attorney at the last hearing in this case on October 24th of 2023, correct?
Correct.
And you understand that you were under oath at that time, and you remain under oath today, right?
Correct.
And you're aware that any false testimony that you provided or provide today could be considered perjury, right?
Yeah, absolutely.
And so based on that, Ms. Owens, before I proceed with my line of questioning, do you have any prior testimony that you'd like to correct at this time?
I do not.
I want to make sure that you're clear-headed, and obviously it's your position that you are pregnant with alleged twins, correct?
100%, yes, correct.
What medications are you currently on?
Objection, Your Honor. Relevance, and that's an inappropriate question for this.
Overall, it can be impacting your testimony.
I'm on prescribed prenatals, and I'm on folic acid, and I also take lamotrigine for epilepsy.
Is there anything else? Is that your entire list of medications?
That's my entire list because I was taken off of anything else that I was on when I found out that I was pregnant.
And have you been diagnosed with any other medical or mental health issues?
Objection, Your Honor. I don't think that's going into your mental health, going into your physical health, mental health. I don't think that's appropriate for this type of hearing.
Overall, I have a question.
Depression.
Okay, and any other physical health diagnoses?
Epilepsy.
And who provided those diagnoses?
I think we're now over the report of that testimony.
Understood, Your Honor. I'll move on, please. And how far along are you as we sit here today with respect to the pregnancy?
I am 24 weeks along.
And when was your last menstrual period in order to calculate your due date?
Objection, Your Honor. I don't think that that's appropriate at this time. It seems like these questions are meant to harass my client. She's indicated she's pregnant. She's indicated they're not a month. You don't need to know things about her menstrual period.
I'm going to sustain the objection.
I'm sorry.
Can you please provide us with your alleged due date?
February 14th.
And you testify that there's absolutely no possibility at all that your alleged twins are anyone other than Clayton, correct?
There's no chance they're anybody else's.
But you understand that Clayton has been very clear from day one that he did not have sexual intercourse with you, right?
Clayton was not. If you look at the June 4th message,
Ma'am, these are yes or no questions. Do you understand that Clayton was very clear from day one that it's his position he did not have sexual intercourse with you?
Then the answer is no.
And as we sit here today, you have participated in 3 DNA tests to try to prove that Clayton's the father, correct?
Correct.
And not a single DNA test has come back.
Oh, I'm sorry.
Stating Clayton's the father.
Sorry, it was 2 DNA tests, not 3.
Well, you indicated at the last hearing that you were providing a sample for the 3rd DNA test to be completed, correct?
But the second one there was an issue with the transit according to the lab. So, I mean, that wasn't tested. So I can't say that I have had 3 tests that have come back with different results because only 2 were tested.
Ms. Owens, you've provided a sample on 3 separate occasions for DNA tests, correct?
Correct, but the second was
Ma'am, these are yes or no questions. I'm not looking for you to elaborate. So we'll move on. As we sit here today, not a single DNA test has come back indicating that Clayton's the father, correct?
The samples were diluted and I'm going back next month is what I was.
These are yes or no questions. It's a very simple question. As we sit here today, you have no DNA test that indicates that Clayton is the father, right?
The results, the testing is ongoing is what I was told, as was Clayton.
So
that's
you said that on a couple occasions, that the testing is ongoing.
Correct.
So is it your testimony that you provide these samples and that there's no results that are coming from these samples you're providing?
I'm unclear on what you're trying to ask me because they said that I need to go back next month to give another sample, that the testing is not back. So I'm unclear, I guess I'm trying to say.
Isn't it true that the test came back and indicated there was 0 fetal DNA?
That's absolutely not true.
Okay. And again, Ms. Owens, you have provided no testimony and no objective evidence or documentation to date to support that you have a positive DNA test proving Clayton's the father of your alleged twins, right?
The testing is ongoing. I'm unclear, I guess, is what you're trying to ask me.
Who is your OBGYN?
Dr. McCool and Dr. Higley.
I wasn't able to hear that, and I'm not sure if that's...
I'll withdraw the objection.
Can you please repeat that, Ms. Owens? Who is your OBGYN?
My main OBGYN is the perinatologist, Dr. McCool.
And when is the last time... Oh, well, you said your main OBGYN. Who else are you seeing? What other pregnancy-related doctors are you seeing?
Dr. Higley, who I saw last Friday, and an epilepsy doctor as well. He specializes in pregnancy.
Okay. And in your exhibit, I believe it was 44, you indicated, actually, let me go back here. I apologize. It was your exhibit 43. You indicated that all of exhibit 43 contains copies of your medical records that would support this alleged pregnancy, correct?
I believe it was Exhibit 46 that was the proof of pregnancy. We didn't do Exhibit 43.
I apologize. Exhibit 46, my mistake. And in that Exhibit 46, all that you have from Dr. McCool here is a screenshot of an upcoming appointment for Monday, July 24th of 2023, right?
Correct. Because he's a doctor.
You understand that anyone can go online at AMOMI, where Dr. McCool works, and make an appointment for an OBGYN appointment with Dr. McCool, correct?
That is not true. Dr. McCool is a perinatologist. I have a referral to see him because I have epilepsy. He's a high risk specialist. You can't go and make an appointment with him. I had to send records to get an appointment with him.
Okay, but the only record that you have provided this court with regarding your alleged high-risk perinatologist is a screenshot of an appointment for Monday, July 24th of 2023, right?
No, I provided the last page was October the 11th with the diagnosis epilepsy during pregnancy from my neurologist after an appointment that day.
Ms. Owens, there is no copy of any medical record from October 11th.
Yes, there is the last page. It's October 11th. If you look at the last page, Zeman Glynis on October 11th, 10:53:20 Mountain Standard Time.
I apologize. What was it that the court indicated?
A few more minutes, so we need to probably step it up a little bit if you want to get to other things.
As we sit here today, Ms. Owens, you have refused to sign any sort of HIPAA release so that Mr. Echard could obtain directly from your medical providers evidence to support any alleged pregnancy.
No, on Friday, I literally had the doctor send it to him directly. I had my provider send it to him directly, and that's an email I sent to him telling him that it was sent directly to him. I signed a HIPAA release.
Ms. Owens, this is not the first time that you've made allegations that you're pregnant with twins within the last 2 years, correct?
That is incorrect.
Okay. So I would ask the court to take judicial notice, Your Honor, of the civil matter involving Mr. Greg Gillespie, who is present in the courtroom today. And it's CV, let me get that number for the court.
I have a protective
2021
Gillespie and against Mr. Echard, and I wish I was aware that Mr. Gillespie
052893.
No, I'm going to object to that.
We had an exhibit that we discussed last time regarding that case, and what was presented was a complaint and a motion to dismiss, and there wasn't any findings from any court on anything related to that. So I'm not going to consider that at this point.
Your Honor, I do have some questions that I think are very important for the court to hear regarding that case. I understand if the court doesn't want to take judicial notice, but I do have questions that are important that I would like to proceed with regarding the uncanny similarities.
I don't think that would be appropriate for this specific hearing. We know the scope of this particular hearing. Bringing up things in a separate case, there's separate issues. These are not the same thing. This is an injunction against harassment. I don't even know what that case is. It's not an injunction against harassment. I know that. It's not appropriate.
Your Honor, this goes to the heart of why Mr. Echard needs this injunction against harassment, and Miss Owens' pattern, her modus operandi, her pattern of behavior, her pattern of making the same claims against other men in the state of Arizona within the last 2 years. And I think it's highly relevant to this case because it supports why Mr. Echard needs this injunction against harassment because this individual has done this before and there are concerns that she will not stop.
I'm going to sustain the objection. I'm not going to allow that testimony.
And Your Honor, I would ask, again, the court to reconsider here because this matter, it's very important that the court hears how Ms. Owens has made the exact same allegations in another matter within the last 2 years. And she has committed perjury in her in the last hearing because she made she made false statements under oath regarding the nature of that case. She opens the door in her testimony when Mr. Lopez was when he was direct examining her regarding the fact that there are no other cases that are similar regarding things that happened in that case. So she did open the door based on her direct examination.
Your Honor, these are very serious allegations that the petitioner's attorney is now alleging against my client. She is insisting that my client has now committed perjury. My client has no criminal history and is not being charged with perjury. So I don't know, like, that's just an allegation. Again, these cases are completely different. We're hearing that the attorney testified that these are the same. These are not the same matters. These questions and this cross-examination of my client regarding these issues, again, would be inappropriate and is outside the scope of this hearing. In fact, it even sounds like she's trying to bring out character evidence, which would be inadmissible in a hearing like this.
I'm going to sustain the objection again. So if there's other things you want to ask about her testimony, okay. You have about 2 more minutes.
Ms. Owens, you understand and you testified under oath that Mr. Echard blocked you from communicating with him, correct?
He would block and unblock. But not from communication. It was on a text number, but we were always in email communication as recently as the day before I went to the press. He sent me an email. So,
well, Mr. Echard told you he didn't want you contacting him anymore and then would block your telephone number, correct?
But told me to email him.
Ms. Owens, these are yes or no questions. Isn't it true that Mr. Echard indicated he did not want you contacting him anymore and then would block your telephone number?
Actually, that's incorrect. From the early resolution conference that we had, Mr. Echard told me specifically to contact him via text. I had forgotten that. If you look at the transcript from that hearing, you would see that. And I haven't contacted him via text after he told me to.
Okay, can you take a look at Exhibit 55 for me, please?
I don't have an Exhibit 55.
These are our supplemental exhibits.
That were not
been the ones that are their exhibits that they would have sent you. It may not be marked by number. Is, I guess, the issue. Hers may not be marked by number.
They are, Your Honor. We sent them exhibits marked by number.
Email. I did not see his exhibits. Excuse me. Let me.
And Your Honor, I'm asking for more time because her not being prepared, knowing I presented these exhibits to her attorney yesterday, is coming into my time, and I have still several questions I'd like to ask.
I was not aware that he was getting more exhibits added after he already had testified, so I apologize. There's text messages between the parties dated 5/25/23. That's all I have. I don't have the actual exhibit.
That's the first one. And then there is another one after that. Do you see?
You have the exhibit that's from May 25th?
I don't see anything. I literally just am seeing a list of plaintiff's trial exhibits 55 through 63. Can you explain what the context is for me to understand?
Are you able to scroll down?
Your Honor, I'm concerned if she doesn't have these exhibits that we're going to need more time, because this is very important that I get through this testimony, and I provided these to counsel in advance to avoid this exact issue. And had Ms. Owens been present, this wouldn't have been an issue at all.
Right, but I have a
Your
protective
Honor.
order against Mr. Echard.
All right, just, can you find the exhibits or not?
Let me just try to see if I can scroll down. Hang on, maybe if I make my screen smaller. Oh, yes, I do. Hang on, I think I see them. I see exhibit 55. Yes, I do.
Go ahead.
Ms. Owens, do you see Exhibit 55 is a text message communication between you and Clayton dated May 25th of 2023, correct?
Correct, the day after he didn't file the,
I would move to admit these exhibits, Your Honor. This exhibit.
It's not testimony. She's asking if you recognize the exhibit. Any objection to 55?
I don't remember sending
I'll
it.
admit 55.
And here, Ms. Owens, on May 25th of 2023, Clayton says to you, I'm debating filing a police report. Please leave me alone, correct?
The context needs to be stated. He did not make
Ms.
two
Owens,
offers
I am
$1.1
asking
million
you yes
for
or
me,
no questions.
and he was found in
Your
violation.
attorney will have the time to ask you a question again, Ms. Owens. So just answer her question, and your attorney will have an opportunity to question you again.
Okay, then can you? I'm sorry. Can you repeat the question? I'm sorry. This is
Your
ridiculous.
Honor, I'm concerned that that she's doing this intentionally to eat into
All right,
my
let's
time.
just ask the questions. You're wasting more time saying all that stuff.
Ms. Owens, isn't it true that on this text message dated May 25th of 2023, Clayton responded to you and said, I'm debating filing a police report. Please leave me alone, correct?
That's what the text message says. I don't have that, but sure.
And
that's what
right below that, you sent him another text message, correct?
That's what it shows. Correct.
Okay. Can we move to Exhibit 56? It should be the next page of the document, please.
Your Honor, how are we on time? Because I know you said 3 minutes. I
We're
understand.
close on time, so I want to leave everyone time to do a closing if they choose to.
You see these emails between you and Clayton dated June 28th of 2023, correct?
Correct, but the middle email is missing from him. But correct, yes.
You're going to move for the admission of Exhibit 56, please.
But it's missing
Objection
the
to 56.
middle
Yeah, Your
email.
Honor, I'm going to object because this isn't everything in whole. You can see that there's an email missing between these two emails. There wasn't any foundation that was laid.
But this was one of many emails sent between the two of us. Clayton changed his mind many times.
I guess just referring to these exhibits. Do you recognize these exhibits? These messages?
I mean, that's what they said. I haven't gotten to read through them, but I mean, that's what it says.
Do you believe these are a representation of the exhibits, of the emails that were sent?
I know that my name when I email somebody else has a picture of me with a horse instead of the LO, so I don't know if that's relevant, whereas like Clayton's picture is shown with Clayton Echard, so I don't know if that's relevant. If I read these quickly, I can see if they are mine. I'm going to trust that they are mine, but I haven't gotten a chance to read through them.
Your Honor, she did testify that she recognized these to be emails dated June 28th of 2023, so I'm asking for their admission.
Again, the middle email is missing where Clayton tried to trap me, but
Your Honor, I'm asking if the court strike that there's no question before her right now regarding that.
I'll strike that statement. I will go ahead and admit Exhibit 56.
In Exhibit 56, Ms. Owens, on line 1, you say, I just need clarity as to what we are doing. I've offered to give you control over the outcome of the pregnancy if we date exclusively and care for each other, correct?
Correct, which was one thought on one day, and I took that away after. Yes.
And this is the exact same statement that you made to Mr. Gillespie back in July of 2021, isn't it?
I have no idea what statement I made to Mr. Gillespie, but both pregnancies have been medically proven, and I have the documentation and sent it.
But Ms. Owens,
All right.
documentation.
We
I
can't keep
released HIPAA
everyone
records.
talking over each other.
I sent the HIPAA records. I released my HIPAA records.
Ms. Owens, there's no question before you. Your Honor, I'm asking the court to strike these statements.
All right. So let's try to just answer the
in
question. If you,
I don't know what I said in 2021.
okay, so if you don't remember, just say, I don't know what I said.
I don't know.
That if I said that. Okay.
I don't
There
know.
we go.
Yeah.
All right. So, but we have room for like one more question, and we're going to be doing closing arguments.
And Your Honor, again, I would just ask that in lieu of closing argument that I be permitted to ask.
I've already done that.
Okay.
We're already at 11:56 at the moment. So,
Okay, Your Honor. And here, Ms. Owens, isn't it true that you alleged you were pregnant with twins with Mr. Gillespie in June of 2021?
No, that was an email that he doctored in 2021 that I have already testified about that in the other case. So no, I never said I was pregnant with twins.
Can you please take a look
Again,
at our exhibit?
This was an exhibit that, whatever it is, I'm guessing I know what it is. It was one message that was doctored by Mr. Gillespie that appeared a year into the court case I had with him.
all right, and we've already discussed the fact that I'm not really considering all of that. So let's move to closing.
Your Honor,
arguments
my concern here, and again, I mean this with all due respect, but Ms. Owens has a pattern of behavior here. She has previously made identical allegations in another case. The exhibits that I have today, as supplemental exhibits, all support that the statements she's made to Mr. Echard are almost identical to statements made to Mr. Gillespie in 2021. This is highly concerning behavior. She has now perjured herself on several occasions during testimony, and I am not being given the opportunity to show the court the documents to support that she is lying under oath.
I have proven my pregnancies and had my records sent to Mr. Echard.
Okay, Ms. Owens, Ms. Owens, we're not testifying right now.
I'm sorry.
Even if it was true that Ms. Owens did that in the past, which we are denying, but even if it was true, that has no relation to this specific case. Just because she may have done it before doesn't mean she's doing it now. And we have presented evidence showing that she is pregnant. We have presented evidence showing why she is.
False.
We're going to do closing arguments now. So whoever wants to do a closing argument, Ms. Arena, go ahead.
Your Honor, this is a clear case of harassment. The court has seen through all of the exhibits submitted by Mr. Echard and the additional exhibits that we presented today that the parties had an encounter in May of 2020. Mr. Echard did not have sexual intercourse with Ms. Owens. Shortly thereafter, Ms. Owens began claiming she was pregnant with Mr. Echard's child, with an alleged child. Mr. Echard repeatedly, from May to today's date, has pleaded with Ms. Owens to stop contacting him. He has blocked her number on several occasions, and she gets a new number and or uses an app to continue contacting him. It has not stopped. Mr. Echard has lost job opportunities, speaking engagements. He has suffered extreme emotional distress over these claims that are baseless and over her repeated outreach attempts after pleading with her to stop. This is the definition of harassment. The court's well aware harassment is defined per the statute as a series of acts over any period of time that is directed at a specific person and that would cause a reasonable person to be seriously alarmed, annoyed, or harassed. And the conduct, in fact, seriously alarms, annoys, or harasses the person and serves no legitimate purpose. Ms. Owens has fabricated a pregnancy now twice on 2 separate occasions. Mr. Echard is the second victim of this. She has provided no medical records to support that she is in fact pregnant. As the court saw, her Exhibit 46, Your Honor, is not medical records to support a pregnancy. It is merely, and I'd like to draw the court's attention to this, it is a picture of a test completed at Banner on June 1st of 2023 regarding HCG. It does not say it is a positive pregnancy test. The next page, Your Honor.
Oh, I'm sorry.
This is not your turn.
I'm sorry, it just does. Okay.
It's not your turn. It is very questionable, as a woman who's been pregnant before, that Ms. Owens goes to Banner to get an alleged pregnancy test on June 1st, and then she never goes back to Banner Health for any additional testing. The next page of this exhibit is simply a screenshot of an upcoming appointment with a Dr. McCool on Monday, July 24th, 2023. There are no records to support that she is an active patient with Dr. McCool, that he is her perinatologist. There's nothing. We just have a screenshot of an appointment that was made, which anyone can do online. The next record, Your Honor, this is now a HCG test from any lab test now in Scottsdale. This is not a positive pregnancy test. This is a positive HCG test. Why is she going to a new provider for a alleged pregnancy test on October 16th? These next 2 pages of records, Your Honor, it's hard to tell what they are. They look like they are screen grabs of an appointment, but it's unclear. It's just unclear. At the root of this case, and the reason that Mr. Echard is fearful, he is scared, is the fact that there has been a fabricated pregnancy. She has participated in several paternity tests, none of which have come back showing any proof or any signs of fetal DNA, Your Honor. If it wasn't for the fact that she has done this before in another case, this is unbelievable. It is very alarming. She lied under oath, and she lied under oath at the last hearing. She's not being truthful today, and my client is legitimately fearful of what else she's capable of. He's asking that this court recognize that he has done everything to handle this appropriately. He has begged and pleaded with her to stop contacting him. There is no reason for these two to have communication, despite what Ms. Owens will say regarding this alleged pregnancy. There is no proven pregnancy at this point. So we are asking that this court find that she has harassed Mr. Echard from May of 2023 up until today's date, and we're asking that the court find that the injunction against harassment needs to be ordered and maintained.
Thank you, Ms. Jonathan.
Yes, Your Honor. Now, I would agree with Clayton that Laura's communications with him were alarming, annoying, harassing, if, in fact, Laura wasn't pregnant, and if, in fact, he wasn't responding to her through the over 4-month period that she's been pregnant. She is pregnant, and he has been responding. Clayton has not met his burden in this matter. He's claimed that the amount of texts and emails has caused him to be alarmed, annoyed, harassed. Well, for starters, the reason there are so many emails and text messages is because the chosen form of communication between Laura and Clayton was through emails and text messages. And because that was how Clayton wanted them to communicate. Not in person, not over the phone, but through emails and text messages. And second, we are talking about a span, again, of over 4 months or more. There are going to be a lot of text messages during that time. There are going to be a lot of emails during that time. Third, he claimed in his petition that he has not responded to Laura and that he had blocked her. Now, that is clearly a lie. And
Your Honor, I would object. That misstates the evidence. There is clear evidence to support that the messages are showing from a blocked sender. That is not accurate.
Your Honor, some of those messages may have been blocked, but there are other communications in the exhibit, in Clinton's own exhibits, that show that he did respond to my client, whether it be in emails or text messages, and we've provided those some of those exhibits in the ones that were admitted to this court. Now, Laura testified that there was communication even aside from the exhibits that we've presented. It's impossible to put all the communication within over 4 months into a short hearing, essentially. Now, I want to talk about the content of that communication. All of the communication from my client to Clayton was meant for legitimate purposes and not to annoy him, not to harass him, not to alarm him. Almost all communication between Laura and Clayton was for the purposes of the pregnancy and paternity. The only other sort of communication from my client toward Clayton was in relation to the post that he put online when my client would receive harassing messages from Clayton's fans and his followers. So the communication around that time, call it August, September, was toward Clayton asking him to take those different things down so that my client wouldn't be harassed. Throughout this entire time, since May, Clayton has never been clear with what he's wanted to do. He's been wishy-washy the entire time. First, he didn't believe that my client was pregnant, so she sent him proof, and she sent him proof again. He wanted numerous forms of proof. You saw in our exhibit the video of Miss Owens pregnant. That was a video that Clayton asked my client to send to him. How can you ask someone to send you proof of their pregnancy and then now call it harassment? Now say that you're alarmed. Now say that you're annoyed. Now say that you're harassed. That doesn't make any sense. He was also wishy-washy about what should be done with the unborn children. And we're talking about at the beginning, around May, June. Should she have the children? Should they be aborted? Are we going to give them up for adoption? Am I going to have sole custody? Is she going to have sole custody? He was never consistent with what he wanted. I'm sure maybe he thought one thing one day and maybe he thought something else another day, and then he thought back to we didn't know what he wanted. And that was communication that was going both ways, back and forth between Clayton and Laura. Again, he hasn't been consistent, and that is what the root of this problem is. That is why there's so many communications back and forth. Had this been done in person, had they chosen to meet up physically or talk over the phone, things wouldn't get lost in translation through email, through text. But that's how Clayton chose how he wanted communication with Laura. And that's what made everything so difficult. During this time period, Laura actually had to hire another attorney to help facilitate paternity testing. That didn't work, so then Laura had to file a matter out of the family court to create a
These are
parenting
not
plan.
facts and evidence at this time. These are exhibits that Mr. Lopez did not get to present.
I think she testified that she filed a paternity lawsuit.
And they did not have, neither of them, my client nor Clayton, have had an attorney in that family matter, so they are forced to communicate with each other because they need to meet and confer. They needed to submit a resolution plan, so there's going to be text and communications back and forth from the two of them. Everything that you've heard during, whether it was our case in chief or the petitioner's case in chief, this is a snapshot of what has happened over the course of over 4 months. We were not able to present everything. All communication between my client and Clayton were for legitimate purposes. Again, not to harass them. Look at the exhibits. Look at the ones that Clayton submitted. There are clear exhibits that show that he was sending messages to her. We had submitted exhibits showing that Clayton had been communicating with her. So the fact that in the petition itself states that he had not responded to her, that's completely untrue. He had indicated in his petition that
my client had harassed him. Well, that's not what happened. Who was the one that was posting videos online and getting harassed? Clayton was posting the videos. My client was getting harassed. Not one communication. There wasn't one communication that indicated after they had been in communication since May. Since then, there was no communications that were sent to my client telling my client, stop texting me, stop emailing me, stop calling me. Not one. They presented one exhibit that shows one message that indicated that, oh, I may call the police, something like that. It seems like he might be worried. But since then, he had been communicating with my client. So again, you can't say that you are being alarmed, annoyed, harassed, but then going ahead and then emailing my client, texting my client. And again, for all of those reasons, I think that the communication between my client and Mr. Echard were for legitimate purposes, for the to determine pregnancy itself, moving into determining paternity itself, to trying to schedule paternity testing with the attorney, to the family court matter, and to today. And so for all those reasons, we're requesting that this be dismissed. Thank you.
Your Honor, in rebuttal, none of the communication from Ms. Owens to Clayton has been for a legitimate purpose. As the court has heard today, it is clear there has been no DNA test or test of any kind to support that she is allegedly pregnant with Mr. Echard's twins. There is no reason for these parties to communicate. What Mr. Lopez is proposing is that if you block someone, but they find another way to contact you, and then you tell them you still don't want to talk to them in a polite email or a polite message, then that's not harassment. That is the epitome of harassment, Your Honor. The court has received exhibits in the first hearing from Mr. Echard supporting that she would find other avenues to communicate with him after he had blocked her. Again, it is Mr. Echard's position that that this pregnancy has been fabricated. And I want to be clear on this, Your Honor. It's possible that Ms. Owens is pregnant, but it's my client's position that he did not have sexual intercourse with her, and she is not pregnant with his alleged twins. And that is the root of the issue here. There has been no support for this alleged pregnancy, other than her attempts to show the court and or Mr. Echard a picture of her alleged pregnancy, which again, we suspect may still be fabricated. So there has been no legitimate purpose to her communication other than to harass Mr. Echard to try to force a relationship on him. She told Mr. Echard on multiple occasions that she was going to force him to communicate with her, whether he wanted to or not. And he has been clear. He does not want any additional communication from her.
All right, thank you. So, as I stated when we first started this hearing, I'm not making a determination as to whether or not she's pregnant or not. That is a family court matter. That case is pending before the family court. The testing or whatever is going to happen is a result of that. So I'm not making a decision and a determination today whether or not there is a valid or invalid pregnancy. I understand Mr. Echard's position is there isn't. I understand her position is there is. That's where we are at the moment. With regards to the evidence and the communication, the court at this time does find there were a series of events that were aimed at the plaintiff that would cause a reasonable person to be alarmed, annoyed, or harassed, that he was in fact alarmed, annoyed, or harassed. I do find they did not serve a legitimate purpose. Messages that have been sent. One, he blocked her on numerous occasions. She even said in the blocking communication, can you unblock me so I can unblock you again? I got a new number and then there's another new number. I think that's clear that he does not wish to have communication. Nature of the communication, while maybe surrounds the pregnancy, the communication that I have a lot of concerns with are the ones where she's trying to make offers to him to continue a relationship, that she is trying to facilitate. If you do this, then I'll give you this. Those kinds of messages are of the nature that are harassing and can be viewed as alarming, annoying, or harassing. There are a number of messages that were admitted that are attempts at, I view kind of almost as trying to, get him to do and agree to things that are not necessarily, it's not like we said, hey, can you take a paternity test? And he said, no. Hey, can you reconsider? I want to do a paternity test. And then I went and filed a lawsuit because you wouldn't do it. I mean, that's one thing. 500 emails back and forth, or messages, I'll say text messages and emails over that period of time to try to clarify and do that is beyond what was necessary to be able to communicate those things. There were a number of threats to go to the media, which were other additional attempts to try to use the media as manipulation, or the threat to go to the media as manipulation. I find those to be alarming, annoying, or harassing. So I am going to grant the injunction at this time. The injunction is going to prevent any communication outside of the legal process, and specifically legal process and court hearings. So I am going to grant the injunction, and so I will sign the granted injunction today, and then I know Ms. Owens isn't present, but we can give a copy of the signed injunction, obviously, to Mr. Lopez today, but whether or not ultimately she needs to be served with it so that the service of the injunction is appropriate, because it will go into effect once the injunction is served upon her. It would remain in effect for a period of 1 year. This was the hearing that she had as a result of that, so there's not an additional time to request an additional hearing. And if you guys want to wait for a few minutes, I'll sign an order. If there were exhibits that you did not offer that you wish to have returned to you, you can let the clerk know and she can release those back.
Thank you.
Thank you.
Thank you.
Thank you.
I'm not sure if her screen froze or if she's just kind of stunned, sitting there looking lost. From what I've seen, she's not used to losing, so she doesn't take rejection well and is probably having a little bit of a hard time with this. Hopefully she's got a good therapist, because I don't think deep breathing exercises are going to fix this one. But I'm glad to see some common sense coming into the case. I got a little worried in the last one when a protection order was issued against Clayton for the revenge PORN, which was a picture of her pregnant belly that she put in a
At least with California, it's nice because I can just drive.
Yeah, yeah. And the weather's always good. Usually.
Especially in the summer.
Yeah. Like, can I travel for 2 months?
Exactly.
All right. Seated, please. Good morning, everyone. This is the time set in FC 2023-052-114. Appearances, please. Beginning first with Petitioner's Counsel.
Morning, Your Honor. Corey Keith appearing on behalf of Petitioner Laura Owens. Myself and client are both present, appearing in person.
Good morning to you both, and from the respondent.
Good morning, Judge. Greg Woodnick. I've got Clayton Echard with me, and my associate Isabel Ranny is behind me.
Good morning to all three of you. All right, this is the time set for status conference. As the parties both know, a motion to continue was filed. Mr. Woodnick, that was your motion, so I'll allow you to go first.
Judge, thank you. As the court is aware from the pleadings, we have zero disclosure, and I don't think zero is an understatement. I did speak with counsel in the hallway. He indicated that disclosure was forthcoming, maybe as soon as later this week. I'll believe it when I see it, but in any event, we are not prepared to go to trial next week on any of the remaining issues because we have nothing. I'm asking the court to reset the trial for 45, 60 days, whatever the court's availability is, and I'm asking the court to give us 2 hours. Petitioner invoked Rule 2. I'm stuck with it, and I intend to present a case that has foundation for evidence, and her deposition, I think, is scheduled for March 1st if she appears. As Your Honor is aware, Petitioner failed to appear at her first deposition setting without leave of court, so I've got to deal with that as well. So we're asking the court just to reset the trial in a couple of months, and hopefully beginning today, there's discovery compliance, and the issues of attorney's fees and sanctions, I think, have to abide trial. And I think that's where we are from our perspective.
Okay, and what time on March 1st, counsel?
Great question, Judge.
8 a.m.
8 a.m.
This morning.
My office.
All right, counsel?
Thank you, Your Honor. Your Honor, we're not opposing the motion to continue the trial. We're in agreement with the need for the continuance on the trial. I did want to address, we received a ruling regarding our motion for confidentiality this morning. There has been new evidence, threats to my client's life that were made to her on Facebook since the pleading practice regarding the motion practice regarding that motion for confidentiality. So I did want to have the opportunity to address that with the court, assuming that the court's position still remains the same with regards to that motion. I did indicate to Mr. Woodnick we will have discovery forthcoming by the end of the week with relation to my client's pregnancy records. Discovery has been requested far outside of the scope of what I believe is appropriate, and so I was hoping to be able to address that with the court as well today.
Okay. All right, so we'll deal with the motion to continue first, then we'll deal with re-urging on the confidentiality and the discovery.
Understood.
Any final thoughts, Mr. Woodnick?
No, I certainly have argument on all of the confidentiality issues, and I think Your Honor ruled on it, but I'll save those for later this morning.
All right. All right, the court will grant the motion to continue. The court is going to vacate the hearing. I believe we had set for the 27th. Yes, we're going to vacate the evidentiary hearing set February 27th at 4 p.m. The court will grant the request to extend the hearing time to 2 hours. I wish I could accommodate 45 to 60 days. We're setting out much further than that, which I apologize for. But Layla, what's our first available 2-hour setting?
It's going to be June 10th, Your Honor, at 8:45.
All right, everyone check your calendar and see if that works. That would be in person again.
And to confirm, that was 8:45 a.m.?
Yes.
I do that because I generally meet with counsel back in chambers for the first 15 minutes, but I don't want that to interrupt any testimony time. So that's why I said it then.
Understood. And that date and time works for me, Your Honor.
All right. Does that work for you, ma'am?
Yes.
Okay. Counsel?
Make it work, Judge.
Sarah, does that work for you?
Yes.
Okay. All right. So we'll set that then for June 10th at 8:45. Now, with regards to the re-urging of the confidentiality motion, counsel?
Your Honor, my client received Facebook messages on February 7th. Prefer not to read them out loud. I did show them to opposing counsel. I'm happy to show them to Your Honor as well.
Okay.
The conduct has just gotten increasingly more concerning from the public. There almost appears to be some sort of obsession with this case. And I think my client, rightfully so, has been nervous to participate in things like the deposition or giving up her privileged medical records because of this increasingly concerning conduct. Your Honor, can I approach and?
Sure. Mr. Woodnick, you've seen these?
Sure.
Your Honor, I know that our reply mentioned voicemails and things of that nature that my client had received. Nothing directly threatening her life at that point, but obviously after the motions and reply were filed, we started to receive these messages, and so she's just concerned that things are going to continue to progress. And Your Honor, I'll just note as well, the person who's referenced underneath the comment that was made is my client's mother. And then I think they're trying to send over her identifying information as well, some sort of insinuation that they know where she lives and things of that nature.
Thank you. Okay, counsel, I'll let you come and retrieve those. Counsel response?
Judge, a couple of things. Number one, in correspondence to Mr. Keith, I asked for some of the foundational information from that. Whoever wrote what they wrote on that, allegedly to Miss Owens, is not my client. He didn't do it. He's not involved in it. So I appreciate that that's not the suggestion here. Whoever wrote that, it's inappropriate, but certainly not a reason to enter confidentiality orders or any sort of sealing, which I assume is going to be members next in the court, that these are both public figures. And I think that the First Amendment doesn't have.
Anyone who might be Mind, please mute your phone or your tablet. Go ahead, counsel.
These are both. Yeah. My ADD does not do well with those noises. Thank you. Judge, these are public people. My client wasn't behind whatever that text was. Frankly, there's a level of incredulity regarding that. I'm not so sure that that text is actually real and it wasn't generated to create an argument to seal or for the confidentiality issue. I can tell Your Honor that we're going to treat Ms. Owens records like them. In this case, it's now 7 months along, as we are supposed to, pursuant to the rules. Just like I'm going to treat her as we're supposed to when I depose her in 2 weeks. But I certainly don't think that some random Bachelor fan maybe put a really inappropriate text to Miss Owens maybe is a warrant for the court to do anything other than remind everyone to act professionally, which has always been my intention.
Thank you. Final thoughts?
All right. I agree with Mr. Woodnick in part. This isn't his client, in my opinion, that's making these statements. However, when you couple the statements that are being made that appear to be getting progressively worse with the instances that were cited in our reply, the civil welfare checks that were sent to her home, the calls to her personal cell phone, when you couple all of these things together and look at the fact that they're getting progressively worse, and my client is now being essentially compelled to produce documents pertaining to her medical history, we don't anticipate this getting better, Your Honor, and my concern is that as this continues to get worse, we start to continue to talk about the safety of the parties involved. I understand that we're talking about public figures to an extent. My client has taken a significant step back. I don't know if, in my opinion, I would classify her as a public figure. She maybe is making statements now to try to defend herself and defend her name. But, Your Honor, my concern is that if this continues to worsen, and like I stated in my response, we don't know what state it's going to get to. We also have witnesses that are afraid to come forward to testify on my client's behalf because they're afraid of what's happening to my client and her family. And so for those reasons, we believe that it's worth at least requesting that the court reconsider the ruling on the motion for confidentiality.
Thank you. Okay, the motion to reconsider is denied. However, we will have the minute entry reflect that Arizona, it's ARS Supreme Court ruling 122 is in effect, meaning all media requests must be through the Maricopa County Superior Court. There are statutory requirements that include using audio only for witnesses, fuzzying people's face out, things like that, that could give some assurances of either anonymity or whatever else may become an issue. I agree the court has absolutely no control over what people post online. It is absolutely inappropriate to threaten people generally, so the court doesn't condone that behavior. However, I don't think at this point it rises to the level of designating anything confidential. So I'm going to affirm my prior ruling on that, recognizing that there may be evidence presented at trial that will require certain exhibits be deemed confidential because of their medical nature or addresses or other things. So the parties need to be prepared to tell me which exhibits at trial need to be designated as confidential, and I'm more than happy to do that. Now, counsel, you also said there was an issue with discovery.
Yes, Your Honor. Your Honor, my client understands the court likely in need, based on the recent ruling, for her to disclose things like her medical records pertaining to the pregnancy. It's been mentioned in the pleadings that opposing counsel has requested that she sign HIPAA releases. Opposing counsel has also sent requests for production of documents. Those HIPAA releases request 5 years of her medical records. Under the recent COMO ruling back in 2022, we don't believe that that's appropriate. We believe and are asking the court to order that while she should comply with requests for her medical records, it should be pertaining to the pregnancy, the only issue that's outstanding in this case. And on that note, Your Honor, there were two rulings on my client's previous motion to dismiss, one which granted in part and left open the issues of attorney's fees and sanctions, and one which I received yesterday, which just outright denied the motion. And so I just wanted to make sure that we were still only talking about attorney's fees and sanctions. And if that is the case, I believe that my client's medical history pertaining to whether or not she was pregnant in this matter is what would be appropriate and relevant for the court to have testimony on at the upcoming trial.
Okay, before I get to you, counsel, and then obviously you'll have final thoughts to go back to that, the court's intention was to deny the motion to dismiss at this time. So that's the ruling that stands. Mr. Woodman?
Judge, I appreciate the Como decision, and I appreciate Mr. Keith's argument. The problem is the nexus of our Rule 26 issue, which is that the entire action was filed in bad faith, is not a fishing expedition under Como. Como was designed to stop parties from fishing expeditions. That's not it. We are looking very specifically for the mental health and medical records that would explain why someone would fabricate a pregnancy, why someone would appear in court in front of Judge Gail Ketsis with a 24-week abdomen, tell Judge Gail Ketsis that they were pregnant, and then magically the babies are gone. And I think in order for us to do that, we have a right to get the relevant mental health records and the relevant medical records. And I also remind the court that that does include the fact, as we've pled here, that there's a history of the fabricating behavior. That's actually the nexus of our Rule 26 motion. For Rule 26, which, to make a clear record, is really Arizona Family Court adopting Rule 11, Civil Rule 11, not Mental Health Rule 11, but Civil Rule 11. And it addresses the propriety of filings and the propriety of signing filings. Filings that were signed by Ms. Owens directly. And she filed them, and then she filed multiple filings after that. And every single one of those filings made claims and assertions that this court has an absolute authority over. In order for us to defend or produce an argument regarding Rule 26, we need to have those records. We will treat them appropriately. They are not going to be publicly shared for any that we have any intention of doing at this point, but it's going to be part of a very public proceeding because Ms. Owens, as recently as 4 days ago or 3 days ago, published an article about these very issues. She's made it. She's the one who went to the Sun tabloid claiming not just that she was pregnant by Mr. Echard, Judge, but that she was pregnant with twins and posted a visual of the twins that she was pregnant with. We have a right to all of the discovery relevant to that for the attorney's fees issue, for the sanctions issue, and for the integrity of Title 25 and the mud that Mr. Echard's been dragged through. I'm not interested in her childhood trauma. That's not relevant here. I totally agree with that. But Rule 49 does specifically say we're entitled to 5 years of back records, and I think asking them to be produced is reasonable. I also remind the court as my final comment, they've provided nothing. When I say nothing, Judge, I mean no medical records, no financial record. I mean nothing. Even the stuff that is not even controversial, like legal fees, zero disclosure. So to come to court today and say, oh no, we want to rein in the disclosure is a little bit disingenuous. They should have been providing records along the way because that's what Rule 49 required.
Thank you. Counsel, do you recollect when the first filing was that would necessitate records back that far?
Yes, it would be 2021 February.
August 2021.
Okay. Final thoughts, counsel?
Your Honor, just to be clear, discovery has been transmitted, albeit minimally, because my client has been afraid of the backlash that would occur. My client did send Mr. Echard confirmation that she was pregnant. She sent him over the results of her blood testing. She has sent him over documents. I believe that the evidence will show that she was pregnant. I believe that that will be clear once everything is presented to the court. And I don't believe that it would be appropriate for her to have to disclose records dating back to January 1st of 2018, as the respondent is requesting, addressing her anger management, substance abuse, domestic violence, and additional things. This is a fishing expedition. This is what's covered under Como. The difference is we don't even have this situation under Como, Your Honor. We have a situation where there is no child. There are no best interests of a child to be considered. We have a situation where the respondent is on a fishing expedition. He's trying to pull things in and twist stories of previous incidents against my client to make it seem like she's fabricating these allegations. When the reality is, and like I said, I believe the evidence will show this, my client was pregnant. She did have a miscarriage. She's no longer pregnant. And I believe that the evidence will show that. And so for those reasons, we're asking the court not to allow this fishing expedition. They're requesting documents dating back to January of 2018. This is absolutely should be covered under COMA, and I believe that the court should actually look at this even further because, like I said, there are no best interests here to evaluate to overrule my client's medical patient privilege. I understand that my client has an obligation to prove her pregnancy, and I think that it's in her best interest to do so as well. But to allow the respondent to go back 5 years into her domestic violence history, her substance abuse history, and obviously assuming that there even is any, is just absolutely inappropriate. And this is a fishing expedition. Thank you.
You said your client did provide limited disclosure. Did that include evidence of the miscarriage?
No, Your Honor. The miscarriage came further throughout this case, and the records that outline the miscarriage and her going to the doctor after the miscarriage have not yet been sent.
And when are well,
Your Honor, all of my client's medical records pertaining to the pregnancy will be sent to the respondent by the end of the week. I do have them. We were just waiting on a ruling on the motion for confidentiality because we have concerns that by next week they'll be released to the public.
how would they be released to the public, counsel, if they're just exchanged between counsel?
Well, Your Honor, I believe that they would also be sent to the respondent, and I can tell the court that even my own emails to opposing counsel have been, in this case, released to the public. I'm not insinuating that that is Mr. Woodnick. I understand he has an obligation to share the documents with his client, but the reality here is documents that are being transmitted, pleadings that are being filed, emails that are being sent between the parties are being released to the public in a manner of hours, not even days, certainly prior to someone's ability to pull pleadings online. Also of note, those pleadings that are being released to the public are being released in color. I believe it's common knowledge that when you go down to the courthouse and request documents, those documents come back in black and white. So it's clear to me that there's some sort of a leak to the public. It's why we filed our motion for confidentiality, and I don't believe it's appropriate for my client's records dating back to 2018 to be dragged through the public.
All right. When did the miscarriage occur, counsel?
Your Honor, I'm not sure that an exact date is known.
What month?
Your Honor, I believe my client went to the doctor in mid-November, and that's when it was determined that she had had a miscarriage. We would believe that it was in the maybe month or 2 months leading up to that time.
So previous counsel should have disclosed that, correct?
Well, Your Honor, I believe that the increasingly concerning nature of this case and the request for confidentiality and the request for the dismissal, I believe that given the fact that everything my client sends to respondent is being shared with the media, I believe that warrants at least some degree of the court finding her actions to be reasonable. She is actually receiving threats to her life, voicemails on her phone. I mean, this is concerning conduct from the public. And so we were just waiting on, same thing with the deposition. I told Mr. Woodnick we would appear for a deposition if the court ordered us to. We just wanted to have the motion to quash and the motion for confidentiality ruled on prior to doing so because we wanted to have the court's input into if those things were necessary.
But counsel, my follow-up question to you then would be, if she had disclosed it in November, wouldn't this case have simply gone away and these issues wouldn't remain?
Well, no, Your Honor, because she did disclose the fact that she had a miscarriage. It's well documented in our pleadings. I understand that the medical record either, but my client does have a patient. She has privileges that in this case are not only being not considered or not fully considered, but it's being taken even further, and her documents are being, I have no doubt that the second we send over that disclosure statement by the end of the week, all of her records will be on Reddit. And so, Your Honor, I don't believe that. I understand where the court is coming from, and I think that had there been some sort of an agreement, we've offered for the documents to be shared between counsel. I've offered for him to come to my office and see the documents, and we've had some discussion about that. Obviously, the recent pleadings, I think, may change that from the court, but it's not us trying to hide the ball. It's us trying to make sure that my client's medical records aren't shared with the entire world.
All right, we'll have the minute at 3 reflect that no party is to disclose outside of themselves any medical or other documentation disclosed between the parties. That goes both ways. I don't want anyone releasing any exhibits, medical records, or anything else regarding the other person. And that goes both ways and truthfully should go without saying, but I recognize it does not in this case. I am going to order that the records be disclosed dating back to August of 2020. That's 1 year prior to the first filing. I think that that's appropriate. Mr. Woodnick, do you have a release with you today that she can sign?
I've sent that.
This outlines that it would date back to 2018, so I believe we need to
redline it. That's fine.
If you'd like to adjust that, and then we can sign that and have that done today. You can do that now.
Judge, on the discovery issue, if I may.
Sure.
I appreciate Your Honor's ruling. Obviously, I'm assuming if there is something that comes out in those records that requires us to seek leave of the court to expand that, we can readdress that with the court. If something is in those records that imagine getting part of a medical record because of the date issue, we'd be able to come back to the court and address that if necessary.
Both parties always have that right.
Secondarily, appreciate that Your Honor's not living this case every day, but the testimony, not the testimony, the statement of counsel was just that mother says she had a miscarriage 2 months before November. In November, the parties appeared in front of Judge Gail Ketsis, where mother had a pregnant belly and told Judge Gail Ketsis she was 100% pregnant by my client. Your Honor's not adjudicating that today, but I'm asking Your Honor to take back the protective order proceeding that was granted in my client's favor for purposes of not consolidation, to be heard concurrently for the purposes of attorney's fees and sanctions on that matter. Because if what counsel just said is that she was not pregnant at that time and she lied to Judge Gail Ketsis in that proceeding, then I think that's sanctionable and Your Honor could enter orders under that proceeding. So I'm asking Your Honor to take, not jurisdiction, but to hear that matter concurrently or to have that file available for our upcoming evidentiary hearing.
Response?
Your Honor, I would ask the court to deny that request. Spoken to experts in this case preemptively about this trial. The reality is sometimes people have miscarriages and they don't even know that they miscarried. I'm not saying that that is the circumstance here. I certainly wasn't present. Saying that my client has not lied in this case. She has not intentionally lied to the court. Whether or not she was pregnant on that date, I think she could have testified that she was pregnant and she could have had a miscarriage days prior. I don't know, but I believe that the testimony in her deposition, the testimony in her final trial, and the expert testimony that will come with it will make those things clear. I believe it'd be absolutely inappropriate to throw out previous proceedings in this case. Based on my statement, not even my client's statement, there would need to be an evidentiary hearing in order for that to be proper.
But I think that's what he's asking. He's asking that the evidentiary hearing be wrapped into this.
And Your Honor, that's not appropriate. The evidentiary hearing has already been done. And like I said, my client's statements that were made during that hearing were true to the best of her knowledge. The reality here is sometimes women believe that they're still pregnant when they've had a miscarriage, and they don't know until they go to the doctor that their levels are no longer appropriate for a pregnant woman. I do believe that that is what occurred in this case. Timing-wise, I don't know if any of us will ever be able to tell exactly when that miscarriage took place. But I do know that my client, from our conversations, did testify truthfully, and there were not misstatements that were made there. We're certainly not intending to change her testimony. But like I said, we have spoken to experts that have identified that sort of occurrence does sometimes happen.
Follow-up question to his comments. Counsel, are you asking that I revisit the order against harassment or just for purposes of fees and costs?
Just for purposes of fees and costs, because the order was appropriate that Judge Gail Ketsis entered. However, she did not order fees and costs. I would contend that if she knew what we think the evidence will show, which was that Ms. Owens just lied and said she was 24 weeks pregnant with twins, and then apparently had a miscarriage apparently 2 months earlier, that had she, if any of that is true, that had she known that that was her testimony at the time, she would have ordered attorney's fees in Mr. Echard's favor, and I'd like that to be on the table at the evidentiary hearing.
Okay, so then if I'm hearing you correctly, what you're saying is the separate cause number is, you think, what delineates and prevents the court from awarding fees and costs at our evidentiary hearing in its totality.
I'm not even sure if I'm right about that. I know that the court changed the rules and required us to use different cause numbers. Otherwise, it's the same parties, and it could be the same cause number. But our rules require us to have two separate cause numbers for the protective order proceeding, which has already been granted, in this tail end of a paternity matter. I'm just asking that Your Honor treat them as one for purposes of any attorney's fees and sanctions you may choose to order at the upcoming hearing.
All right. Final thoughts on that?
Your Honor, this is a res judicata issue. The issue of attorney's fees pertaining to protective orders and injunctions against harassment have already been litigated. They've already been decided. In my opinion, to the extent, well, one, I do believe that it would inhibit, I believe it's a separate case that would inhibit this court's ability to order fees unless it were to be merged, which I don't believe is appropriate with it already being over. If there were more evidence after our trial that would warrant Mr. Woodnick believing that his client would have been entitled to fees, I believe that he would need to take recourse with that judge in that case number and seek appropriate remedies. I don't believe it's appropriate for the court to reissue something that's already been litigated in anticipation of Mr. Woodnick's assertion that there may be additional evidence that would prove his client's claim. There certainly isn't at this point. There haven't been those things proven at this point. So I'd ask the court to deny the request.
Did either party have an attorney at that hearing?
Yeah. Yes, Your Honor, I believe both.
Okay. All right. So then what the court is going to do is the court is going to hear evidence and testimony as it applies to sanctions and attorney's fees and costs dating back to the filing of the petition, all pleadings filed within the Maricopa County Superior Court. So everyone's on notice to be prepared to present testimony and evidence on that. Whether I ultimately award anything as it applies to that case, I can't tell you right now because I haven't heard any evidence or testimony. But I'm not going to preclude myself from that option at this point. So we'll have the minute entry reflected so that it's clear.
Your Honor, if there was, and I wasn't present during those proceedings, but if there was an order denying the request for attorney's fees at that time, is this court setting that order aside?
No, I definitely wouldn't be, but are both parties, I recognize that the court can take full judicial notice of the entire docket of the Maricopa County Superior Court, so I don't need your permission to go look at that case, but I do think I need your permission to go watch the hearing. Do either of you object to me going and watching the hearing?
Absolutely not.
No, Your Honor.
Okay, so we'll have the minute entry reflect that between now and June 10th at 8:45, the court will review the order of harassment hearing. Do we know what date that occurred on?
The hearing dates, it was split in two. There was October 24th, 2023 and November 2nd, 2023.
Thank you. November 2nd, 2023. All right, so the court will review that between now and then, and that'll give me a little bit better idea of what authority, if any, I have. That just wasn't something I was willing to look at until I had the party's permission.
Thank you, Your Honor.
Okay. All right, and then with regards to Mr. Woodnick's request for the DNA testing and the vital records, is that disclosure you intend to present today or by the end of the week, as you talked about earlier?
DNA testing and the vital records, what exactly are you referring to, Your Honor?
If you look at page 14, I believe it was of his response to your motion, it requests the court issue an order compelling Ravegan Inc. to produce all records and documents related to fetal DNA testing in this matter, and subsection D was issue an order compelling Vital Records to produce all records and documents related to fetal death certificates under, and then the appropriate ARS for alleged twin fetuses born to petitioner.
Well, Your Honor, there isn't, to my knowledge, there isn't a Vital Records record or request that would be able to be produced because there wasn't one. Regarding the DNA testing results, that will be included, what my client has will be included in our disclosure.
Okay, and when is that forthcoming, today or?
It'd be by the end of the week, Your Honor. I just have to prepare. And just for the record, I believe that Mr. Echard did participate in those with the DNA testing, so I'm not sure why he wouldn't have received those records independently as well.
And obviously, I don't know either, but I did read in your motions that one of the results was lost in the mail, so I don't know how else that was conveyed to anyone. Whether it was conveyed or not, I don't know. So recognizing that it may be moot. Yes, Mr. Woodnick?
If you can help us. Smarter than the associate whispered in my ear that Jen requested you to release the information. So if Your Honor would be inclined to, since Mother's obviously now cooperating, if Your Honor would be inclined to endorse or include language in there, I'm happy to shepherd it over to RabGen, directing them to produce all records related to any DNA tests taken by or with Mr. Echard and or Ms. Owens in the past 10 months, whatever it's been. That would be our request.
And Your Honor, for the record, I don't have an objection to that. I believe it would be an appropriate disclosure.
Okay, well, go ahead.
The other thing in our request was we had wanted Mother to sign the requisite fetal death certificate, the verification, so we could get those records. I realized Mr. Keith can't testify, but is the position of mother, there will be no fetal death records because none were ever submitted. If that's the case, I'll let the issue go. I'll address it at trial. But him testifying doesn't really cut it on that issue. If not, we need confirmation from the state of Arizona that there are no fetal death certificates.
And Your Honor, that is correct. And on that note, and I haven't addressed this with Mr. Woodnick, but I think it might be appropriate for us to amend our initial petition just for clarity at this point and to make sure that all parties are on the same page with what's being pled. So I would ask the court for leave to amend our position just so that we could make these points clear in anticipation, although I do believe the discovery and her deposition will probably do that to an extent. I believe it's appropriate for us to make that clear in the pleadings as well.
And what are those intended amendments, counsel?
Your Honor, the amendments would be just outlining the new circumstances. Obviously, her petition was filed predating any sort of miscarriage or likely even a lot of the care surrounding the pregnancy. So it would be to make those things more clear. And also, Your Honor, I don't believe there were attorneys at the beginning of the case, so it would be to make sure that we're explicitly requesting attorney's fees as well.
Okay. Don't you think your motion to dismiss addressed that?
Your Honor, I think the motion to dismiss did address that in part, and it did request attorney's fees for the motion to dismiss. But if we're going to request it for the entire case, I believe amending the petition would be appropriate. I also know, I believe the respondent was just allowed to amend his petition a month or two prior. So I don't believe that it would prejudice anyone with us scheduling the trial out so far. I'd have no objection getting it done in a week. And if the court wants to consider our motion to dismiss a request for attorney's fees for the entirety of the case, I would be fine stipulating to that and saving the motion practice as well. And maybe Mr. Woodnick is stipulating to that.
She wants to make, if Your Honor wants to consider her claim for attorney's fees at trial, I have no issue with that. I have an issue with amending a paternity petition, which was perjured, because I don't want to be precluded from addressing the perjurous statements in the paternity petition. If they want to amend it, that's fine, but I'm not ignoring, and nor do I think I have to ignore what was signed and filed with this court originally and then repeatedly prior to us coming here today. And so I don't want to lose that opportunity because mother all of a sudden realizes that stuff that she put in that petition was not truthful.
Okay. What we'll do is we'll treat the motion to dismiss as a request for attorney's fees and a motion to dismiss. Of course, I'm not minimizing that, but we will note in the minute entry, Lamar, that both sides are seeking attorney's fees and costs. And then the leave to amend based on the argument you've presented today is denied. In the event you need leave to amend for some other reason that doesn't change the alleged facts that were presented back in August, then of course I'm not precluding you from filing a separate motion to amend. I'm just denying your request as it's given to me today.
Understood, Your Honor, if I may. I just want to be clear. My intentions are not to change any of the facts that were originally pled, just to expand on the facts that were originally pled. I just want to make sure I'm clear on that for the record.
I understand. All right. Now, with regards to disclosure, since we're set out now in June and we've got the deposition March 1st, when's an appropriate disclosure deadline? I don't know how much. It sounds like everything maybe still needs to be done, but truthfully, this is not a complex case. It shouldn't take very long.
You're going to have the HIPAA responses, so I guess I'll leave this one to.
So don't know what we're getting, but if we get HIPAA responses, I guess the burden is now on us to take those HIPAA responses and go to the listed doctors that she said. I'm concerned that that's going to take some time. If she's having the HIPAA release today.
Yeah.
Do you have an inventory of what you can disclose now?
Okay. Okay, that's fine. So obviously March 1st is a pivotal day. Why don't we we'll set the disclosure deadline 30 days, Lamar, 30 days before trial. And that is, from any disclosure beyond that deadline will be precluded. However, the parties are to complete initial disclosure no later than 45 days from today's date. So that gives you guys about 30 days after the depo. And then assuming that there may be additional depots that need to be done. Are there any questions about that schedule?
Oh, yeah.
Just my last comment, and appreciate of your time. Just so the court's aware, I have every intention of taking this HIPAA release, because I sent a bunch of them originally, because there's a bunch of doctors that you claim. I'm just going to reproduce it and repopulate it. Is that okay, Corey? Yeah.
Okay. All right, we'll have the minute entry reflect that Mr. Woodnick has been provided with a amended signed HIPAA release, and counsel agree that he may amend the provider.
And the date as well, Your Honor, because it requested
Yeah,
2018. And I'm worried that they won't accept it with me crossing off the date too.
Do you want me to sign it too? It might help.
I don't know how you want to do this, Judge.
Okay.
I'll
Right.
defer to you, Your Honor.
So that's fine. We'll just endorse. Who are we endorsing, Mr. Woodnick?
There's, at the protective order hearing, Mother listed 4 physicians that she claimed she was treating her current pregnancy for.
Okay, and I don't want to disclose those today in the hearing because I'm not sure who I have here virtually, but can the parties send a joint email to the court with the names of those doctors? And so that I have a record of it, we will not put it in the minute entry because that is public. We'll just have the minute entry reflect, Lamar, that the court will be provided with 4 additional providers.
I think it's 4. Don't hold me to that.
And Your Honor, I think it'll be more. Just to be clear, I believe it may have been 4 then, but we'll figure out the list.
All right, we'll just have the minute entry cross out 4 and put more than 1. All right. So we've discussed disclosure, we've discussed the deposition, we've discussed all the pending motions. Mr. Woodnick, since this was your motion, is there anything you feel that the court has failed to address?
I think today was very productive. Thank you, Judge.
Thank you, Mr. Keith. Anything the court's failed to address?
I agree, Your Honor. Thank you for the court's time.
You're welcome. All right, everyone, we will stand in recess until June.
All rise.
Oh.